ಬರ್ಬೇಕು ಸಾಹೇಬ್ರು ಬನ್ನಿ ರೆಡಿಯಾಗಿ ಪೇಜ್ ಕರಿತೀನಿ ಸರ್ ಹೇಳಿ ಬನ್ನೇಲಿ ಕೊಡಿ ಸರ್ ಅಲ್ವಾ
ನಮ್ಗೆ ಹೇಳೋದೇನ ನೀವು ಮತ್ಬಿಡ್ರಿ ಅಂತ ಬರ್ತಿದಾರಲ್ಲ
ಬರೀತಾರೆ ನೀವ್ ಯಾವ್ದ್ರಲ್ಲಿ ಇರ್ತೀರೋ ಅದಕ್ಕೆ ಬರೀತಾರೆ.
ಮೂರು ನಾನೇ ಇದ್ದಿದ್ದಲ್ಲ ಈಗ
ಹಾ
ಎಲ್ಲದಕ್ಕೂ ನಾನೇ ಇದ್ದಿದ್ದು ಮೂರಕ್ಕೂ.
ನಿನ್ನೆ ಯಾವ್ದೇ ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಇದೆಯೋ ಅದಕ್ಕೆ ಹೇಳಿದೆ.
ಥ್ಯಾಂಕ್ ಯು.
ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಕೊಡಿ, ಮೆಮೊ ಕೊಡಿ. ಇದನ್ನ ನಾಳೆ ಪೋಸ್ಟ್ ಮಾಡ್ಸೋಣ.
There is urgency. Your
ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ objections ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ.
objection complaint ಆಗಿದೆ. That is listed today. That is listed for admission.
ಒಂದ್ರದಾಯ್ತು ಮೇಡಮ್, ಇನ್ನೊಂದು ಕನೆಕ್ಟೆಡ್ ಅಂತ.
ಅಲ್ಲ connected ಅಂತ.
ಕನೆಕ್ಟೆಡ್ ಅಲ್ವಾ?
Connected ಎರಡು IA ಹಾಕಿದ್ರು ಇದ್ರಲ್ಲಿ. Appellant had the benefit of injunction in respect of shelter. And in fact
ಆಯ್ತು, ಏನ್ ಹಾಕ್ಬೇಕು ಹೇಳಿ ಮೆಮೊದ್ದು.
ಮೆಮೊ ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ನಾಳೆಗೆ ಲಿಸ್ಟ್ ಮಾಡ್ಲಿಕ್ಕೆ.
ನಾಳೆಗೆ ಲಿಸ್ಟ್ ಮಾಡ್ಸೋಣ, ಕೊಡಿ ಅದೇ. ಅದನ್ನೇ ಹೇಳಿದ್ ನಾನು.
Grateful.
Mentioning from page number 14,
ಕೊಡಿ ಅವ್ರಿಗೆ ಕೊಡಿ ಮೆಮೊ ಕೊಡಿ.
36, 30, 36, admission matter ಇಂದ.
36. Short
Huh?
accommodation, short accommodation.
ಏಕೆ ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟರ್ ಅಲ್ವಾ? ಡೇಟ್ ಅಂತ ಇದೆ ನೋಡಿ, ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟರ್. No. Order 9, Rule 9 dismissed with cost of rupees 2000. You assist the court, that's all. No date. Other side ಇದಾರಾ?
ಇದಾರೆ sir.
ನೀವು ರೆಡಿ ಇಲ್ವಾ?
Judgment ಕೇಳಿದ್ರು.
ನೀವು ರೆಡಿ ಇದ್ದೀರಾ ಇಲ್ಲ ಅಷ್ಟೇ ಹೇಳಿ. ನಾನು ಕೇಳಿದ್ ನೀವು ರೆಡಿ ಇದ್ದೀರಾ ಇಲ್ಲ ಅಂತ. ರೆಡಿ ಇದ್ದೀರಲ್ಲ, ನಾನು ಓದ್ಕೊ ಬಂದಿದ್ದೀನಿ, ಅಸಿಸ್ಟ್ ಮಾಡಿ ಕೋರ್ಟ್ಗೆ.
36, 37 to 42. Okay. 43 to 46.
CL number 43, my
Serial
lord.
number
43.
43, my lord. For appellant.
ಸಿಮ್ಮನ್
Yes,
ಹೇಳ್ರಿ.
my lord. My lord, praying for short accommodation, my lord. Today and tomorrow senior is not available.
ಹಾ.
Some inconvenience, my lord.
Apparent counsel seeks time, list this matter on 12/11.
Obliged.
Serial number 45, my lordship. I am appearing for appellant.
ಹೇಳಿ.
Kindly place short accommodation, my lord.
ಅದರ್ ಸೈಡ್ ಅಪಿಯರ್ ಆಗಿದಾರಾ ಇಲ್ಲ?
Inform ಮಾಡಿದೀವಿ ಸ್ವಾಮಿ. Inform ಮಾಡಿದೀನಿ. Next hearing.
ಮಾಡಿದಿರಿ, ನಾವು ಓದ್ಕೊ ಬಂದಿದೀವಲ್ಲ, ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ?
Please, my lordship.
ನೀವಿಬ್ರು ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ಕೊಂಡ್ರೆ ಆಗೋದಿಲ್ಲ ಅದು. ಯಾರ ಇದಾರಲ್ಲ ಮಂಜುನಾಥ್ KV for R5 to 8 ಅಂತ.
Senior counsel not feeling well, my lordship.
ತಗೊಳ್ಳಿ, ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ submits that senior counsel is not feeling well and also intimated counsel for respondent. List this matter on 12/11.
Very grateful, my lordship.
47 to 53. 54 and 55.
Your lordship, 55, your lordship.
55
Appearing
yes.
for R1, your lordship.
Ah.
Senior is not keeping well, very serious, your lordship. Therefore, praise time, your lordship.
Started matter, madam.
Your lordship is not
Third
keeping
matter.
well. He's really not keeping well, your lordship.
ನೋಡಿ, ಇಂಟಿಮೇಟ್ ಮಾಡಿದ್ರ ವಿನೋದ್ ರೆಡ್ಡಿ ಅವ್ರಿಗೆ
Illa Swami.
ಮಾಡಿ, ಇಂಟಿಮೇಟ್ ಮಾಡಿ. ಅವ್ರು ವೇಟ್ ಮಾಡೋದ್ ಬೇಡ, ನೀವು ಡೇಟ್ ತಗೊಂಡು ಹೋಗೋದು, ಅವ್ರ ಸಂಜೆವರೆಗೆ ಕಾಯೋ
Martin,
ಅವಶ್ಯಕತೆ.
Swami.
ಫಸ್ಟ್ ಯು ಇನ್ಫಾರ್ಮ್, ಇಂಟಿಮೇಟ್,
Much.
then I will consider your request.
To 58. 59 to 64.
62.
ಹೇಳಿ.
Could it be taken up on Monday, my lords?
ಏಕೆ
ಮಧ್ಯಾಹ್ನ ಸ್ವಲ್ಪ ಪರ್ಸನಲ್ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್
ಅದರ್ ಸೈಡ್ ಹೇಳಿದಿರಾ?
ಹೇಳಿದೀನಿ ರಾಹುಲ್ my lords, I intimated him.
2007 ಮ್ಯಾಟರ್
7 ಮಾಡು.
ಇನ್ನೇನ್ ಟೈಮ್ ಕೇಳ್ತೀರಿ ನೀವು?
ಇಲ್ಲ ಮಂಡೇಗೆ ಹಾಕೊಳ್ಳಿ my lords, I not seek any agenda.
Apparent counsel seeks time and also submits that he has already intimated counsel for R1A. ಒಬ್ರೇ ಇರೋದು R1A
ಅವ್ರು
and list this matter first week or second week ಅಲ್ಲ ಕೊಡಿ.
611.
6/11.
much
65 to 65 and 66. 67. 230.
ಇನ್ನೆಲ್ಲ ಮಧ್ಯಾಹ್ನದ 2:30.
Non-compliance for fourth time. Serial number 1. Prakash Angdi BV.
In this case, my lord, the objections is that, my lord, the second set is second set of.
Whatever it may be, matter is listed for fourth time for non-compliance.
My
How
lord,
many times
it
matter
is
has
not
to be
required,
listed
my lord,
before
the
the
second
court?
set is not required to be
compliance.
filed, my lord. And one more the IA is that is to be not present. It comes before dishonorable court only, single
Sorry,
bench.
matter is listed for fourth time for non-compliance and in spite of it not complied the same. And hence granted 2 weeks time on cost of rupees 1,000.
No, my lord, now only I am complaining, my lord, there is no nothing to be complained, my lord, only the IA has to be not pressed, my lord.
And list the matter after compliance.
My lord, I may be permitted to complain during
No,
the course of
counsel,
the day, my lord.
Not giving any permission before this court for compliance. Last 4 time list ಆಗಿದೆ.
ಅಲ್ಲ ಅದು ಏನಿಲ್ಲ ಅದ್ರಲ್ಲ ಐಎ
ಏನಿಲ್ಲ ಅಲ್ಲ, ಅದು ಇರೋದ್ನೇ ಮಾಡಿ.
ಡಿವಿಷನ್ ಬೆಂಚ್ ಮುಂದೆ
No, counsel,
ಎರಡು ಆಗ್ತಿದೆ.
I have passed an order, you complied, that's all.
Orders matter. Serial number 2.
Dismissal of appeal for non-compliance of office objection as per order dated 14/6.
T. Sheshgiri Rao.
The appellant counsel is absent and not paid the cost as ordered by this court and also not complied with office objection, and this court-wide order dated 14/6/24 made it clear that if office objections are not complied and cost not paid, list the matter for dismissal, and in spite of it not paid the cost and complied, and hence appeal is dismissed in terms of the order dated 14/6/24.
Sohani Escola.
We have paid the
Dismissal
fine.
for
We have paid
appeal
the
for
fine, your lordship.
non-compliance of office objection as per order dated 10/4/24.
Yes, we have paid the fine, your lordship, and we have complied with the major objections.
Major, minor ಅಂತ ಇಲ್ಲ, ಕಂಪ್ಲೈ ಮಾಡಿದ್ರೆ ಇಲ್ಲ ಅಷ್ಟೇನೆ. Matter is listed for non-compliance of office objection for fifth time.
Because valuation slip, we
Counsel
could
for
not get the
appellant seeks
valuation
further
slip.
time. Since sufficient time is already granted, further time can be granted only on cost. Hence, 2 weeks time is granted to comply with office objection subject to payment of cost of rupees 2,000 to Advocates Welfare Fund, Bangalore. In case of failure to pay cost and comply with office objection, within that time, matter to be listed for orders regarding dismissal for non-compliance. Held.
We have already paid the cost in this. 2,000 rupees has been paid.
The council
We were-
submits that cost of rupees 2,000 is paid.
Yes, we were awaiting the valuation slip, your lordship, since we were not made as parties before the trial. court. It was,
If it is only valuation, then I will keep alive the file. Or otherwise dismiss it right now. 5 ಸಾರಿ ಲಿಸ್ಟ್ ಆದ್ರೂ ಕಂಪ್ಲೈ ಮಾಡಿಲ್ಲ. ಇದು 6ನೇ ಸರಿ ಕೋರ್ಟ್ ಮುಂದೆ ಕಂಪ್ಲೈನ್ಸ್ಗೆ. ಅದು 22 ಮ್ಯಾಟರ್. ಮೇಲೆ ಇನ್ನು 5 ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೈ ಮಾಡಿಲ್ಲ ಕೊಡಿ. The council submits that valuation slip is awaited and hence could not comply. But on verification, even still there are 5 office objections.
I will do it during the course of the day, your lordship.
And the same has not been complied, and my appeal was filed in 2022, and even in spite of 6 time matter is listed for compliance, not complied with the same, and hence in view of the earlier order dated 19/7/24, the appeal is dismissed for non-compliance.
Number 4.
R. Shashidhara,
Respondent number
compliance
2,
of
my lord,
office
is
objection raised on process memo, furnishing correct appeal copy to issue notice to R2.
R2 is the my lord's DC, Deputy Commissioner. Government advocate may be directed to take notice, my lords. Respondent number 1 and 3 is already represented by an advocate. I will serve the copy on.
Deputy Commissioner.
Yes, ma'am. Arbitrator come Deputy
The
Commissioner.
counsel for the appellant would submit that R2 is the deputy commissioner and hence AGA is directed to take notice for R2. The appellant counsel is directed
Please.
to furnish the copy of the appeal memo forthwith. ಏನ್ ಹೇಳಿ? Arbitrator ಅಂತೇನ ಇದೆಯಲ್ರಿ?
Arbitrator come Deputy Commissioner, National Highway Authority means case for the arbitrator, Deputy Commissioner is the arbitrator, my lords.
ನೀವು ಅವ್ರಿಗೆ ಅಪೇರ್ ಆಗ್ತೀರೇನ್ರಿ ಆರ್ಬಿಟ್ರೇಷನ್ ರೋಲ್ DC ಮಾಡಿದಾಗ?
ಇಲ್ಲ ಸರ್.
ಹಾ?
ಅಲ್ಲಿ ಚೆಕ್ ಮಾಡ್ತೇನೆ.
ತಗೊಳ್ಳಿ. Directed to take notice and serve the copy on the AGA forthwith.
The serial number 4, my lord, 26, 27, 37, 38 are the similar matters, my lord. Earlier it was 6, 27, 37, 38 are similar matters.
ಅವಾಗ ಏನಕ್ಕಿದೆ ನೋಡೋಣ ಅದ್ ಬಂದಾಗ ಹೇಳಿ.
Please.
ಆಮೇಲೆ ನೋಡೋಣ. Discuss
Number
matter up to 2 weeks.
2 weeks, matter is, my lord, covered by the judgment, my lord. Any
Huh?
short date, next week it may be.
ಇಲ್ಲ ರೀ 22ರಿಂದ ನಿಮ್ಗೆ ಅರ್ಜೆಂಟ್ ಇರ್ಲಿಲ್ಲ. ಈಗ 2 ವಾರ
Last time our time turned, respondents time turned.
First you serve a copy on him. Let him also go through the papers. 2 ವರ್ಷ ಅರ್ಜೆಂಟ್ ಇಲ್ಲ, ಈಗ ಅರ್ಜೆಂಟ್.
Serial number 5.
I have duly complied, my lords. I have paid the cost. I have
Office
paid the court fee
objections.
also, but the office has
Order
raised
dated
objection
14/6/24.
because
ಕೊಡ್ರಿ.
so far as the valuation is concerned, I had said 180 rupees per square foot on the date of acquisition. Because at the time of reference, no court fee had been paid, as your lordship is aware.
Matter is listed for non-compliance of office objection.
I
for
have complied.
6th time.
Our America lidru, court fee kattirilla, katru Swami. They were taking treatment in America. I have complied. I have duly complied. I don't know why office is raising objection that.
ಕಾಸ್ಟ್ ಕಟ್ಟಿದ್ರ 1,000?
Kottidhi, Swami.
ಯಾವಾಗ ಕಟ್ಟಿದ್ರಿ?
I have paid on 22/6.
If cost not paid and office objections are not.
I'll copy this one. I have complied.
Huh?
Ella compliant.
Value of the appeal on ಬರಿಬೇಕು. ಕೋರ್ಟ್ ಫೀಸ್
ಎರಡು ಕಟ್ಟಿದ್ದೀನಿ.
ಕೋರ್ಟ್ ಫೀ ಕಟ್ಟಿದ್ದೀರಾ?
ಎಲ್ಲ ಕಟ್ಟಿದ್ದೀನಿ.
ಯಾವಾಗ?
8/7.
The council submit that he has paid the court fee on 8/7.
8/7/2024 and cost of 1,000 has been paid on 7 on.
ಅಷ್ಟ ಆಯ್ತು. ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಪ್ಯಾರಾ ಬರಿಬೇಕಂತಲ್ಲ ಮತ್ತೆ.
ಅದು ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ, ಅದು ಮಾಡಿದ್ದೀನಿ.
ಏನ್ ಅಮೌಂಟ್ 60 lakhs ಇದೆಯೇನ್ರಿ ವ್ಯಾಲ್ಯೂಯೇಷನ್?
ಹೌದು ಸ್ವಾಮಿ.
ನಮ್ಮ ಮುಂದೆ ಹೆಂಗ್ ಬರುತ್ತೆ?
ಅದೇನಾಗಿದೆ 60,97,380 is the total amount. ಅದ್ರ ಮೇಲೆ I have paid the court fee.
ಟೋಟಲ್ ವ್ಯಾಲ್ಯೂ ಆಫ್ ದಿ ಸಬ್ಜೆಕ್ಟ್ ಅಲ್ಲ ರೀ, ನಮ್ಮ ಮುಂದೆ ಹೇಗ್ ಬರುತ್ತೆ? ಡಿವಿಷನ್ ಬೆಂಚ್ ಮುಂದೆ ಹೋಗಬೇಕಲ್ಲ?
Division bench. ಆದ್ರೆ I have complied, my lord. I have complied. I have duly
ಎಲ್ಲಿ
complied.
ಮಾಡಿದ್ರಿ ವ್ಯಾಲ್ಯೂಯೇಷನ್? ಎಲ್ಲಿ ಬರ್ದಿದ್ದೀರಿ ನೀವು?
Page 63.
ಯಾವ್ದು ಮೇಡಮ್ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಪ್ಯಾರಾ?
Page 63, para 43.
63, 43 ಇದೆ.
ಹಾ.
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಏನ್ ನೋಡಿ. ಹಾ. ನೀವು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿಲ್ವಲ್ರಿ ವ್ಯಾಲ್ಯೂಯೇಷನ್
ದುಡ್ಡು ಕಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ. I have.
ಕಟ್ಟಿದಾಯ್ತ್ರಿ, ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಬಗ್ಗೆ ಕೇಳ್ತಾ ಇದೀನಿ ನಾನು.
ಅಲ್ಲ, ಪೇಜ್ 63 ನಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ.
63 ನಲ್ಲಿ ನೀವು ಹೇಳಿರೋ ಪ್ರಕಾರ ಇದು ಅಪೀಲ್ ನಮ್ ಕೋರ್ಟ್ ಮುಂದೆ ಬರಲ್ಲ, ಡಿವಿಷನ್ ಬೆಂಚ್ ಹೋಗ್ತದೆ.
ಡಿವಿಷನ್ ಬೆಂಚ್ ಬರುತ್ತೆ, ಬಟ್ so far
ಅದನ್ನ ನೀವು ಕ್ಲಾರಿಫೈ ಮಾಡ್ಬೇಕಲ್ಲ,
it will be for-
ಅದ್ರ ಬಗ್ಗೆನೇ ಬರ್ದಿರೋದು.
I will clarify today in 1 hour. Kindly pass over. I will clarify.
ಸೊ ಇರ್ಲಿ.
Serial number 6.
Dismissal of the appeal in view of non-compliance of office objection as per court
Appearing to
order
the
dated
appellant, my lords,
21/6.
cost has been paid, my lords. The only objection, my lords, is with respect to the
Is
valuation.
it posted for only for payment of cost or for complaints?
Complaints also, my lords.
Why you have complied it or
My
not?
lords, complaints has been carried out. The only valuation, my lords.
Value of the appeal to be stated correctly ಅಂತಿದೆ.
As per suggestion amount of 12%, my lords.
ಪಾಸ್ ಓವರ್ ಮಾಡಿರ್ತೀನಿ ನೋಡಿ.
Please, my lord.
ಬರೀ ಕಾಸ್ಟ್ ಕಟ್ಟೋದಲ್ಲ, ಕಂಪ್ಲೇಂಟ್ಸ್
Great, great.
ಮಾಡ್ಬೇಕು. ಡಿಸ್ಮಿಸಲ್ ಗಿಟ್ರು ಮಾಡಲ್ಲ. Next 7.
7.
Appeal for the appellant, my lord.
Dismissal of the appeal for non-compliance. ಹೇಳ್ರಿ ಏನ್
My lords, major ಅದರಲ್ಲಿ ಇರೋದು ಡೆಫಿಸಿಟ್ ಕೋರ್ಟ್ ಫೀ ಪೇ ಮಾಡ್ಬೇಕು.
ಮಾಡಿದೀರಾ ಇಲ್ಲ ಅಷ್ಟೇ.
ಮಾಡಿಲ್ಲ.
ಡಿಸ್ಮಿಸಲ್ ಗಿಟ್ಟಿದೆ, ನೀವು ಮಾಡಿದೀರಾ ಇಲ್ಲ?
ಮಾಡಿಲ್ಲ ಮೇಡಮ್.
ಮಾಡಿಲ್ಲ.
unable to reach the client, my lord.
ಹಾ?
my lord. 4 lakhs ಕೋರ್ಟ್ ಫೀ ಇದೆ, my lord. We are unable to reach the client. ಅವರಿಂದ ಏನು ರೆಸ್ಪಾನ್ಸ್ ಇಲ್ಲ.
4 office objection ತಗೊಳ್ಳಿ. The counsel submitted that the appellant did not turn up to comply with office objections, and this court, having taken note of matter was listed for non-compliance on 4th time, imposed the cost. Cost ಕಟ್ಟಿದ್ದೀರಾ?
ಕಾಸ್ಟ್ ಪೇ ಮಾಡಿದ್ವಿ, my lord.
And cost has been paid but not complied with the other office objection, and still there are 4 office objections. And in view of the order passed by this court on 19/7/24, the appeal is dismissed.
Great.
8.
Non-compliance of office objection.
Complied, my
I
registered
appeal for the respondent, my lord.
are-
It is the appellant, my lord, who is required to bring the LRs on record.
Application is filed, my lord.
ಯಾವಾಗ ಹಾಕಿದಿರಿ?
Today, my lord.
ಇವತ್ತು
Please.
ರಿಜಿಸ್ಟ್ರಿ ಹಾಕಿದಿರಾ?
Yes, my.
The counsel for the appellant would submit that he has filed the application for bringing LRs,
LRs on record.
LRs of
report.
R1.
R1.
And hence registry is directed to put up the same.
Machope.
List this matter on. Date ಕೊಡಿ. Notice ಹೋಗ್ಬೇಕು ಮತ್ತೆ ಅದ್ರ ಮೇಲೆ.
6.
6/11.
Machope.
9.
And for the appellant in this case.
Naveen Nanda.
Case I appear for respondent.
And summons and the appeal memo is served, my lord.
First
The memo
time.
is already filed, my lord.
ಏನಾಯ್ತು?
And summons and appeal memo is served, my lord.
ಹಾ.
And same is furnished before the court.
ಅಡ್ವೊಕೇಟ್ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇದೀರಲ್ಲ ನೀವು?
Yeah, come on the record, my lord.
ಹಾ?
Respondent ಒಬ್ರೇ ಇರೋದು. Appear ಆಗಿದ್ದಾರೆ. PF ಏನ್ ಬೇಡ.
PF is also paid, my lord.
ಇದ್ದಾರಲ್ಲ ಅದಕ್ಕೆ ಕೌನ್ಸಿಲ್ ಆಲ್ರೆಡಿ ಆನ್ ರೆಕಾರ್ಡ್.
ಹಾ.
ಏನ್ ಮೇಡಮ್ ನಿಮ್ದು?
I am appear for Proceedings, your
ಹಾ.
honor. The on record is out of station. your
ತಗೊಳ್ಳಿ. ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ
My lord, this
appellant
was
submit
not
that
date may
copy
be
has been
accommodated.
served on the other side,
Date may be given.
and also counsel appeared on behalf of the respondent. And proxy counsel submits that counsel on record for respondent is not in station. And hence list this matter ಯಾವಾಗ ಬೇಕು?
Next week, my lord.
Next week ಕೊಡಿ. 30/10.
Much obliged.
30/10.
Much obliged.
10.
Is a fresh matter appeal, my lord, permitted to serve notice to the
Not
counsel
taking
for
out
trial court
notice on the
adjudication.
learned counsel appearing with the respondents before the trial court. ಹೇಳಿ.
That it was not served to the trial court since the counsel was not in station for some
ಈಗ
time.
ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳ್ರಿ? ಟೈಮ್ ಬೇಕಾ?
One week
Appellant
time.
counsel seeks time to serve the copy of this appeal memo on the counsel on record before the trial court, and hence another 1 week time granted. List this matter on ಯಾವಾಗ ಬೇಕು? ಎಷ್ಟು ದಿವಸದೊಳಗೆ ಶುರು ಮಾಡ್ತೀರಾ?
Within one day after tomorrow I will serve.
ಆಯ್ತು. List this matter on 30/10.
11.
Appellant.
Revision.
Non-compliance of office objection raised on wakalat filed for R1 to R3. ಯಾರು ಇದು R1 to R3?
Lord, I
BS
appear for
Raviprasad.
R1 to R3.
He voluntarily undertook to appear.
BK Sushila.
Hmm.
Appellant has referred her name as BK Sushilamma.
Hmm.
Her Aadhaar also says, my lord, her name is BK Sushila. Wrongly written the name as Sushilamma. And the office is stating that
office
signature
objection-
should be
Office objection only ಸುಶೀಲಮ್ಮಗ.
Sushilamma ಅಂತಾನೆ sign ಮಾಡ್ಬೇಕು ಅಂತ
Office
officer.
objection is overruled. ನೆಕ್ಸ್ಟ್ ಏನ್ ಹೇಳಿ?
ಅದ್ರಲ್ಲಿ the appellant has to serve a copy on me. Appeal
ಆಫೀಸರ್
person.
ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ, now we have directly filed the wakalat.
ನೀವು ಡೈರೆಕ್ಟ್ ಆಗಿ ಹಾಕಿದ್ದೀರಿ.
Without even caveat, he,
Notice.
when the matter I moved,
Ah.
he came and appeared and argued the matter.
Now he is on record, you serve the copy on him.
Well, sir.
The appellant counsel is directed to serve the copy of, ನೀವೊಂದು ಅಪೀಲ್ ಹಾಕಿದ್ದೀರಾ?
ನಾವೊಂದು ಅಪೀಲ್
ಅದ್ರ ಕಾಪಿ ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಟ್ಟಿಲ್ಲ ಏನು.
ಕೊಟ್ಟಿಲ್ಲ.
ಇದು it is coming up for the first time, my lord.
ನೀವು ಕೊಡಿ, ಅವ್ರು
ಕೊಡ್ತೀವಿ.
ಕೊಡಿ, ಒಟ್ಟಿಗೆ ತಗೊಳ್ಳೋಣ.
Yes, and my lord, there is office objection in my matter to say that the
First
documents,
ನನ್ನ matter
now documents. ಏನ್
ನಿಮ್ದ್ರಲ್ಲೂ
produce-
ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಇದೆಯಾ? ಅದು ಆಯ್ತಲ್ಲ.
ಅದಕ್ಕೆ TI may kindly be extended. There is an order of injunction.
Counsel submission with regard to office objection, ಏನ್ ಮೇಡಮ್? ಫಸ್ಟ್ ಸೆಕೆಂಡ್ ಒನ್ ಅಲ್ಲಿ ಹೇಳಿ ಏನು?
Documents ನಾವೇನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀವೋ ಈ ಅಪೀಲ್ ಅಲ್ಲಿ ವೆದರ್ ದಿ ಸೇಮ್ ಇಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಬಿಫೋರ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಂಡ್ ಟೈಪ್ಡ್ ಕಾಪಿ.
ಹೌದ್ರಿ, ಇದನ್ನ ಯಾರು ಓದಕ್ಕಾಗುತ್ತೇನ್ರಿ ಇದು?
Lord, these are what has been produced by the plaintiff before the trial court. Trial court ಅಲ್ಲಿ ಅವ್ರು ಏನ್ ಹಾಕಿದಾರೋ ಅದನ್ನ ಹಾಕಿದ್ರು.
ಟೈಪ್ಡ್ ಕಾಪಿ ಮಾಡಿ ಸಾಕ್ಬೇಕಲ್ಲ?
ಅಲ್ಲ, ಅದೆಲ್ಲ ಬರೀ ರೆಫರೆನ್ಸ್ ಪರ್ಪಸ್.
ಇದು ಅಲ್ದಲೇನೆ 130 to 150 ಏನಾದ್ರು ರೆಲೆವೆಂಟ್ ಡಾಕ್ಯುಮೆಂಟ್ಸಾ?
He is claiming on the basis of a partition, adoption, my lord, suit for partition, stating that he is an adopted son, which the defendants refused to accept that he is the
ಈ
adopted.
ಡಾಕ್ಯುಮೆಂಟ್ ಹೆಂಗ್ರಿ ಓದೋದು?
Very well.
ರಿಲೇ ಮಾಡ್ತೀರಾ ಇಲ್ಲ?
ಇಲ್ಲ, ಅದನ್ನ ನಾವು to only to show that it is not an ancestral property, it is a self-acquired property ಅನ್ನೋದು. His claim is that it's a joint family property ಅಂತ, and passing only one statement to say that it's an ancestral ಅಂತ. There is no other pleading that ಯಾರಿಂದ ಬಂತು ಅಂತ, to show that, my lord, in the written statement it is filed, these documents, that it is a self-acquired property.
ನಾನು ಏನ್ ಬರ್ಕೋಬೇಕ್ರಿ ನಿಮ್ಮ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹೇಳ್ರಿ? ಕೆಲವು ಡಾಕ್ಯುಮೆಂಟ್ ನಾಟ್ ಲೆಜಿಬಲ್.
I'll furnish, next week it may be taken.
Counsel for the appellant in MFA 6503 of 24 seeks time to place the typed copy of page number 59 and 132 to 150. ಆಯ್ತು ಹೇಳಿ. ನೆಕ್ಸ್ಟ್ ನಿಮ್ದೇನು ಹೇಳಿ?
TI extend ಆಗ.
TI ಎಂಟ್ರಿ ಮಾಡಿದೀಯಾ? The entry order granted earlier in MFA 6092 of 24 is extended till next date of hearing. The respective counsels for appellant are directed to serve the copy of appeal memo on the other side and list this matter on. ಯಾವಾಗ?
Any date, next week, any date.
ಕೊಡ್ರಿ. 6/11.
In fact, the suit is already stayed, my lord. We had filed rejection of claim, which was rejected. We have filed a CRP. This honorable court has already stayed further proceedings of the trial.
ಇನ್ನೇನು ಎಂಟ್ರಿ ಮಾಡಿದೀಯ ಅಂತಲ್ಲ?
ಅವರು, in spite of me stating the same thing before the court, they insisted that they wanted an entry.
6/11 ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಹೇಳಿ.
Very well.
ಯಾರು
ಒಂದೇ ಸಮ ಮಾತಾಡ್ತಾ ಇದಾರೆ, ತಪ್ಪು ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಒಂದೇ ಸಮ ಮಾತಾಡ್ತಾರೆ ನಮ್ಮ ಸ್ನೇಹಿತರು. ಇಲ್ಲಿ ನಾನ್ ಕೇಳ್ತಾ ಇರೋದು ಇಂಜಂಕ್ಷನ್ ನಾಟ್ ಟು ಡಿಸ್ಪೋಸಸ್, ಅದಿರೋದು ಫರ್ದರ್ ಪ್ರೊಸೀಡಿಂಗ್. ಅದಕ್ಕೆ ಇದಕ್ಕೂ ಸಂಬಂಧ.
Stay of the suit ಆದ ನಂತರ
ಆಯ್ತ್ರಿ,
what happens?
ಯಾರು ಅನ್ನೋದು ಡಿಸೈಡ್ ಮಾಡೋಣ. ಆಯ್ತು. ಆಯ್ತು.
My lord, serial number 9 interim order may be extended.
ಯಾವ ಸೀರಿಯಲ್ ನಂಬರ್?
9 interim order may be extended. Last occasion interim order ಇದೆ.
ತಗೊಳ್ಳಿ, ಸೀರಿಯಲ್ ನಂಬರ್ 9 ಅಲ್ಲಿ ಎಂಟ್ರಿ ಆರ್ಡರ್ ಗ್ರಾಂಟೆಡ್ ಅರ್ಲಿಯರ್ ಇಸ್ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಟಿಲ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಅಂತ ಹಾಕೊಳ್ಳಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 9.
12
May please your lordship,
KV.
for the appellant, my lord, the office has raised the issue of
ಮೇಂಟೈನಬಿಲಿಟಿ ಅಪೀಲ್ ಅಗೇನ್ಸ್ಟ್ ಆರ್ಡರ್ ಡೇಟೆಡ್ so and so.
My lord, I may be permitted to file this memo on behalf of the appellant.
ಏನ್ ಮೆಮೋದಲ್ಲಿ ಏನಿದೆ ಹೇಳ್ರಿ?
If I may submit, the appellant is before your lordship under section 37 of the Arbitration Act. The appellant's land was acquired by the National Highways Authority, and then it was subject to compulsory arbitration under section 3G5. Unhappy with the arbitral award, the appellant had approached the district court of Dakshin Kannada under section 34, which also had been designated as a commercial court. Hagagi, when I'm before your lordship under section 37.
The appellant submits that he has filed the appeal against the arbitration suit filed under
Arbitration petition, my lord.
petition 34 ತಾನೇ ನೀವು ಅವಾಗ ಹಾಕಿದ್ದು, ಈಗ 37 ಅಲ್ಲಿ ಹಾಕಿದ್ರಿ. ಈಗ 34 of the Arbitration Act, and the very same court is also designated as commercial court, and hence the same is not a commercial appeal, and hence counsel memo is accepted and office objection regarding maintainability is overruled. ಇನ್ನೊಂದು ಎಷ್ಟು? 15. The appellant counsel is directed to comply with remaining office objections within 2 weeks.
Please.
15 ಇದೆ ನೋಡಿ.
13.
Discrepancy in the father name of R2.
Kindly
Plain copy of trial court impugned.
ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿದ್ವಿ ಸುಮ್ಮನೆ
ಹಾ.
ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 16 ಅಲ್ಲಿ ತಪ್ಪಾಗಿದೆ.
Ordinal mistake ಆಗಿದೆಯಾ?
ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ.
Counsel appearing with the appellant would submit that the plaint correctly mentioned the name and while typing the order, there is a typographical error and hence office objection is overruled. List this matter ಯಾವಾಗ ಬೇಕು ಹೇಳಿ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮೇಲೆ
3010.
14.
Swaroop Anand.
Oh, the appellant.
Non-depositing of
Deposited
rupees
the
3
funds
lakh
on
before this
2110.
court. Huh?
I have deposited the funds on
The
21.
council submits that he has deposited an amount of rupees 3 lakh on 21/10/2024.
24.
ಹೌದಾ?
The acknowledgement.
ಅಷ್ಟೇನಾ? List this matter on.
My lords, I'm also filing an affidavit, my lords. There is an interim order not to precipitate. In spite of that, my lords, they're troubling me and disconnecting the DG power, asking not the garbage na tegibedi anta.
Sorry, the counsel for the appellant also filed affidavit before this court. Copies serve ಮಾಡಿರ other side ಗೆ?
ಇಲ್ಲ sir.
And copies.
We have not precipitated anything in this case, your lordship.
Copies served on
Though,
the other side. Huh?
even though the stay was not there, then also we have not disconnected anything.
they
We
have-
are giving all the amenities to them.
I think affidavit
On,
ಹಾಕಿದ್ರೆ.
on
ಹಾಕಿದ್ದಾರೆ.
record, it's
affidavit ಗೆ
maybe-
ಏನಾದ್ರು ನೀವು
Yes, ma'am.
objections ಹಾಕಂಗಿದ್ರೆ ಹಾಕಿ. ಯಾವತ್ತು? ಏನ್ ಮಾಡ್ತೀವಿ?
Maybe
ಅಲ್ಲ ನಿಮ್ submission record ಮಾಡ್ಲಾ?
submission ಅಂತ record ಮಾಡಿ. We have not disconnected
Not
anything.
disconnecting.
Any amenities has not been stopped.
my lords, their own written statement have accepted it that in spite
DG
of the interim order, they have disconnected the DG power ಅಂತ ಅವರೇ writing ಅಲ್ಲಿ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಎಲ್ಲಿದಾರ?
My lords, the written statement, my lords may kindly look at page 1.
ಈ statement ಅಲ್ಲಿ ನೀವೇ disconnect ಮಾಡಿದ್ದೀರಿ.
Disconnect ಮಾಡಿ ಅಂತ ಹೇಳಿಲ್ಲ ಸ್ವಾಮಿ.
ಮಾಡಿ-
Misguide ಮಾಡ್ತಾರೆ.
ಅಲ್ಲ,
One second. I will read out that portion.
Order ತೋರಿಸ್ಬಿಡ್ತೀನಿ ಸ್ವಾಮಿ.
ಆಯ್ತು.
Interim order ಅಲ್ಲಿ including DG power ಅಂತ interim order ಇದೆ specific ಆಗಿ.
ಆಯ್ತು.
ಅವರ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ paragraph 8 ಅಲ್ಲಿ page 193 ನಲ್ಲಿ ಅವರೇ ಬರ್ಕೊಳ್ತಾರೆ ಸ್ವಾಮಿ that we have disconnected DG power ಅಂತ.
Your lordship, it is not.
Paragraph 8, page 193, my lords. They have themselves written in the written statement that they have disconnected DG power. Until date, I don't have.
193 ನಲ್ಲಿ paragraph 8 ಯಾವುದು ಇಲ್ಲ.
Page 193, my lords.
194 ಅಲ್ಲಿ ಇದೆ.
Paragraph, sorry, my lord.
DG power connection disconnected long ago where the scheduled property was locked from 2018.
Correct.
That the Bescom also had disconnected.
Bescom power ಬಗ್ಗೆ ನಾನು ಮಾತಾಡ್ತಾನೆ. DG power ಗೆ
connection
ನಾನ್
for the
disconnect ಮಾಡಿಲ್ಲ
non-payment
ಅದನ್ನ.
of
ಅಲ್ಲ DG power out
DG power
control ಅಲ್ಲೇ
2018 ಅಲ್ಲಿ disconnect
2018 disconnect
ಆಗಿ ಹೋಗಿದೆ.
ಸ್ವಾಮಿ DG ಅವ್ರ ಕಂಟ್ರೋಲ್ ಅಲ್ಲೇ ಇರೋದು.
Sir, control ಅಲ್ಲಿ, sir, your lordship, if you can.
ಬೆಸ್ಕಾಂಗೂ ಇದಕ್ಕೂ ಸಂಬಂಧನೇ ಇಲ್ಲ ಸ್ವಾಮಿ.
Bescom ನಾವು question ಮಾಡಿಲ್ಲ ಇಲ್ಲಿ.
Interim order specifically says that I should be given DG power ಅಂತ.
DG
of the
power.
trial
ಇಲ್ಲ ಅವರು ಓದಿ ಕರೆಕ್ಟ್ ಆಗಿ that the Bescom also had disconnected the power connection for the non-payment of.
I have Bescom power today, my lords. There is no problem with Bescom power.
In the month of March 2024, the connection was restored after clearing the dues ಅಂತ ಅವರೇ ಹೇಳಿದಾರ್ರಿ.
ಅಲ್ಲ ಸ್ವಾಮಿ, DG power is an additional cost to the same has to be
Additional
connected
cost to the
post payment
association
of
and
maintenance dues.
ಹೌದು.
Connected
Post
post
payment of
the-
maintenance dues. The entire dispute is the quantum of maintenance dues, my lords. In fact, my contention is that, my lords, they are claiming from 2018. They have not made any claim against
ಆಯ್ತು,
by.
ನೀವೇನು affidavit ಗೆ objections ಹಾಕ್ತೀರಾ ಹಾಕಿ
Your lordship, in statement of objection, page number 6, just, I will highlight that, just only that paragraph.
ಹಾಕಿರೋ statement of.
Key statement of objection. Yes, your lordship. At page number 6, it is very clear why that has been, issue is rising.
ಏನ್ ಹೇಳಿದ್ರಿ?
Appellant has entered the high voltage electric panel area, which is para number 10, your lordship.
ಹಾ.
So dangerous, and it is installed a non-compatible ACCL. One second, your lordship. Non-compatible ACCL without the approval of the respondent association. They have installed a 32 AMPS ACCL to switch to over to the DG instead of 25 AMPS, which is a non-compatible and can draw 7 kilowatts load of the DG instead of designed KW 1 kilowatt of DG. See, basically the requirement is 1 kilowatts for that 25 AMPS, which they have to install it. We have not disconnected anything. They have to install proper
Manufacturer ಅಲ್ಲೇ ಇಲ್ಲ ಸ್ವಾಮಿ.
instrument to that. No, we have not disconnected anything.
ಅದು ಮ್ಯಾನುಫ್ಯಾಕ್ಚರ್ ಅಲ್ಲೇ ಇಲ್ಲ ಸ್ವಾಮಿ.
ಇಲ್ಲ ಸ್ವಾಮಿ,
ಈ
ನಾನು
ಬೇರೆ
quotation
ಎಲ್ಲ
ಕೊಡ್ತೀನಿ.
apartments 32 AMPS ಇರೋದು.
If that is the case, I will produce the copy.
9 ಲಕ್ಷ ಕೊಡ್ಬೇಕು, ಇಲ್ಲಾಂದ್ರೆ ಕೊಡಲ್ಲ ಅಂತಾನೆ ಕೂತ್ಕೊಂಡಿರೋದು ಅವ್ರು.
ಇಲ್ಲ.
Order of this court, trial court, everything.
We can go to
It's unfortunate
the, on the main argument, we can go ahead, your lordship, because
ಅಲ್ಲ, I'm
if you want to argue, we'll.
I'm ready.
The counsel for the appellant has filed affidavit and the counsel for the respondent submits that they have not disconnected the DG power.
Correct. They have to put the compatible machine.
And hence list this matter for consideration of the main appeal on grounds, a main appeal on ಯಾವತ್ತಾರ ಒಂದು ಡೇಟ್ ಕೊಡಿ ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ ನಲ್ಲಿ
29.
29/10.
Please.
My lords, interim order may kindly be extended.
Interim order granted earlier is extended till next date of hearing.
Highly obliged.
50.
I'll clarify on the maintainability, my lord.
Hmm.
I've also already told the party to obtain the certified copy of the valuation slip, my lord. 2 weeks time may be granted, my lord.
The council seeks 2 weeks time to comply with office objection and hence list after 2 weeks.
Sustainability.
Hmm?
More than value ಇರೋದು sir. More than 10 lakhs.
ಅದೇ more than value ಜಾಸ್ತಿ ಇದೆ ಅಂತ ಅವ್ರೇನೋ ಡಾಕ್ಯುಮೆಂಟ್ ತರ್ಲಿ ಕೇಳಿದಾರೆ.
Document sub-ratio value, because it is 4 acres of land
Yes.
and it is 10 lakhs, it is shown as 10 lakhs.
Acceptance of PF furnished number
60.
on 8/10/24 after lapse of time granted by this honorable court. ಏನ್ರಿ ಇದು? PF ಆಮೇಲೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
My lord, in this matter,
Hmm.
Lord, the caveat had been filed on 4th of October itself.
Hmm.
Without noting the caveat, my lord, the matter was heard in the vacation bench.
No caveat. There is no caveat. my lord.
There is, my lord, I have an acknowledgement for having filed caveat.
Was there any objection to the caveat petition?
It is
Not
not
that I
even
am aware of,
listed.
my lord. Anyway, I have a copy of the caveat petition with me, my lord.
ನೀವು ಎಷ್ಟು ಗಂಟೆಗೆ ಫೈಲ್ ಮಾಡಿದ್ರಿ?
Pardon?
ಮ್ಯಾಟರ್ ಕೋರ್ಟ್ ಮುಂದೆ ಲಿಸ್ಟ್ ಆಗಿರೋದೇ 410 ಅಲ್ಲಿ.
ಅದೇ 410 ಗೆ ಫೈಲ್ ಮಾಡಿದೆ.
ನೀವು ಫೈಲ್ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಫೈಲ್ ಆಗಿ.
No, but your lordship sees it appears to have been moved in the morning and taken up at 2:30. And by then I had filed the caveat petition. Anyway, I'm
No, my lord, we didn't.
I'm not saying he knows about it. All that I'm saying is that the wakalat filed in the
ವಕಾಲತ್ತು ನೀವು ಕೇವೇಟ್ ಹಾಕಿದ್ರು ಅವ್ರಿಗೆ ಕಾಪಿ ಸರ್ವ್ ಆಗಿರಲ್ಲ.
ಹಾ.
ಅದರಿಂದ ಅವ್ರಿಗೂ ಕೂಡ ನಾಲೆಡ್ಜ್ ಇರಲ್ಲ. ಬಟ್ ಅವತ್ತೇ 4th ಆರ್ಡರ್ ಆಗಿದೆ. ಹೇಳಿ ಏನಾದ್ರು ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಏರ್ ಮಾಡೋಣ ಇಲ್ಲ ಡೇಟ್ ಕೊಡೋಣ.
ಇಲ್ಲ, my friend wanted time. Your lordship may have it tomorrow, my lord, for admission.
ನೋಡಿ. ಮಂಡೇ ಹಾಕೋಣ.
No, your lordship may have it tomorrow, my lord. There is some urgency in this.
ಹಾ.
The reason is this, my lord. I have a registered sale deed in my favor in 13th of March 2024. He has an unregistered sale agreement which doesn't say about delivery of possession. Trial court has said that since I have got a registered sale deed, my lord, not to interfere with my possession. Question is whether that order requires.
Sale is.
No, he asked for time for tomorrow, my lord. I have no difficulty.
ಟೈಮ್ ಬೇಕಾ?
Either tomorrow or Monday, my lord. I'll argue.
ನೋಡಿ ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ 6 ಟೈಮ್ ಅಂಡ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್. ಓ ನಿಮ್ದು ಹೆಸರು ತೋರಿಸಿಲ್ವಾ?
ಅದಕ್ಕೆ the wakalat in the.
This is directed to show the name of the council. ಯಾರ ಹೆಸರಲ್ಲಿ ಹಾಕಿರೋದು?
Manasa Rao, my lord.
Manasa Rao. In view of caveat is already filed on 4th of October. Copies ಎಲ್ಲ ಸರ್ವಾಗಿದೆಯಾ?
ಎಲ್ಲ ಆಗಿದೆ.
No, we served them, my lord, separately.
Yes, I'm not saying no.
And council submits that copy is also served on the other side and hence list this matter day after tomorrow.
Obliged, madam.
Interim order is speaker.
Interim order granted earlier is extended till next date of hearing.
70. And Ashwath.
The loss is kind, my lord. 2 weeks time may be.
Non-taking of steps in respect of deceased R4, R5, R8.
Yes, my last time they reported before the court, I
Hmm?
got the information from the party. I'll file it within 10 days, my lord. Let it be 2 weeks, my lord.
ಏನ್ ಟೈಮ್ ಬೇಕಾ?
One time.
ಇಷ್ಟ್ ಜನ ಸತ್ತವ್ರಲ್ರಿ?
10 ಜನ ಸತ್ತೋಗಿದ್ದಾರೆ.
ಆರ್
ನಾನು
ನೈನ್
ರಿಕ್ವೆಸ್ಟ್
12
ಮಾಡಿದೆ
14
ಕೋರ್ಟ್ಗೆ.
6 to
It was
18.
heard partly several times, but even then court said 2 weeks time may be granted.
Appellant counsel seeks 2 weeks time to bring the LRs of the deceased respondents.
Please.
Hence 2 weeks granted, list this matter, 2 weeks ಆದ ತಕ್ಷಣ ಕೊಡಿ ಮೇಡಮ್.
711.
711.
Obliged.
18.
ಅದೇನೋ ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಟೈಪ್ಡ್ ಕಾಪಿ ಏನೋ ಇದೆ ನೋಡ್ರಿ.
So, respondents have to file that.
ಮೇಡಮ್
ಮಾಡ್ತೀವಿ sir.
ತೊಗೊಳ್ಳಿ. Respondent counsel seeks time to file typed copy of D1 to D4.
ಸಿನಾಪ್ಸಿಸ್ ಎಲ್ಲ ಹಾಕಿದೀವಿ ಅದು ಬಟ್ ಮತ್ತೆ ಬಂದಿದೆ ಅದು.
ಮತ್ತೇನೋ ಇಲ್ಲ ಅಂತ ಬಂದಿದೆ?
ಎಲ್ಲ ಅದು ಹಾಕಿದೀವಿ ಸಿನಾಪ್ಸಿಸ್ ಎಲ್ಲ ಐ ಫೈಲ್ಡ್ ಇನಿಷಿಯಲಿ ಇಟ್ಸ್
18. Sachin BS.
Other LRs has already taken steps.
Furnishing of PF ಹೇಳ್ರಿ ಏನು?
Steps, other LRs ತಗೊಂಡಿದ್ದಾರೆ steps, but ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿಲ್ಲ. 5A ಒಂದು ಮಾತ್ರ ಸರ್ವ್ ಮಾಡಿ.
ಫೈಲ್ ಸತ್ತೋಗಿದ್ದಾರೆ. ಅವ್ರಿಗೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರು.
ಹಾಕಿದಾರ?
ಅದರಲ್ಲಿ 5A ಮಾತ್ರ ಸರ್ವಿಸ್ ಮಾಡಿಲ್ಲ.
ಸೇಮ್ ಅಡ್ರೆಸ್ ಎಲ್ಲ ಇದ್ದಾರೆ, ಬಟ್ ಇವರು
ಸರಿ ಈಗ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ?
ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ತಗೋದು.
Appellant counsel seeks time to file necessary application. for paper publication. And hence, ಎಷ್ಟು ದಿವಸ ಬೇಕು?
1 week, madam.
Hence 1 week time granted. List this matter 1 week ಆದ್ಮೇಲೆ ಕೊಡಿ.
ಮತ್ತೆ?
30/10 4/11.
19. Prakash T. Hebbar.
appellant.
Notes idರಲ್ಲಿ appellant one
Compliance of office objection raised on IA 1/23 for bringing LRs of deceased A1.
Office
F.
of-
have the copy, my lords.
Huh?
I have the copy, my lords. I'll serve it, my lords. The application may be considered, my lords. Appellant one F ತೀರೋಗಿದೆ.
Other side copy serve ಮಾಡಿಲ್ವಾ? Okay.
I'll serve it.
Appellant counsel seeks 1 week time to comply with office objections on IA 1/23. 23 ಹಾಕಿರೋದು ಒಂದು ಕಾಪಿ ಕೊಡಕ್ಕಾಗಲ್ವೇನ್ರಿ ಅದರ್ ಸೈಡ್ಗೆ 2008 ಅಪೀಲ್.
I'll serve it today on.
List this matter on one date ಕೊಡಿ ಮೇಡಮ್.
4/11.
4/11.
20. VB Shivkumar.
Non taking of steps in respect of deceased R2 by counsel for appellant. ಹಾ ಹೇಳ್ರಿ. ಇಲ್ವಾ? ಎಷ್ಟನೇ ಸರಿ ಬಂದಿದೆ ನೋಡಿ, ಯಾರು ಸತ್ತೋಗಿದಾರ? ಯಾವಾಗ ರಿಪೋರ್ಟ್ ಆಗಿರೋದು ಡೆತ್?
ಜುಲೈಯಲ್ಲಿ ಆಗಿದೆ. ಒಂದ್ಸತಿ ಆಗಿದೆ ಸರ್, ಅದಾದ್ಮೇಲೆ ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇರೋದು.
ಫಸ್ಟ್ ಟೈಮ್. The appellant counsel is absent, 2 weeks time granted to bring the LRs of. Time ತಗೊಂಡಿದಾರಲ್ರಿ 23 ನಲ್ಲಿ. Learned counsel for the appellant submit that respondent number 2 is dead and prays weeks time to take necessary steps. Third, in spite of time was taken, ಹೊರದಾಕಿ ಮೇಡಮ್ ಬಂದಿಂದು. In spite of time was taken on 25/7/23 to bring LRs of respondent number 2, even after lapse of 15 months. No steps are taken and hence appeal against R2 is abated.
21.
Appellant in this
PM
case,
Narayan Swami.
the appellant number 1 died, my lord. The LRs already brought on record.
ಯಾರು? ಆಲ್ರೆಡಿ ಇದಾರ?
ಇದಾರೆ ಸರ್, ಮಕ್ಕಳಿದ್ದಾರೆ. ವಿಶ್ವನಾಥ್ 3 ಜನ ಇದ್ದಾರೆ.
ಮಕ್ಳಿದಾರ್ರಿ, ಮೆಮೋ ಹಾಕಿದ್ರೇನ್ರಿ ನೀವು?
ಮೆಮೋ
ಮತ್ತೆ ಕೊಡಿ. ಇದಾರೆ ಅಂದ್ರೆ? The appellant counsel files memo. Already brought on record ಅಂತ ಹೇಳ್ತೀರಲ್ರಿ, ಯಾರು ಹೇಳ್ರಿ? ದೇವ್ರ ಕಾಪಾಡ್ಬೇಕು ನಿಮ್ಮನ್ನ.
ಫೈಲ್ ಮೆಮೋ
ಯಾರು ಹೇಳಿ?
ವಿಶ್ವ
ಅಪ್ಲೆಂಟ್ 1 ಯಾರ್ರಿ ಎಲ್ಲಾರ್ಸು?
appellant 2, appellant 1 died, 2 to 4 my lord. ಅವರಲ್ಲಿ ಇದಾರೆ 3 ಜನ ಇದ್ದಾರೆ.
ಅಪ್ಲೆಂಟ್ ನಂಬರ್
2 to 4 my lord.
2 to 4
Please.
ಕರೆಕ್ಟಾ? ಅದನ್ನ ಬರೆಯಕ್ಕೇನು? ಅಪ್ಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಟ್ಸ್ ದಟ್ ದಿ ಅಪ್ಲೆಂಟ್ ನಂಬರ್ 2 to ಇದಾರ ನೋಡಿ ಮೇಡಮ್.
ನೋಡ್ತಾ ಇದೀನಿ.
2 to 4 are the LRs of appellant number 1 and they may be treated as LRs of appellant number 1. ಹೌದಾ? And hence ಅದ್ರಲ್ಲಿ ಬರ್ಸ್ಕೊಳ್ಳಿ, ಕರೆಕ್ಟಾಗಿ ಬರ್ಸ್ಕೊಳ್ಳಿ ಅವ್ರ ಕೇಳಿ.
ಯಾರ್ಯಾರು?
And hence memo is accepted and they are treated as LRs of appellant number 1. Appellant counsel is directed to amend the cast title and file amended cast title within 1 week from today. List this matter on 4/11.
22.
For the appellant.
Letter issued from Honorable Supreme Court in notary pertaining to civil appeal number so and so arising out of RFA 1041 of 2008 and RP number 12 of 2008. Non-compliance of office objection raised on paper book, that is signature of the, ಏನ್ ರಿಮ್ಯಾಂಡ್ ಆಗಿದೆಯಾ ಮ್ಯಾಟ್ರ್? ಏನಾಗಿದೆ ರೀ?
ವರ್ಷಪ್ ಅದು ವಾಪಸ್ ಬಂದು ಇದಾಗಿದೆ. ರಿವ್ಯೂ ಪೆಟಿಷನ್ ಹಾಕಿದ್ದು, ಇಟ್ ವಾಸ್ ಡಿಸ್ಮಿಸ್. ಅದರದ್ದು ರಿವ್ಯೂ
RFA ಡಿಸ್ಪೋಸ್ ಆಯ್ತು.
ಹೌದು.
ಅದ್ರ ಮೇಲೆ ಹಾಕಿದ್ರಿ.
Even we are not sure why this matter has come up. We are not sure why this matter has come up. It was done and dusted. So it may be disposed of, your lordship.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಲೆಟರ್ ಏನ್ ನೋಡ್ರಿ, ಮೋಸ್ಟ್ಲಿ ಅದು ಇಂಟಿಮೇಷನ್ ಇರ್ಬೇಕು. RP ಅಲೋ ಮಾಡಿದ್ರು, ಅದ್ರ ಮೇಲೆ ಹೋಗಿದ್ದಾರೆ, ಅದನ್ನ ಚಾಲೆಂಜ್ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿ RFA ನಲ್ಲಿ ಏನಿತ್ತು ಅದೇ ಆರ್ಡರ್ ಕನ್ಫರ್ಮ್ ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ. ರಿವ್ಯೂ ಆರ್ಡರ್ ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನ ರಿವ್ಯೂ ಆರ್ಡರ್ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿ ಲೆಟರ್ ಕಳಿಸಿದ್ದಾರೆ. ಇದು ಕಾಪಿ ಆಫ್ ದಿ ಜಡ್ಜ್ಮೆಂಟ್ ಕಳಿಸಿದ್ದಾರೆ. ವೈ ದೇ ಹ್ಯಾವ್ ಪೋಸ್ಟೆಡ್ ದಿ ಮ್ಯಾಟರ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್ ಕನ್ಸಿಡರ್ಡ್ ಅಟ್ ದಿ ಸ್ಟೇಜ್ ಆಫ್ ಫೈಲ್ಡ್ ಹಿಯರಿಂಗ್ ಅಂತೇನೋ ಇದೆ ಇಲ್ಲಿ. One for permission filed by respondent. Why it is posted those? Pass over nodan. Why they have posted, we'll see.
23
ಏನ IA3 filed for appellant ಇವೆಲ್ಲ ಏನೇನೋ ಇದೆಯಲ್ಲ ಮೇಡಮ್, ಏನಕ್ಕೆ ಹಾಕಿದ್ದಾರೆ?
non compliance ಇದೆ.
2016 ಹಳೆವೆಲ್ಲ ಯಾಕೆ ಹಾಕಿದ್ದಾರೆ ಡಿಸ್ಪೋಸಲ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ?
23
Letter dated 29 regards return of the original entire records in OS number 1302 this District Court Bangalore. Non-compliance of office objection raised on IA3/2000. ಈ ಹಳೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಎಲ್ಲ ನೋಟ್ ಮಾಡಿ ಯಾಕೆ ಹಾಕ್ತಾರೆ ಮೇಡಮ್?
ಕಾಪಿ ನಾಟ್ ಸರ್ವ್ಡ್ ಅಂತ ಇದೆ ಸರ್, ಅದು ಅವಾಗಿಂದ.
ಅದಾಗಿರ್ಲಿ, ಈಗ ಏನಕ್ಕೆ ಹಾಕಿದ್ರು ಕೋರ್ಟ್ ಮುಂದೆ? ಲೆಟರ್ ಬಂದಿದೆ, ರಿಕಾರ್ಡ್ಸ್ ರಿಟರ್ನ್ ಆಫ್ ದಿ ಒರಿಜಿನಲ್ ರೆಕಾರ್ಡ್ಸ್ ಅಂತ ಅವ್ರೇನೋ ಒರಿಜಿನಲ್ ರೆಕಾರ್ಡ್ಸ್ ಕಳಿಸಿ ಅಂತ ಲೆಟರ್ ಬರ್ದಿರ್ಬೇಕು ನೋಡಿ. 1365 of 1989. Sorry. This court has received the letter dated 29/24 from the Registrar City Civil Court, wherein request is made to return the entire record in OS number 1365 of 1989. And in terms of the letter, the concerned branch is directed to return the original entire records in OS number 1365 of 1989 to the concerned.
I have filed wakalat for appellant. I have filed wakalat for appellant number 2, my lord. It has not been.
Appellant number 2 na?
Appellant number 2 and some of the.
Then matter pending ಇದೆಯಾ?
Matter pending.
ಮತ್ತೆ ಯಾಕೆ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ ಲೆಟರ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕಳಿಸಿ ಅಂತ ರೆಕಾರ್ಡ್ಸ್ ಕಳಿಸಿ ಅಂತ ಬರ್ದವ್ರಲ್ಲ ಯಾಕೆ ಮೇಡಮ್?
Records have been called by the trial court.
ಏನಕ್ಕೆ ಅಂತ ಏನೋ ರೀಸನ್ಸ್ ಇದೆಯಾ?
For amendment of the.
Amendment of FDP filed by the incorporator section maintaining the application after amendment of the plan. Draw the fresh preliminary decree by incorporating them item number 16 property further directed to Rolly. Send the records to the City Civil Court and get back the same within 2 weeks from today.
One submission, my lordship.
For appellant number, my name may be shown in the cast statement.
ನೀವು ವಕಾಲತ್ ಹಾಕಿದಿರ?
I filed wakalat in.
ಸರ್ ಯಾರಿಗೆ ಅಪಲೆಂಟ್ ನಂಬರ್?
Appellant number 2.
ಯಾರ ಇದಾರಲ್ಲ ಕೆ ಪ್ರಕಾಶ್ ಅಂತ.
No, with
ಬೈ ಮೆಸರ್ಸ್ ಲೀಗಲ್ ಸರ್ವಿಸಸ್ ಇಂಕ್ ಫಾರ್ R1A and A2 ಅಂತ ಇದೆ.
even for some of the legal years of A1 have died, my lord. I will bring them also, my lord.
ಅಲ್ಲ ಬಟ್ ಅವರಿಂದ NOC ತಗೊಂಡಿದ್ದೀರ?
NOC with NOC we had filed wakalat.
ನೀವು ಯಾರ್ಯಾರು ವಕಾಲತ್ ಹಾಕಿದ್ರಿ ಈಗ?
For as of now I filed for appellant number 2, my lord.
ಅಪಲೆಂಟ್ ನಂಬರ್ 2 ಮಾತ್ರ?
Appellant number 2.
ಕೌನ್ಸಿಲ್ ಶ್ರೀ
Alaswamy, BM Alaswamy.
BM Halaswamy submits that he has filed wakalat for appellant number 2 with NOC. ಹೌದಾ? And hence registry is directed to put up the same and show the name of the counsel for appellant number 2.
One submission, my lordship. I am appearing for R5B. And if I have given, the R5B has obtained NOC wakalat from my lordship, but still my name has been reflected. R5B.
R5B.
P Nehru Association.
He is also died.
I have given NOC wakalat. Yeah, they obtained the NOC wakalat from me. Avagle 2019 they have taken NOC wakalat from me.
NOC ವಕಾಲತಿಗೆ ಯಾರಿಗೂ ಹಾಕಿಲ್ಲ.
My name may be
No, she is also dead, madam.
ಅವ್ರು ಹಾಕಿಲ್ಲ ಸ್ವಾಮಿ, but they are taken. but-
R5B
R5B is also no more. I will bring LR sub.
The appellant counsel submits that R5B is also no more. And counsel for R5B submits that his name may be deleted. And hence, counsel P. Nehru and K. Govind Raju by Messrs. Nehru Associates name is ordered to be deleted.
Much obliged.
24. Rakshit Kumar.
Allow one sentence, sir. The appellant counsel seeks time to bring the LRs of R5B. And next time. Here, Rakshit Kumar.
My lords, in this, the only objection, my lords, on the app, that my lords, we have not served a copy on the other side, my lords, that was done. In fact, the matter was listed on two previous occasions, my lords, where copies were served on the learned counsels appearing for the.
Again, serve madidira.
Agis.
The counsel for the appellant would submit that he has already served the copy of IA number 3 of 24 on the other side. So the other side are idara.
State is one party, Swami.
Nimi copy ಕೊಟ್ಟಿದ್ದಾರೇನ್ರಿ? 3 of 24.
Early hearing application.
State bitter ಬೇರೆ ಯಾರು?
Private respond.
MC Ravi Kumar for R3 to R7 ಇದ್ದಾರೆ.
ಅವ್ರಿಗೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದೆ ಸ್ವಾಮಿ. ಅವ್ರು ಇನ್ಫ್ಯಾಕ್ಟ್ ಸಿನಾಪ್ಸಿಸ್ ಹಾಕಿದ್ದಾರೆ. ಸೊ ದಿ ಆಲ್ ದ ಪ್ಲೀಸ್
ಅವ್ರು ಹಾಕಿದಾರ?
ಅವರು ಹಾಕಿದ್ದಾರೆ. Pleadings are completed, not sir.
The application is filed for early hearing and this is the appeal of the year 2012. And counsel for R3 to 7 is also not present before the court. And in view of the reasons stated in the accompanying application and affidavit on IA number 3 of 24, IA is allowed. Post the matter for final hearing on,
ನಮಗೆ ಮಾಡಿದ್ದಾರೆ.
ವಕಾಲತ್ ಹಾಕಿಲ್ವೇನ್ರಿ?
ವಕಾಲತ್ ಹಾಕಿದೀವಿ ಸ್ವಾಮಿ. ವಕಾಲತ್ ಸೆಪರೇಟ್ ಆಗಿ
ಕಾಪಿ ಸಬ್ಜೆಕ್ಷನ್ ಇದೆ ನೋಡಿ. ವಕಾಲತ್ ಟು ಬಿ ಫೈಲ್ಡ್ ಅಂತ ಇದೆ. ಅಜಿತ್ ಆನಂದ್ ಶೆಟ್ಟಿ.
ಅಲ್ಲ, ಇನ್ ದ ಮೀನ್ ಟೈಮ್ ಅದ್ ಮಾಡ್ತೇನೆ ಸ್ವಾಮಿ. ನಾನು ಮಾಡಿ we have filed the ವಕಾಲತ್. I'll verify. Because it was a NOC brief.
ಏನು ಆರ್ಡರ್ ಇಲ್ಲ. The counsel submits that he has served the copy on the other side. ಅಷ್ಟೇ ಹಾಕ್ಬಿಡಿ. And counsel is directed to verify whether he has filed wakalat or not in view of the office objection. List this matter on 7/11.
Grateful.
Hearing on I-25. Sangamesh G. Patil.
Notice ಹೋಗಿದೆಯಾ?
Appellant.
Non-filing of detailed affidavit in support of the IA 1 of 16. ಹೇಳ್ರಿ.
I have filed the better affidavit.
ಹಾಕಿದೀರಾ?
Please.
ಯಾವಾಗ?
Yesterday I filed.
Copy has not been received.
Better affidavit copy. ನೀವು ಎಸ್ಟರ್ಡೇ ಹಾಕಿದ್ರೆ ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
Copy I will serve.
ಕೊಡ್ರಿ. ಮೊದ್ಲೇ ಕಾಪಿ ಫೈಲ್ ಮಾಡಕ್ಕಿಂತ ಮುಂಚೆನೆ ಸರ್ವ್ ಮಾಡಬೇಕು. ತಗೊಳ್ಳಿ. The counsel for the appellant submits that he has filed better affidavit and copy is also served on the counsel. ಯಾರು ನೀವು ಯಾರಿಗೆ?
For respondent number 2, my lord.
R2 ಗ?
Please, ma'am.
ಅವ್ರಿಗೆ ಕೊಡಿ. AGA ಕೊಡಿ.
Served, my lord. Government we have served.
Serve ಮಾಡಿದ್ದೀರಾ?
Filing we have served.
And counsel for the appellant submits that already served. AGA who appears for R1. ಇದೆಯಾ ಕಾಪಿ ಇದೆಯಾ?
I'll verify and file the objections, my lord. This is for continuation.
Covered by the judgments of the.
Counsel for R2 seeks time to file objections to better affidavit filed by the appellant. List this matter on 7/11.
Please.
26. R. Shashidhara.
Appear for the respondents in this matter.
PD of 39 days. ಹೇಳ್ರಿ.
Your lordship, in this matter, there are consequence of matters which are.
ಏನ್ರಿ ಚೀಟಿ ಬರ್ಕೊ ಬಂದಿದ್ದೀರಿ?
Alla, these are the list of matters, your lordship, in this same series, your lordship. Your lordship, at serial number.
ಅದಾಯ್ತು, ಆಮೇಲೆ ನೋಡೋಣ. ಈಗ ಡಿಲೇಗೆ ಏನು ಅಬ್ಜೆಕ್ಷನ್ ಇದೆಯಾ ನಿಮ್ದು? 39 ದಿವಸ ಇದೆ.
ಏನಂದ್ರೆ the subject matter of all the cases are one and the same. ಅದಕ್ಕೋಸ್ಕರ ಜೊತೆಗೆ if it is taken up and it fixed, I have.
ಆಯ್ತು, ಹೋಗ್ಲಿ ಕೊಡಿ, ಲಿಸ್ಟ್ ಕೊಡಿ.
Please, your lordship. Your lordship, serial number 4, serial number 26, serial number 27, serial number 37 and 38, your lordship.
ಈಗ ಆಯ್ತಲ್ಲ, ಯಾರ ಇದ್ರಲ್ಲ ಅವಾಗ?
In the morning session.
ಮಾರ್ನಿಂಗ್ ಯಾರ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರಲ್ಲ?
My colleague, your lordship, and we have taken notice for the same. ಎಲ್ಲ ಮಂಡೇಗೆ ಹಾಕೊಂಡ್ರೆ we will conclude the matter on the same threshold, your lordship.
ಇದೇನು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಏನಿದೆ ರೀ? ಶಶಿಧರ, ಇವ್ರು ಯಾವ್ದು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇಲ್ವಾ? ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಏನಿಲ್ಲ.
But the subject matter is same, one and the same family members, your lordship.
ಆ ಡೇಟ್ ಕೊಟ್ಟು ಸೀರಿಯಲ್ ನಂಬರ್ 4.
Serial number 4. ಅದರಲ್ಲಿ ಡೇಟ್ ಏನು ಕೊಟ್ಟಿಲ್ಲ. 2 weeks ಅಂತ ಇದೆ.
2 weeks ಅಂತಿದೆ. ಕೊಡಿ. The registry is directed to list MFA 6151 of 2022 and MFA number 4944 of 22.
27 also.
MFA 4983 of 22.
Serial number 37 and 38. also.
ಆಮೇಲೆ
Serial number 37 and 38.
MFA
4974.
4974 of 22 and MFA 6062 of 22. ಅಷ್ಟೇನಾ?
ಹೌದು ಸ್ವಾಮಿ.
All these matters on 711. 711. ಹಾಕ್ಬಿಡಿ. ಏನಾರು ಕಂಪ್ಲೇಂಟ್ಸ್ ಆ ರೀತಿ ಏನಾರು ಇದೆಯಾ?
ಸೀರಿಯಲ್ ನಂಬರ್ 27 ಅಲ್ಲಿ ಒಂದು
27 ಅಲ್ಲಿ ಏನಿದೆ?
ರೀಕಾಲಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೆ ಸ್ವಾಮಿ.
ಅದಿದೆ ರೀ, ಅದೆಲ್ಲ ಕನ್ಸಿಡರೇಷನ್ಗೆ ಅವತ್ತು ಮಾಡ್ತೀವಿ. ಬೇರೆ ಏನಾದ್ರು ಕಂಪ್ಲೇಂಟ್ಸ್ ಇದೆಯಾ ಅಂತ ಇಲ್ಲ. ಆಯ್ತು, ಪೋಸ್ಟ್ ಆನ್ 711 ತಗೊಳ್ಳಿ.
Recalling order ಇನ್ನೊಂದು 27 ಅಲ್ಲಿ.
ಅದೆಲ್ಲ ಅವತ್ತು ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ರಿ, ಒಟ್ಟಿಗೆ ಲಿಸ್ಟ್ ಆಗ್ಲಿ ಎಲ್ಲ. 28 ಕೇಶವ್ ಎಂ ದಾತಾರ್, delay of 56 days.
There's a delay of 56 days.
I issue notice on IA number 1 of 24.
Permit me to serve the trial court advocate, my lords.
And also counsel is permitted to serve the copy of the appeal memo and also IAS on the counsel who appears on behalf of the respondents before the trial court.
If a date could be fixed, my lord,
Fix
next
this matter
coming
on
Monday.
711.
Grateful.
PF ಕೊಡಿ ನೀವು.
PF
Notice
ಕೊಡ್ತೀನಿ.
ಹೋಗ್ಲಿ.
ಇವತ್ತು
Then we'll
ಇವತ್ತೇ
see.
ಕಟ್ಬಿಡ್ತೀನಿ. Grateful.
29 agitation.
And directed to pay PF forthwith ಅಂತ ಅಲ್ಲೇ ಹಾಕ್ಬಿಡಿ ಮೇಡಮ್.
For the respondent, my lord, may I seek for a passover, my lord?
But the application is not pressed, my lords, because that is an order which has been questioned separately by way of a writ petition. So IA for dispensation may not survive. Agate.
The counsel for the appellant submits that IA 1 of 24 is not pressed and
Please.
hence dismissed as not pressed.
Please. Matter needs to be heard. not
My lord,
for
may I seek for a passover?
ಆಯ್ತು, pass over.
Great.
30 RB ಸದಾಶಿವಪ್ಪ.
Disobedience of interim order dated 13/10 to 2003.
I think, I think, my lord, these two applications could be considered along with the main. ಇದು already 3 years ಆಗಿದೆ.
ಯಾರು ಅದರ್ ಸೈಡ್
ಯಾರು ಬಂದಿಲ್ಲ, ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿಲ್ಲ ನಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ಗೆ.
ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ಗೆ IA ಹಾಕಿಲ್ವಾ? ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿಲ್ಲ. ನೋಡಿ, IA number 1 of 21 will be considered along with main appeal.
Similarly 2, my lord.
And
Similarly, IA number 2 of 21. ಎರಡಿದೆ.
and so also IA number 2 of 21. ನೋಡಿ, 2003 ಸಾಕು, 20 ವರ್ಷ 21 ವರ್ಷ ಯಾವಾಗ ಬೇಕು ಹೇಳಿ. List this matter on
November 2nd week.
next week 29.
Second week ಅಲ್ಲ.
Second week 2003 ನಮ್ಮ ರೋಸ್ಟರ್ ಅಲ್ಲೇ ಮುಗ್ಸೋಣ ಹೇಳಿ, ಅಸಿಸ್ಟ್ ಮಾಡಿ ಕೋರ್ಟ್ಗೆ. ಸಾಕು, 21 ವರ್ಷ ಇಟ್ಕೊಂಡಿರೋದು ಫಸ್ಟ್ ಅಪೀಲ್.
First week ಅಲ್ಲ.
411 ಆಯ್ತು, 411 ತಗೊಳ್ಳಿ. ಇವತ್ತು ಬಟ್ ಇವತ್ತು ಆರ್ಡರ್ಸಿಗೆ ಬಂದಿದೆ ಅಲ್ವಾ?
31 Rahul S. Reddy. My lords, serial number 31, my lords, the suit is filed by my father, my lords, which came to be dismissed. Subsequently, I have
Now you have filed an application for recalling.
called, my lords. My lords, only for the reason, my lords, when the review petition was filed by the respondent, during the, when the review petition was pending, my father died, my lord. My father died on 23/11/2014, and the review petition came to be allowed and RFA was restored. And RFA came to be allowed on, my lords, 19/2/2015, my lords. Now, my lords, the order.
Madam, this order of dismissal was passed on 25th day of March 2019. Why you did not appear before the court in the previous occasions?
My lords, it was not in my knowledge, my lord. Subsequently, my lords, in between, I have filed
Not in your knowledge means?
My lords, my father has filed a suit and it was pending before the High Court. It was not in my knowledge, my lords. When I have subsequently filed a suit for specific performance, my lords, which is the connected matter here in 31.1, wherein, my lords, when the suit came to be dismissed and the party has come to us, after going through the judgment, we got to know there was already a suit was filed by my father and it
What
was,
happened that suit?
my lord, that also came to be dismissed. I have
That was
challenged.
dismissed against that RFA was filed before this court.
Please, my lords, which
That is RFA number 410 of 2004.
my lords, RFA number
410.
1621 of 2022, my lords, connected matter.
1621, that is
Please.
recent one.
Please.
Ah.
410/2004 was filed by my father, my lords. which came to be dismissed.
The suit filed by your father was dismissed before the trial court.
Please, my lords.
Against that order, father had filed an appeal in RFA number 410/2004, correct?
Please, my lords.
That's what I said. 2004.
Please.
You are not aware of the same.
I was not aware.
When the father passed away,
My lords, again, that was partly allowed RFA, my lords.
RFA was partly allowed.
Please, my lords.
Ah,
Then the
then-
respondent counsel, he has filed a review petition.
Ah,
In 2007, the review petition came to be restored. Now, during the pendency of the review
RFA
petition-
was restored.
Please, my lords, it was
Ah.
restored.
Hmm.
Now, during the pendency of the review petition, my father died in the year 2014, which is 23/11/2014.
Hmm.
And my lords, review was restored on 19/2/2015, my lords. So, there was no notice.
After the death of the father only, review petition was allowed.
My lords.
Whether the review petitioner counsel brought to the notice of the
No,
court
my
or
lords.
not.
No, my lords, there was
No.
no application filed.
Ah.
Subsequently, it was restored.
Hmm.
And RFA came to be dismissed for non-prosecution, my lords. When the RFA was restored, at that point of time also, they have not bring to the knowledge of the court, my lords, that the sole appellant was died.
Yaar other side idara?
My lords, they have filed an objection. He has appeared last time.
Now also filed an IA for bringing LRs.
Please, my lords, in the RFA.
Recalling the application, recalling the order dated 25/3. Sole appellant. Oh, he himself has filed an application to come on record.
Please, my lords.
So, what about in RFA 16/21/22? Why it was connected?
My lords, because that suit is filed by me, my lords, wherein here the 410 is filed by my father. And my lords,
Hello, why this matter is connected?
subject property is the same, my lords.
Subject property is same.
Please.
Chandrasekhar Reddy for R3, ilva? Told. Appellant counsel is present, respondent counsel is absent. If respondent counsel doesn't appear in the next date of hearing, AS will be considered in his absence. List this matter on 7/11.
Much obliged. 32.
IA 1/23 for bringing LRs of deceased R5 on record.
32.3 ಮಿಲಾಟ್.
Notice ಹೋಗಿದ್ಯಾ? 32 ನಲ್ಲಿ? ಹಾ? ನೋಟಿಸ್ ಹೋಯ್ತಾ ಅಂತ ಕೇಳಿದೆ.
ಹೌದು ಸರ್.
ಏನಾಯ್ತು?
ಸರ್ವಿಸ್ ಆಗಿದೆ.
R5 ಗ?
ABCD 5ABCD.
ಇರೋದೇ ABCD ನಾ? R5A ಸರ್ವ್ಡ್, B ಸರ್ವ್ಡ್, C ಸರ್ವ್ಡ್, D ಸರ್ವ್ಡ್. ಹೇಳಿ.
32.3 ಇಲ್ಲಿ my name
2.3 ಆಮೇಲೆ ನೋಡೋಣ. ಫಸ್ಟ್ ಇದನ್ನ ನೋಡೋಣ. Heard on IA 1/23 for bringing LRs of deceased R5 on record. And this court has issued notice against the LRs and LRs have been served and unrepresented. And for the reasons stated in the accompanying application and affidavit, IA 1/23 is allowed permitting to bring the LRs of R5 on record. The appellant counsel is directed to amend the cast title and file a amended cast title. ಒಂದಾಯ್ತು. ನೆಕ್ಸ್ಟ್ ಈಗ IA 3. 10 ನೋಟಿಸ್ ಆಗಿದೆಯಾ?
ABC.
ಸರ್ವಾಗಿದೆ. ಸೇಮ್ IA ನಂಬರ್ ಹಾಕೊಳ್ಳಿ ಮೇಡಮ್, ಅದೇ ಆರ್ಡರ್ ಸೇಮ್. IA ನಂಬರ್ 3/23 ಸೇಮ್. R5 and R10 allowed and amend ಆಯ್ತು. ನೆಕ್ಸ್ಟ್ ಈಗ R4
ಸತ್ತೋಗಿರೋದಕ್ಕೆ
H&I.
ಅದು ಸರ್ವಿಸ್ ಇಲ್ಲ ಸರ್, ಅದಕ್ಕೆ ಅವ್ರು PF ಕೊಡ್ಬೇಕು.
The counsel submits that he has paid the PF to issue notice to R4 H&I and hence issue notice against R4 H&I. ಇಲ್ಲೇನು ಮೊದ್ಲಿಂದ ಒಂದೇನು ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿಲ್ವಲ್ಲ, ಅದೇನು ಹಾಕಿದ್ದೀರಾ? The counsel submits that he has filed the amended cast title and seeks permission to amend the cast title in respect of R1 and R3 and permitted to amend the same. ಅದು ಅಷ್ಟೇ. ಮೇಲಿಂದ ಈಗ R5 R10 ಅದು ಅಮೆಂಡ್ ಮಾಡಿ. ನೆಕ್ಸ್ಟ್ ನೋಡೋಣ. ಕನೆಕ್ಟೆಡ್ ಹೇಳಿ.
32.3 ಅಲ್ಲಿ my name kindly be deleted. ಅದೇನ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆವಾಗ ನಾನು ನಡೆಸಿದ್ದೀನಿ.
32.3 and IA for bringing LRs of deceased R6 on record ಅಂತಿದೆ.
ಅದೇ ನನ್ನ ನೇಮ್ kindly be deleted. ನಾನು ವಕಾಲತ್ ಹಾಕಿಲ್ಲ ಸುಮ್ಮನೆ.
ನೀವು ವಕಾಲತ್ ಹಾಕಿಲ್ಲ?
ಇಲ್ಲ, ನಾನು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ 1990 ಅಪಿಯರ್ ಆಗಿದ್ದೆ, ಅದಕ್ಕೆ ಮೋಸ್ಟ್ಲಿ ಹಾಕಿದ್ದಾರೆ.
ಹಂಗ್ ಮಾಡಲ್ವಲ್ಲ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹಾಕಿದ್ಕು ಇಲ್ಲ ಹಾಕಿದ್ಕು ಬರಲ್ಲ ನೋಡಿ ಮೇಡಮ್.
ಅದೇ ನೋಟಿಸ್ ಟು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ಅಂತ ಮಾಡಿರ್ಬೇಕು, ಅದಕ್ಕೋಸ್ಕರ ತೋರಿಸಿದ್ದಾರೆ. ನಾಟ್ ಅಪಿಯರ್ಡ್.
ಹೆಸರು ಡಿಲೀಟ್ ಮಾಡಿದ್ರೆ ನಾವು ಸರ್ವಿಸ್ ಆಗಿದೆ ಇಲ್ಲ ನೋಡ್ಬೇಕಲ್ಲ R4 and
ಸರ್ವಿಸ್
R9 ಗೆ
ಗೊತ್ತಿಲ್ಲ ಸರ್ ನಮಗೆ ಅದು.
ಅದು ವೆರಿಫೈ ಮಾಡ್ಬೇಕು ನಾವು.
ನಾನು ವಕಾಲತ್ತಂತೂ ಹಾಕಿಲ್ಲ, ನಾನು ಆಫೀಸಲ್ಲೆಲ್ಲ ಚೆಕ್ ಮಾಡಿ
ನಂತರ R5 to R8 4 and 9 10 SG Santama Saruda Vasudev Murthy.
ಅವರು KG Vasudev Murthy also trial court advocate. He passed away recently.
ನೋಟಿಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಸರ್ವ್ ಅಂತ ಮಾಡಿರ್ತೀವಿ ಅಷ್ಟೇನೆ.
ಅದೇ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಆವಾಗ ನಾನು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆ ಕೇಸಲ್ಲಿ ಅಪೇರ್ ಆಗಿದ್ದೆ ಅಂತ. ಫಸ್ಟ್ ಮಾಡಿ ನೋಟಿಸ್ ಆಗೋದು.
R4 ಸತ್ತೋಗಿದ್ದಾರೆ ಅವ್ರು ಎಲ್ಲಾರ್ಸು R9 R10 ಅಂತ.
ಅದೇ
ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು. R6 ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು ಸರ್. ಎಲ್ಲಾರ್ಸ R6 ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು, ಹೋಗಿಲ್ಲ ಅದು.
ಈಗ ಹೋಗಿಲ್ವಾ? ಇಶ್ಯೂ ನೋಟಿಸ್ ಆನ್ IA number 1 of 23 against the LRs of R6. ಅಲ್ಲ ಅವ್ರು ಹೇಳ್ತಾರಲ್ಲ ಅವ್ರ ಹೆಸರನ್ನು ಡಿಲೀಟ್ ಆಗ್ಬೇಕು, ವಕಾಲತ್ ಹಾಕಿಲ್ಲ ಅಂತ. ವಕಾಲತ್ ಇದೆಯಾ?
ವಕಾಲತ್ ಕಾಣಿಸ್ತಿಲ್ಲ.
ಇಲ್ಲ ವಕಾಲತ್
ಅದು
ಹಾಕಿಲ್ಲ.
KG ವಾಸುದೇವ ಮೂರ್ತಿ ಅವರು ನೋಡಿ ಏನೋ ಇಲ್ಲ ಅಂತಲ್ಲ ತೀರ್ಕೊಂಡ.
ಅವ್ರು ಇಲ್ಲ, ಅವರು ಶಿವಮೊಗ್ಗ
ಅವರು ವಕಾಲತ್ ಹಾಕಿದಾರ ಇಲ್ಲ ನೋಡಿ, ಪಾಸ್ ಅವರು ಚೆಕ್ ಮಾಡಿ. ಇಲ್ಲ ಅಂದ್ರೆ ನೀವು ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ಬೇಕಾಗುತ್ತೆ.
My name may be kindly be deleted.
ಒಂದ್ ನಿಮಿಷ ನೋಡ್ಬಿಟ್ಟು ಮಾಡ್ತೀವಿ.
ಆಯ್ತು ಆಯ್ತು.
ವೆರಿಫೈ ಮಾಡ್ರಿ ಪಾಸ್ ಅವರು. ನಿಮ್ ವಕಾಲತ್ ಇದ್ರೆ ಡಿಲೀಟ್ ಮಾಡಕ್ ಬರಲ್ಲ ಅದಕ್ಕೆ.
ವಕಾಲತ್ ಇಲ್ಲ.
33
I represent.
IA 1 of 23 for further orders on further orders. ಯಾಕೆ ಮೊದಲು ಒಂದು ಆರ್ಡರ್ ಆಗಿದೆ ಇದ್ರ ಮೇಲೆ IA ಮೇಲೆ.
ಏನು ಆಗಿಲ್ಲ ಅದ್ರಲ್ಲಿ.
ಫರ್ದರ್ ಆರ್ಡರ್ಸ್
ಅಂತ ಬಂದಿದೆ.
724 days ಡಿಲೇ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದಿರಾ ನೀವು?
ಇಲ್ಲ ಅವ್ರೇನ್ ಹಾಕಿಲ್ಲ.
ಮ್ಯಾಟರ್ ಸೆಟ್ಲ್ ಆಗ್ಬಿಟ್ಟಿದೆ ಸ್ವಾಮಿ. Appeal itself will not be made up.
Both appeals have to be dismissed as said.
ಆಲ್ರೆಡಿ ಸೆಟ್ಲ್ ಆಗಿದೆಯಾ?
ಹೌದು
ಆಗಿದೆ.
ಕ್ರಾಸ್ ಅಪೀಲ್ ಐ ಆಮ್ ವಿಡ್ರಾಯಿಂಗ್.
ತೊಗೊಳ್ಳಿ ಅಪಲೆಂಟ್ ತೊಗೊಳ್ಳಿ. ಕೌನ್ಸಿಲ್ ಫಾರ್ ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಟರ್ files memo stating that already matter has been settled
ನಮ್ದು
and
ತಗೋಬೇಕು.
seeks permission of this court to
Dismiss as settled out of court.
withdraw the cross appeal and hence permitted to withdraw in terms of the memo. The appellant counsel also
ನಾನು
submitted
file
that
ಮಾಡ್ತೀನಿ.
the matter has been settled and may be permitted to withdraw the appeal. Memo kodi and
ಕೊಡ್ತೀನಿ.
hence permitted to withdraw. RFA 144 of 2008. Next 34.
34 ಅಲ್ಲಿ is put for permanent injunction.
Hmm.
During the suit was dismissed.
Ah.
During the pendency of the appeal,
Hmm.
the sole respondent, who is a defendant, died.
Ah.
We filed LR application.
Hmm.
I filed objections, whether this, if the defendant dies,
Hmm.
whether suit dies along with the defendant in a suit for permanent injunction.
ಪರ್ಮನೆಂಟ್ ಇಂಜಂಕ್ಷನ್ ಆದ್ರೆ ಅವ್ನ್ ಮಾತ್ರ ಇಂಟರ್ಫಿಯರ್ ಆಗ್ತಾ ಇದ್ದ ಅವನ ಮೇಲೆ ಹೋಗುತ್ತೆ. How you can maintain an IA for bringing LRs?
That is the only question.
Ah.
There is a
Now,
judgment of
whether
this.
in case if again they are LRs are interfering with your possession, you can file a
Fresh suit.
on fresh suit on recurring cause of action ಅಷ್ಟೇ.
Still judgment of this court.
ಏನು
Justice ಸಂದೇಹ ಕೊಟ್ಟಿರೋದು ಒಂದು ಇದೆಯಂತೆ ನನ್ನ ಹತ್ರ ಇಲ್ಲ ಕಾಪಿ.
ಅಂದ್ರೆ ಕಂಟಿನ್ಯೂ ಮಾಡಬಹುದು ಅಂತ.
ಮಾಡಬಹುದು ಅಂತಿದೆ.
ಎರಡೂ ತರನೂ ಇದೆ.
ಹೌದು ಅಷ್ಟೇ.
ಏನ್ ಮಾಡ್ತೀರಿ ಹೇಳಿ, ಏನ್ ಮಾಡ್ಬೇಕು?
ಅಲೌ ಮಾಡಿದ್ರೆ ನೋಡಿ ಮೆರಿಟ್ ಮೇಲೆ ಏನಾದ್ರು IA may be allowed. I represent the appellant.
ಅಲ್ಲ ಬಟ್ ನೀವು ಅದೇನೋ ಜಜ್ಮೆಂಟ್ ಇದೆ ಅಂತಿರಲ್ಲ ನೋಡಿ ಫಸ್ಟ್.
ಅಲ್ಲ ನೋಡ್ಬಿಟ್ಟು
ಇದ್ರ ಬೇರೆ ಡಿಲೇ ಇದೆ 884 days.
ಹೌದು
ತಗೊಳ್ಳಿ ಅಪರೆಂಟ್ ಕೌನ್ಸಿಲ್ 6 time ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 7/11 ಅಷ್ಟೊಳಗೆ ವೆರಿಫೈ ಮಾಡಿ.
ನೋಟಿಸ್
ನಾವು ಯಾವ್ದೋ ಒಂದು ಜಸ್ಟಿಸ್ ಬಾಲಕೃಷ್ಣ ಶಾಸ್ತ್ರಿ ಒಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರು ಇನ್ ಎ ಕೇಸ್ ಆಫ್ ಮೋಸ್ಟ್ಲಿ ನಮ್ಮ ಮುಂದೆ ಡಿಸ್ಪೋಸ್ ಆಗ್ಲಿಲ್ಲ ಅನ್ಸುತ್ತೆ. ಸೇಮ್ ಸಿಮಿಲರ್ ಸೆಟ್ ಆಫ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಸೂಟ್ ಫಾರ್ ಇಂಜಂಕ್ಷನ್ ಇದ್ದಾಗ.
ಬೇರೆ ರೀತಿ ಬರ್ತಿದ್ದಾರೆ.
ಹಾ
ಧಾರವಾಡ ಬೆಂಚ್.
ಹಾ ಅದು ಏನೋ ಬೇರೆ ಬೇರೆ ಜಡ್ಜ್ಮೆಂಟ್ ಮೇಲೆ ಮಾಡಿರ್ಬೇಕು. ನನ್ ಮುಂದೆನೆ ಸೇಮ್ ಸಿಮಿಲರ್ ಮ್ಯಾಟರ್ ಬಂತು ಲಾಸ್ಟ್ ಟೈಮ್ ಬಿಫೋರ್ ಗೋಯಿಂಗ್ ಟು ಬೆಂಚ್. ಬಟ್ ಅದ್ರ ಮೇಲೆ ಡಿಸಿಷನ್ ತಗೊಂಡ ಇಲ್ಲ ಗೊತ್ತಿಲ್ಲ ನನ್ಗೆ. ನೋಡಿ ನಾನು ತಗೊಂಡ ಡಿಸಿಷನ್. ಅದೇನೋ ಬಂತು 2-3 ದಿವಸ ಡೇಟ್ ಕೊಟ್ಟೆ ನಾನು ಬಾಲಕೃಷ್ಣ ಶಾಸ್ತ್ರಿ ಅವ್ರಿಗೆ ಹೇಳಿದೆ ಇಟ್ ವಿಲ್ ನಾಟ್ ಕಂಟಿನ್ಯೂ ಹೇಗೆ ಮಾಡುತ್ತೆ ಅಂತ. ಅವ್ರು ಯಾವ್ದೋ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಕೋರ್ಟ್ ಮಾಡಿದ್ದು ಏನೋ ಇತ್ತು ನನಗೆ ನೆನಪಿದೆ. ನೋಡಿ ಒಂದು ಏನೋ ಆರ್ಡರ್ ಆಗಿದೆ ಅಂತ. ನೋಡಿ ನೀವು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿ ಯಾವ್ದೇ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ತಗೊಬನ್ನಿ. ದೆನ್ ವಿಲ್ ಟೇಕ್ ಎ ಡಿಸಿಷನ್. ಹಾ ಇಲ್ಲ ಲಾರ್ಜರ್ ಬೆಂಚ್ಗೆ ರೆಫರ್ ಮಾಡೋಣ. ಇದೇನು ಇದು ಸೇಮಾ?
ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್.
ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಅಲೋ ಮಾಡೋಣ. Early hearing allow ಮಾಡೋಣ ಅಂದೆ. Heard on IA number 2 of 24 for early hearing and for the reason stated in the accompanying application and affidavit, IA is allowed. ಈ final hearing ಆಯ್ತು, list the matter for final hearing on 7/11.
My request on 12th.
12 ಆಯ್ತು, 12/11.
Petition matter.
36.
PB Raju.
ಒಂದ್ 2 ದಿವಸ ಟೈಮ್ ಕೊಡ್ಸಿ. 2 days. Friday ಮಾಡ್ತೀನಿ.
Appellant counsel seeks time and counsel for the respondent present list this matter next week ಅಲ್ಲಿ ಕೊಡ್ರಿ ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್. 30/10 please.
37, 38, adjourn 39. HP Leela.
37 urgent. ಆಯ್ತು. 38 ಅಲ್ಲ ಆಯ್ತು ಆಯ್ತಲ್ಲ. 39 ಹೇಳಿ.
Yes, you are asking what
Kalyan R. Memo along with written statement with documents filed by advocate for appellant.
Yes. The plaintiff, that is the respondent here in your arson, has filed a suit for.
IFI is allowed. Not to alienate irಬೇಕು.
Not to alienate. What I am submitting before the honorable.
Last time auto sheet ಕೊಡಿ. ಬಂದ್ರಲ್ಲ.
On the basis of the alleged agreement, your
Lord, seek for 2 days accommodation to file statement of objection to the application.
Statement of objections ಯಾವ್ದಕ್ಕೆ?
IA ಹಾಕಿದ್ದಾರೆ.
IA ಬೇಕಾಗಿಲ್ಲ, ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಹಿಯರ್ ಮಾಡೋಣ. ಮೈನ್ ಅಪೀಲ್. IAಗ್ ಒಂದ್ಸರಿ, ಮೈನ್ ಅಪೀಲ್ ಬೇರೆ ಒಂದ್ಸಲಿ, ಮಿಸ್ಲೇನಿಯಸ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಬೇಕಾಗಿಲ್ಲ.
Date may kindly be fixed, I'll.
Counsel for the respondent.
Date may be fixed, your honor.
Fix ಮಾಡ್ತಾ ಇದೀನಿ. Counsel for the respondent seeks time to argue on merits and counsel for the appellant also present and see submits that the date may be fixed and hence list this matter on ಯಾವಾಗ ಮೇಡಮ್? 7/11
please. That's all.
40. P Narayanappa.
Narayanappa, VB Shivkumar. A1 was dismissed.
2 days time, my lord. 2 days time.
ಅಲ್ಲ ರೀ, ನಾವ್ ಎಲ್ಲ ಓದ್ಕೊ ಬಂದಿರ್ತೀವಿ ಅಡ್ಮಿಷನ್ ಮ್ಯಾಟರ್ಸ್. ಬೆಳಗ್ಗೆಯಿಂದ ನೋಡಿದ್ರೆ ಎಲ್ಲರೂ ಟೈಮ್ ಕೇಳ್ತಾರೆ. ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ, ನಾ ಇನ್ಮೇಲೆ ಫೈಲ ಓದೋದಿಲ್ಲ. ನೋಡಿ, ಅಡ್ಮಿಷನ್ ಮ್ಯಾಟ್ರು 36 ಓದ್ಕೊ ಬಂದಿದ್ದೆ, 37 ಓದ್ಕೊ ಬಂದಿದ್ದೆ, 38, 39 ಎಲ್ಲ ಅಡ್ಮಿಷನ್ ಮ್ಯಾಟರ್ಸ್ ಓದ್ಕೊಂಡು ಬಂದಿದ್ದೆ. ಬಂದವರೆಲ್ಲ ಟೈಮ್ ಕೇಳೋದು. ಅದಕ್ಕೆ ನಾನು ಮೊದ್ಲೇ ಹಾಕ್ಸ್ಬಿಟ್ಟಿರ್ತೀನಿ, ಅಡ್ವೊಕೇಟ್ಸ್ ನೀಡ್ ನಾಟ್ ಸೀಕ್ ಎನಿ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಅಂತ. ಇಲ್ವಾ? ಮೊದ್ಲೇ ಹಾಕಿಲ್ವಾ? Advocates are requested not to seek any adjournment ಅಂತ. How many times court has to read the papers? Admission ಗೆ ಬಂದಾಗ್ಲೂ ಅಸಿಸ್ಟ್ ಮಾಡಲ್ಲ ಕೋರ್ಟ್ಗೆ ಅಂದ್ರೆ ಏನ್ರಿ? ಏನ್ ಹೇಳಿ, ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಏನ್ ನಿಮ್ಗೆ ಈಗ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಕ್ಕೆ? ಸೀನಿಯರ್ ಬೇಕಾಗಿಲ್ಲ ನನ್ನ ಕೋರ್ಟಿಗೆ ಜೂನಿಯರ್ ಹೇಳಿದ್ರು ನಡೆಯುತ್ತೆ. ನಾನ್ ಮುಖ ನೋಡಿ ಮಣೆ ಹಾಕಲ್ಲ.
2 days.
You assist the court, that's all. You assist the court. ಓದಿದ್ರೆ ಇಲ್ಲ ಹೋಗ್ಲಿ ಆರ್ಡರ್ನ. ಓದಿಲ್ಲ, ಸೀನಿಯರ್ ಇಲ್ಲ ಅಂತ ನೀವು ಓದ್ಲಿಲ್ಲ. ನಾವು ಓದ್ಕೊಬರ್ಬೇಕು, ನೀವು ಓದಕ್ ರೆಡಿ ಇಲ್ಲ. ಏನ್ರಿ? dismissed on the ground that you have not made all the family members as parties to the proceedings. And also earlier, sale deed also executed, and even defendant number 3 and 4 have also executed confirmation deed, and plaintiff number 3 and 4 have also executed the confirmation deed. Nothing on record, dismissed.
2 days, Monday.
The appellant counsel seeks time. Counsel for respondent is absent. List this matter on 7/11.
41.
For the respondent in
Shetty B.
I pay for the.
order 9 rule 13, my lord.
Dismissed.
My lords,
He also rejected.
my lord, the appellant is the defendant, my lords, who filed miscellaneous petition seeking restoration of the suit. I mean, setting aside the judgment and decree passed by the trial court and to permit her to proceed with the above case. My lord, it is not in dispute, my lord, the respondent number 1 on filing the suit, my lord, was number 5996 of 1998. The appellant has entered appearance also, my lords. She has filed the return statement also. My lord, subsequently, my lords, please, the issues are being framed by the honorable trial court. After framing of the issues and on adducing evidence on the part of the plaintiff side, my lord, the appellant being the defendant number 1, she has not cross-examined. Then subsequently, my lords, please, the honorable trial court is pleased to decree the suit by a judgment and decree dated 29th August 2009, my lord. My lord, thereafter, it is also not in dispute on record, my lord. An execution petition came to be filed by the plaintiff in execution petition number 1716 of 2012. My lords, please, in 1716 of 2012 also, my lord, the appellant has engaged the services of a counsel. Due to lack of innocence, I can say, my lord, she is a widow. My lord, in fact, at the time of filing of the suit, she had her husband. He met with an accident and he was admitted in the Nimans hospital and subsequently he passed away. In meantime, judgment also be passed. He was alive, my lord. He was in the treatment and hospitalized, but he was alive. My lord, thereafter, the miscellaneous petition came to
2009 and 10 after the judgment.
After the judgment.
Whether how it will be a reason for setting aside the judgment.
My
and
lord, the
decree.
reason is that a widow and innocent, she did
Maybe
not
in-
know
widow,
legal
But
consequences.
at the time of
Yes,
passing
I
a
understood,
decree,
my lord. It has,
husband was alive.
no, but he was due to accident. he was.
Accident agide yavaga?
Idru Swami. Illa, that is subsequent date. Then I verified also.
Accident
Yes,
subsequent to
subsequent
the.
date, my lord.
judgment and
I
decree.
cannot say that it is during pendency. My lord, the dates are, it's correct also. The only problem is that, my lord, only when on 9/2/2015, a delivery warrant has come to our door for delivery of the possession of the property. She has been alerted, then she has filed the miscellaneous petition immediately on 23/2/2015. There is a delay, my lords, please. My humble submission is that the claim on the property of both the parties with regard to the title, my lord, it is a suit for declaration. My lord, since in view of the fact that it is a suit for declaration, the title of the parties, my lord, an opportunity on any terms, my lord, I can understand there is an inconvenience is caused to the plaintiff. An opportunity may be given by imposing a cost and also giving an opportunity by fixing any short time for conclusion of the evidence. Anyhow, evidence of the plaintiff was already concluded therein. Only the cross-examination and the defense evidence would remain. If my lord pleases, an opportunity as the title of the property is involved in the case, my lords, please. Yes, there is mistake on the part of the appellant. I concede due to innocence and without lack of knowledge regarding the legal consequences. And both the parties are claiming a title over the property, my lords, please. Because the respondent's claim is that the site is allotted to her in the year 1975. And the appellant's claim is that the site was allotted in favor of one Pushpalata and she has transferred the same in favor of another person on Bairamma, and thereafter house is constructed. And admittedly, as could be seen from the even plaintiff governments and also according to the plaintiff, the defendant is trespassed. It is of her case, my lord. Please. It is not permissive position and all. So these circumstances, my lord, kindly consider an opportunity may be given to the party. That much only I can say. I can understand very well on looking into the documents also. there are latches could be seen on the part of the party, but due to the innocence, she has no knowledge with regard to the consequences of the matter. So my humble submission may kindly consider the request. And position as on today concerned, my lord, is continued with the appellant only, man.
Yes,
On the execution petition was filed in 2010.
2010.
10.
Ah,
Then I filed an application for appointment of commissioner.
hmm,
And that notice was issued
hmm.
to the JDR on 13/8/2012.
13/8.
2012.
Ah,
They appeared,
Served
and they appeared to
represented
advocate.
through counsel also.
Oh, sir.
Ah,
After 3 years,
filed the miscellaneous petition.
miscellaneous. Order 9 Rule 13, my lord.
Hmm,
See, in the initial stage when notice been served, ಎಸ್ ಪಾರ್ಟಿ ಆಯ್ತು ಅದನ್ನು ಒಪ್ಕೊಂತೀನಿ. 25 ವರ್ಷದಿಂದ ಕೇಸ್ ನಡೆಸ್ತಾ ಇದ್ದೀನಿ ಸ್ವಾಮಿ.
hmm,
ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿದ್ದಾರೆ.
hmm,
ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿ ಅವ್ರು ಇನ್ನೊಬ್ಬರು ಪಾರ್ಟಿನೂ ಬಂದಿದ್ರು ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಕ್ಕೆ,
hmm,
ಅವ್ರನ್ನೂ ಅಲೋ ಮಾಡಿಸ್ದೆ.
hmm,
ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಫೈಲ್ ಮಾಡಿದ್ರು.
hmm,
Lot of opportunity was given for the cross examination.
hmm,
Then the suit was declared in 2009.
hmm,
After 10 years,
hmm,
2010 I filed a miscellaneous.
hmm,
2012 was been served.
hmm.
2015 ಬಂದು ಈ ತರ ಹೇಳಿ ಆಮೇಲೆ ಸಿಂಪತಿ ಇತ್ತು, ನಂಗೆ ಹಂಗಾಗೋಯ್ತು. ಇನ್ನೋಸೆನ್ಸ್ ಬರಲ್ಲ ಸುಂದ. Order 9 Rule 13 sufficient cause has to be shown. Order 9 Rule 13 ಬೇರೆ ನಾನು ಇನ್ಶಿಯಲ್ ಸ್ಟೇಜ್ ಅಲ್ಲೇ ಎಸ್ ಪಾರ್ಟಿ ಆಗಿ
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲೂ ಕೂಡ ನೋಟಿಸ್ ಸರ್ವ್ ಆದ್ಮೇಲೆ
ಆಗಿದೆ ಸ್ವಾಮಿ. ಐ ಆಮ್ ನಾಟ್, ಐ ಹಾವ್ ಸ್ಟೇಟೆಡ್ ಇನ್ ಮೈ ಅಪೀಲ್.
ಕೂಡ filed ಅದು
ಆಗಿದೆ, ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ, ಮನೆಯಲ್ಲಿ ಇದ್ದು ಬಿಟ್ಟಿದ್ದಾರೆ. ವಕಾಲತ್ ಹಾಕಿ ಇಲ್ಲ. I have narrated all the facts in the appeal memo also. I am not here to just to make some
ಇದನ್ನು
false
evidence
submission
ಆಗಿದೆ.
and to seek the relief.
ಎವಿಡೆನ್ಸ್ ಆಗಿದೆ, ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಆಮೇಲೆ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್. ಅಲ್ಲೂ 10 ವರ್ಷ ಆಗಿದೆ ಸ್ವಾಮಿ ಮಿಸ್ಲೇನಿಯಸ್.
Heard the appellant counsel and also the counsel appearing for the respondent. This miscellaneous first appeal is filed, being agreed by the
ಸರ್ ನಾನು ಸ್ವಲ್ಪ ಕೂತ್ಕೊಂತೀನಿ ಕಾಲ.
dismissal of the miscellaneous petition filed under Order 9 Rule 13 of CPC and also rejection of application filed under Section 5 of Limitation Act. The main contention of the petitioner counsel that appellant counsel that trial court committed an error in dismissing the petition filed by invoking Order 9 Rule 13 and failed to condone the delay. And counsel also submits that though suit was decreed in 2009 and immediately the husband of the appellant met with an accident and he also died in 2010. The counsel also submits that when the execution petition was filed and came to know about the same and immediately filed the petition in miscellaneous number 142 of 2015. And trial court also given an opportunity to adduce evidence and petition appellant was examined as PW1 and document exhibit P1 to 3 are produced and medical records are also produced before the court, and in spite of it not considered the same, and exhibit P1 and P2 are the certified copy of the judgment and decree passed in original suit, and particularly exhibit P3 is the medical records, and ought to have appreciated the document of exhibit P3 medical treatment file of Niman's Hospital. The counsel also submits that the appellant is a widow and she could not file the miscellaneous immediately, and lenience can be considered, and even any terms judgment and decree may be set aside, and an opportunity has to be given to the appellant to contest the original suit OS number 5996 of 1998, and hence prayed this court to set aside the order. For contra, the counsel appearing for the respondent would vehemently contend that suit is of the year 1998. And also the appellant husband appeared and filed the written statement and issues were framed and evidence also recorded and opportunity was given, and even after 11 years suit was decreed. And thereafter also execution petition was filed in 2010. And application is also filed for appointment of commissioner and notice also issued against the appellant, and the same was served in 2012, that is on 13/8/2012 itself. And in spite of it, not filed any petition and petition invoking Order 9 Rule 13, and the petition was filed in 2015 only. The council would submit that the trial court has considered all this material on record while appreciating the evidence, and rightly comes to the conclusion that not made out any sufficient cause to invoke Order 9 Rule 13. Having heard the appellant counsel and also the counsel appearing for the respondent, it is not in dispute that suit was filed in year 1998, and also not in dispute that the appellant also appeared and filed written statement, and thereafter not contested the matter, and also the judgment and decree was passed in the year 2009 itself. The records also discloses that Exhibit P3 discloses that husband was met with an accident. Yeah, yearly 1999. 1999. And he died in 2010.
After.
Exhibit P3 medical reports produced by the petitioner are pertaining to year 1999. And rightly appreciated that
Is no more ಅನ್ನೋದಕ್ಕೆ
these
not for-
documents will not helpful to the appellant to seek for even lenience. It has to be noted that he died in 2010, but even prior to the death, judgment and decree was passed in 2009 itself. That is on 29/8/2009. And thereafter also not taken any steps. And even the appellant not dispute the fact that in execution petition also notice was served on 13/8/2012. And miscellaneous petition was filed in 2015. That is on 23/2/2015.
23 to 2015.
23/2/2015. And no sufficient cause was shown for approaching the court invoking Order 9 Rule 13. The trial court also, while rejecting the petition filed under Order 9 Rule 13, also in paragraph number 11 taken note of invoking of Order 9 Rule 13. And so also decree was passed in 2009 itself. And the miscellaneous petition was filed in 2015, and the appellant also having the knowledge about the judgment and decree in 2012 itself, when the notice was served in the execution petition, but not taken any steps. And having taken note of these materials on record, I do not find any ground to set aside the order of the trial court, and trial court also given the reason for not filing the miscellaneous immediately. In paragraph number 17 also taken note of the appellant put appearance in the execution petition through her counsel on 13/8/2012. And when such being the case, the detailed order has been passed by the trial court and even considered Exhibit P3 medical records pertaining to the year 1999. And Exhibit P3 also cannot come to the aid of the appellant. When such being the case, when the trial court passed the reasoned order appreciating both oral and documentary evidence available on record, and appellant not made out any ground to set aside the order. The submission with regard to even any terms order may be set aside cannot be accepted, and suit was filed in 1998, and the same was decreed in 2009 after long period, and also not shown any interest, having the knowledge also, and hence question of setting aside the order on terms also doesn't arise, and hence I do not find any ground to set aside the same. In view of the discussions made up, I pass the following order. Appeal is dismissed.
42. Prakash B.N. Punit C.
And for the appellant. Lord, appeal by defendants number 6 and 7. Suit is one for a declaration.
Why
And
there are two appeals?
Two appeals, my lord. One application was filed by the plaintiff for injunction. Another application filed by defendant number 7 for injunction. Both applications, the plaintiff's application is allowed and defendant's application is dismissed.
Dismissed.
Yes, my lord. Kindly take, my lord, MFA 2991 of 2024. Second appeal.
Whether the others have been served or not.
Lord, plaintiffs have been represented. I have filed
Plaintiff?
wakal.
plaintiffs have filed wakalat and I've represented, I've also.
Plaintiff,
Plaintiffs.
ಬೇರೆಯವರೆಲ್ಲ ಯಾರು?
ಬೇರೆಯವರೆಲ್ಲ they are
There are
other
the
defendants.
other, who have sold the property. to
ಆಲ್ರೆಡಿ
me.
ಡಿಸ್ಪೆನ್ಸ್ ಆಗಿದೆಯಲ್ಲ?
ಹೌದು, ಹೌದು. Who have sold the property to me.
ಆಯ್ತು ಹೇಳಿ.
My lord, the property, according to the defendant number 6 and 7, property belong to one Dodda Giriyappa, son of Kani Girigowda. My lord, according to the plaintiff, it belonged to Dodda Giriyappa, son of Venkate Gowda.
And father name is different.
The father name is different. My lord, that property, according to the plaintiff, was sold to one Kuri Tirumale Gowda. And
Sold to whom?
sold by, according to them, Dodda Giriyappa, son of Venkate Gowda, from whom they are claiming title or tracing title, was sold to one Kuri Tirumale Gowda. My lord, they are claiming as legal heirs of Kuri Tirumalaya. My lord, I have purchased the property.
This sale made by Dodda Giriyappa in which year?
1952.
1952.
Yes, my lord. My lord, I am tracing the title through Dodda Giriyappa, son of Kani Girigowda. And who died, whose legal heirs are defendant number 1 to 5. They sold the property in favor of defendant number 6 under the sale deed of 14/2/2022.
14?
To 2022. And then it was gifted to defendant number 7 by defendant number 6 on 24/3/2022. Record of rights are standing in my name. But the trial court.
What is the extent of land?
Extent of land is, my lord, 1 acre.
2 acre.
Sorry, 2
17
acres.
17 guntas.
17 guntas.
Measurement also no dispute.
No dispute.
2 acres.
Only I am disputing the boundary which is shown in the sale deed. But the trial court dismisses allows the application of the plaintiff only on the ground that 1952 sale deed is in favor of Kuri Tirumalaya, and insofar as the plaintiff's status as legal heirs will have to be decided in the trial. Therefore, trial court grants the injunction restraining me from interfering with my possession. Trial court failed to consider that the record of rights standing in my name and I am in possession of the property. So therefore, I am before this court. Now kindly see the order of
What are the documents produced by the plaintiff?
Plaintiff 1 1952 sale deed and then 1 1933 Tippani copy. And the RTC is produced by me, produced by them. RTC shows Kuri Tirumalaya is in possession of the property earlier, prior to my purchase. And there is nothing on record to show, establish that they are the legal heirs of that Kuri Tirumalaya. But trial court says it has to be decided in trial. Now I am in possession of the property by virtue of the interim order granted in their favor.
ಆಯ್ತು, ನಿಮ್ಮ ದೊಡ್ಡಗಿರಿ ಗೌಡ.
Yes, brother.
ದೊಡ್ಡಗಿರಿಯಪ್ಪ
Yes,
son of, ಕಾಣಿಗಿರಿ.
Kanigiri Gowda.
ಕಾಣಿಗಿರಿ ಗೌಡ. How he got the property?
Malad, from 1962 onwards, RTC is standing in the name of Doddagiriyappa.
What is the title?
There is no other document. Malad. There is no other document. RTC stands in the name of Doddagiriyappa continuously till I purchase the property.
Because Doddagiriyappa, son of Venkatagiri Gowda, Venkate Gowda, purchased in the year 1952.
Yes, Malad, that is what their contention, and only except 1952 document.
There is a sale deed. Title is also
Malad, I
there.
agree, Malad. But except 1950.
That's why I asked you, what is the basis for you for transfer of property in favor of this Doddagiriyappa, son of Kanigiri Gowda? What is the basis?
Basis is, Malad, record of rights. From
Only
52
RTC.
onwards,
Only RTC.
record of rights continues in his name. Therefore, on that basis, the father purchased the property in
That itself is the crux of the
22. But my lord, the question is
That
whether,
itself is the crux of the issue.
my lord, whether Doddagiriyappa, son of Venkate Gowda, or Doddagiriyappa, son of Kani Girigowda,
They are showing better title of the year.
my lord, but
1952.
possession continues to be with Doddagiriyappa, son of Kani Girigowda.
How a possession came to you?
Possession, my lord, that's why I said, my lord, long standing entry in the revenue record.
ನೀವು Entry revenue records RTC ನಲ್ಲಿ ಹೆಸರು change ಮಾಡಿಸ್ಕೊಬಿಟ್ಟು ಬೇರೆ ಪ್ರಾಪರ್ಟಿ
Although if they don't make a claim till 2023, my lord, till the filing of the suit 22.
RTC ನಲ್ಲಿ ಏನಿದೆ ರೀ?
ಅಲ್ಲ, my lord,
As of the date of filing of suit.
may I submit the facts, please, my lord? I'll produce this document. Lord, may I submit few facts, please, my lord?
But identity of the property is not in dispute.
Identity
Both
of the
both are
property is
claiming
not,
the very same property.
it is not in dispute, please,
Ah.
my lord. The
Ah.
only issue and only crux of the case is whether who is Doddagiriyappa alias Doddagiri Gowda alias Doddagiriyappa, son of Dodda Venkate Gowda, and Doddagiriyappa, son of Kanigiri Gowda. My lord, I trace my title from Doddagiriyappa alias son of Dodda Venkate Gowda. Kindly peruse my tippani, please, my lord, which is of the year 1933 at page number 16. In order to establish that the property vests with Doddagiriyappa, son of Dodda Venkate Gowda. Page 16. My lord, Ali,
That is
survey
the-
number 124.
idea, you would have verified the title.
Yes, my lord. I have got a title report.
G3 before purchasing the property.
My lord, I have got a title report. I furnished it also.
Ah.
Please see, my lord. If my lord is pleased to bear with me for a moment. My lord, there is one title report of lawyer Louis Braganza at ink page 157. That is with reference to this property.
Prima facie,
Yes, ma'am.
material shows that she is the daughter of
So that's a
Appayan.
claim. My lord, I'm not even, because it's not within me to dispute their family tree at this stage. It will be unfair for me to say it.
Yes.
But I, my lord, as a bona fide purchaser, I take a title report at ink page 157.
Bona fide purchaser must verify the title and then.
I've got a title report, my lord.
Maybe
From a,
title report is there. Title report cannot be a basis.
my lord, a lawyer would tell me, my lord, who are the children based on the title documents furnished.
ಕೊಡ್ಬೇಕಲ್ಲ title report na.
My lord, please see, my lord, they have narrated the entire flow. And after that, my lord is pleased to see ink page 161, another title report from another eminent lawyer. Two lawyers have given a proper documented title report after going through the document. And thereafter, my lord, this is an apartment building which is
The
complete.
advocate before giving the report would have insisted the G3.
Please, my lord.
Advocate before giving the report,
Yes, my lord.
title report.
Yes.
Would have insisted for G3.
Genealogical tree. Yes. My lord, the genealogical tree which I have been furnished with would not show the name of the plaintiff, which I produced.
Now the relief is not to alienate, that's all. I will give direction to dispose of the matter within a one year.
My lord, I just want to submit one more aspect for my lord's kind consideration. My lord, I filed on 4/6/24. I filed a memo because this matter was being heard earlier, and the additional documents. Please see, my lord, the memo. The same plaintiff files one more suit represented by her GPA holder. And in this suit, my lord is pleased to see the memo, page 59, para 9, where she again.
Memo dated?
4/6/24.
No such memo. ಏನಾರು ಇದೆಯಾ madam?
4/6/24, ma'am. You got a copy?
ಇಷ್ಟೇ ಇರೋದು records? ಇಲ್ವಲ್ಲ ಯಾವುದು? 4/6/24 memo. Only 39/24 is available, on one more is 21.
I have one more copy, ma'am.
ಯಾವ ಡೇಟ್ ನೋಡಿ? 4/6.
4/6/24.
ಇದೆ ಕೋರ್ಟಿಗೆ ಫೈಲ್ ಮಾಡೋದು ಯಾವಾಗ? ಇಲ್ವಲ್ಲ? That is 13/9.
13/9.
ಅವ್ರದ್ರಲ್ಲಿ ಎಲ್ಲಿದೆ? ಸೀಲ್ ಎಲ್ಲಿದೆ?
Date of filing is.
Where is the seal? For having produced before the court.
You got a seal.
Maybe same with you only.
File. I'm sorry, my learned colleague doesn't have it here. This is the same copy, my lord. If my lord requires, I'll file a fresh copy.
Then you have to serve the copy of these documents on the other side also.
But they have not appeared on the last day. I'll serve them a copy. Why I'm saying this, the first suit they file against 45 people. Second suit, the defendant, that is Mayana's children, are the same. They file it against 75 people. And in
They are also the subsequent purchasers.
yes, now
Here also the apartment is constructed and
different properties, my lord, it nearly covers half of Bangalore. Every schedule they have brought.
Hmm.
Now here, I just want to show conduct.
Hmm.
Para 9 of that plaint,
Hmm.
just for a moment, my lord is pleased to see,
Hmm.
at page 59.
Hmm.
It is submitted in the year, I'll share it with my learned friend.
You first furnish copy on the other
Yes,
side.
yes, he
then-
must be aware. Are you the plaintiff lawyer in that case?
No, counsel, once you files this much.
I will serve another.
First you serve on the other side and then I will consider. There cannot be any half.
I will. No doubt.
Half-hearted.
No.
Hmm.
I understand.
First you serve the copy on the other side.
Yes, I will do that.
Let him also meet your case.
Yes, ma'am.
Without serving the copy. how
Next
can-
date, my lord.
Told.
7th, my lord.
Heard in part. The counsel for the appellant produced list of documents, serial number 1 to 5. And counsel for the appellant is directed to serve the copy of this list of documents on the other side. And list this matter on 7th of November.
Grateful.
Manjula.
For respondent in this case, Manoj.
Bharatpudi, madam. Documents are filed in the court. Anta.
It will be.
Yes, 57.
I appear for appellant in this case, my lord.
Yes, madam.
This is, my lord, death due to accident by in the train, my lord.
Why it was rejected?
It was rejected, my lord, on the ground that, my lord, the time mentioned in the claim petition of the time of the accident is differing, my lord. But actually there was no person accompanying the deceased, my lord. The time written is, my lord, as it is shown in the medical documents. Only on that ground, my lord, my claim petition is rejected.
Where is the reasoning? Based on available facts and evidence about the train and location timing at alleged incident spot does not match with timings mentioned in the application. The incident timing in application is some 4 hours after the passage
I have written in the,
of train at Holenarsipura.
I mentioned
The
that
applicant counsel maintained that the time of admission to hospital has been mentioned in the application as timing of incident, but no one knows the timing of the incident.
because there
Facts
was
of the-
nobody accompanied him, my lord. His parents, my lord, who were residing in Haveri district, my lord, they received a phone call that from the railway police that, my lord, accident occurred and he is hospitalized in Hasna. Thereafter, they came to know about the incident. In the FIR, my lord, at A1, my lord, annexure A1, it clearly shows that, my lord. Last me kindly see annexure A1, my lord.
But
It
go to
is-
page number 22, you have examined one witness, AW3, Chandrappa,
Yes, my
who
lord.
claimed to have witnessed the purchasing of the ticket by the deceased
Yes, my lord.
and who is said to have travelled with the deceased.
Deceased.
Stated that boy died 3 days later than travel date. And subsequently, as reported by his wife on his return to village after 2 days at Dharmasthala, where he went after return from travel with the deceased boy after 2 days, would make the unfortunate death of the boy 4 days after the travel date, which actually the death occurred 7 days after the alleged date of travel, that is on 17/3/2010. This witness did not specify the date of travel. Quite obviously, the witness was tutored and his testimony is false.
But my lord, he has clearly stated in the evidence that, my lord, he saw the deceased purchasing the ticket at Haveri. And my lord, there might be some difference because, my lord, after some days, my lord, his statement is recorded. Immediately after the incident, he did not return to his hometown. He went to Dharmasthala and thereafter he returned. After 1 year, the evidence is recorded, my lord. There may be some discrepancy, my lord, in variations. But, my lord, the police documents, my lord,
What is the material to show that he traveled on that date in the train?
that he is the witness, my lord, he is evidence.
Manjunath wrongly mentioned in the application initially, but was later amended as Parappa Gowda alias. Even ನಿಮ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಏನ್ರಿ ಇವನ್ ಡಿಸೀಸ್ಡ್ ಹೆಸರು ಕೂಡ ತಪ್ಪ
ಅಲಿಯಾಸ್ ಅಂತಿದೆ, 2 ಹೆಸರಿದೆ, ಚೆನ್ನಪ್ಪ ಅಲಿಯಾಸ್ ಪರಪ್ಪ ಗೌಡ.
ಅದಾಮೇಲೆ ಅಮೆಂಡ್ ಮಾಡಿರೋದು. ಅದಕ್ಕಿಂತ ಮುಂಚೆ
ಅದು ಒಂದ್ ಹೇಳಿದ್ವಿ ನಾವು, ಬಟ್ ಇನ್ ದ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ my lord, police documents, the both names are my lord mentioned. Parappa Gowda alias
he was
Channappa.
traveling from which place?
He was traveling from Haveri. He boarded the train in Haveri. He has to go to
Mysore.
Hasana.
Hasan or Mysore?
Hasan, my lord.
Hasan.
It was Dharwad Mysore train. He boarded the train at Haveri.
He was standing near the door when the Solanashpura railway station. He fell down from the train and sustained grievous injuries. Immediately admitted to J. Chamarajendra Hospital, Hasan, taken to Kim's Hospital, Hubli, where he died on 17/3/2010. Oh, he has not died at the spot.
He had to alight in the Hasan, but my lord, the station was gone, my lord. When he asked the passengers, it has already gone. Therefore, my lord, to alight at the next station, he was standing near the door, my lord. He fell down from the train. His body was, my lord, found at 9:30. Immediately, the police only, my lord, shifted him to Hasana Hospital. The first information report, my lord, A1, my lord. AW1, it clearly shows, my lord, occurrence of
Who
the
is
incident.
AW1?
AW1, my lord. It is
Documents ನೋಡೋಣ ಏನ್ ಮಾರ್ಕ್ ಮಾಡಿದಿರಿ.
This is first information report, my lord. The occurrence of the offense, my lord, on 17/3/2010, 17/3/2010. This is, my lord, Hubli. He died in the hospital, Kim's Hospital, 17/3. Therefore, my lord, occurrence of the offense, it is shown as 73/2010, my lord.
Incident ಯಾವಾಗ ಆಗಿರೋದು ಮೇಡಮ್?
Incident is on 10th, my lord.
10/3.
10/3/2010.
Who noticed and shifted the injured to the
The
hospital?
railway police only, my lord,
ಎಲ್ಲಿದೆ ಅದ್ರ
noticed it.
ಬಗ್ಗೆನೇ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನು, ಎಲ್ಲಿದೆ ಅಂತ ಮೆಟೀರಿಯಲ್.
ಅದು FIR ಅಲ್ಲಿ, my lord, 1 minute. Case diary, my lord.
ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಆಗಿರೋದೇ 17/3. 10ನೇ ತಾರೀಕಿಂದ 17ನೇ ತಾರೀಕುವರೆಗೆ ಏನಾಯ್ತು ಮೇಡಮ್?
My lord, on 9/3 he alighted the train. 10/3 early morning, my lord, at 3 o'clock, in between 3 to 4 a.m. the accident occurred. He was admitted at Hasan Hospital at 9:30 p.m. 9:30 a.m.
Who took the injured to the
Railway police only, my lord.
ಎಲ್ಲಿದೆ ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಏನು? ಆಯ್ತು, ರೈಲ್ವೆ ಪೊಲೀಸ್ ಕೇಸ್ ಯಾಕೆ ರಿಜಿಸ್ಟರ್ ಆಗ್ಲಿಲ್ಲ ಇಮಿಡಿಯೇಟ್ ಆಗಿ?
My lord, AW2, my lord, case diary. My lord, in case diary, my lord, column number 9, my lord. AW2, case diary, column number 2. Dead body was identified by his father, deceased Parappa Gowda.
The inquest, madam.
24, my lord. Deceased was traveling in the Dharwad Mysore train on 9/3/2010 from Haveri to Hasana to go to his brother-in-law's house. There was very much crowd in the train. He was standing near the door. He fell down from Chillak, lasting balance near Hole Narsipura and severely injured. On 10/3/2010, he was given first aid treatment in government hospital, Hasana. For further treatment, he admitted to Kim's Hospital, Hubli on 11/3/2010. During treatment, he died accidentally on 17/3/2010. My lord, his brother-in-law was at Hirebendigeri only. When he received the call that, my lord, my lord, AW6, my lord. This is a letter written by Railway Police Hubli.
Hello, madam. If he is traveling from Haveri to Hasan,
Okay.
why he fell down at Valendrashipura?
He could have alerted at Hasan, but by mistakenly, my lord, he didn't alight. He did not alight at Hasana. The train continued, my lord. When he asked, Hasana station is already gone. Therefore, to alight at the next station, my lord, he was standing near the door.
ಅಲ್ಲಿ ಇಳಿಲಿಲ್ಲ ಅಂತ ಇವನೇ ಬಿದ್ದಿರ್ಬೇಕು ನೋಡಿ, ಹಾರಿರ್ಬೇಕು ಟ್ರೈನಿಂದ.
ಇಲ್ಲ my lord, he was standing near the door, my lord, because of the
ಆಯ್ತು
jerk of
ಮೇಡಮ್,
the train.
ನಿಮ್ಮ ಪ್ರಕಾರನೇ ಪ್ಲೀಡಿಂಗ್ಸ್ ಪ್ರಕಾರ ಹಾವೇರಿ ಟು ಹಾಸನ್, ಹಾಸನ್ ಆದ್ಮೇಲೆ ಹೊಳೆನರಸೀಪುರ ಸಿಗೋದು.
ಹೌದು, ಹಾಸನ್
ಹೊಳೆನರಸೀಪುರದಲ್ಲಿ ಯಾಕೆ ಡೆತ್ ಆಯ್ತು?
Hasan Ali, he could not alight, therefore he
and
was
fell
standing
down.
near the train.
Tilak, lasting balance near ಹೊಳೆನರಸೀಪುರ and severely injured. ನಿದ್ದೆ ಬಂದು ಎಚ್ಚರ ಆಗಿರ್ಬೇಕು ನೋಡಿ.
He was standing near the door ಅಂತ ಹೇಳ್ತಾರೆ. He was admitted to.
ಆಯ್ತು ಹೋಗ್ಲಿ, ಟಿಕೆಟ್ ಇದೆಯಾ?
My lord, there was nobody to recover the ticket, my lord. Only police only, my lord, admitted him to hospital. Therefore, I have examined a witness, my lord, who saw the purchase of the ticket from the deceased, my lord, at Haveri only.
This evidence is also not clear.
My lord, it is clearly, my lord, he has clearly stated in his evidence, my lord, Chandrappa, in his evidence, he has stated, my lord, I know the applicant and his son Parappa Gowda, who was called by name Chandrappa also. Evidence of, my lord, PW2, Chandrappa.
ಆಯ್ತು, ಫೈನಲ್ ರಿಪೋರ್ಟ್ ಎಲ್ಲಿದೆ? ಪೊಲೀಸ್ ಫೈನಲ್ ರಿಪೋರ್ಟ್.
Police report, my lord, at A11, my lord. A16, my lord, ಅಂತಿಮ ವರದಿ. ಅಂತಿಮ ವರದಿನಲ್ಲಿ
A11.
A11, A16, my lord. This is the Railway Police Mysore Circle. Mysore Railway has given this final report, my lord. ಕೇಸಿನ ಸಂಕ್ಷಿಪ್ತ ವರದಿ. ಈ ಪ್ರಕರಣದ ವಿವರವೇನೆಂದ್ರೆ, I have filed the translation, my lord. Brief facts of the case. The particulars of the case are that on 19/3/2010 at 10:30 a.m., I, Sri Narsimha Swami, Sub-Inspector of Police, who was in charge of the station, was at station. The complainant, Sri Ashok Hubli RPS, came to the station and submitted the file of Hubli RPS UDR 17 of 10 regarding transfer. When it is verified, there was one report in MLC 7145, which was received by Hubli RPS dated 17/3/2010 at 12:15 p.m. On verifying, Channappa Kallangouda, resident of Kundgola, fell from moving train near Holenarsipura railway station on 10/3/2010 and sustained injuries, admitted to Government Hospital Hassan, and for further treatment he was shifted to Kim's Hospital, Hubli on 11/3/2010. There he succumbed to injuries on 17/3/2010 at 3:20 a.m. The dead body shifted to mortuary, and for further action the case was registered in Hubli RPS under
ಮೆಡಿಕಲ್
UDR.
ರೆಕಾರ್ಡ್ಸ್ ಏನ್ ಹೇಳುತ್ತೆ? ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ಸ್, when he was shifted to the hospital immediately after the accident on 10/3. What is the medical record?
My lord, the postmortem report is there.
ಪೋಸ್ಟ್ ಮಾರ್ಟಮ್ ಬೇಡ್ರಿ, ಬದುಕಿದ್ದವನು 10ರಿಂದ 17ರವರೆಗೆ.
Yes, my lord.
What is the history given in the hospital?
I will see. Postmortem report ಅಲ್ಲಿ antemortem my lord, discharge report, discharge request is there, my lord, A7. This is, my lord, Chamarajendra Aspatre, Hasana. It says, my lord, history of the case is, my lord, fall from moving train, my lord, on 10/3/2010. It shows the fracture of the head, my lord, and fracture of the shoulder also. A7, AW7. This is discharge request, my lord.
ಫೈನಲ್ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಪೊಲೀಸು filed the report and comes to the conclusion that after the investigation, he was traveling in the train. He fell down on 10/3/2024 and immediately he was taken to the government hospital, Hassan. Yes. And thereafter he was shifted to the Kim's Hospital and he died on account of the injuries sustained by him. The final report A16.
Yes, sir.
Why tribunal has not considered this document?
I
This is-
request, my lords, could it be remanded with respect to that point and that let answer? Because
It has to be remanded.
original authority,
It's a part of record.
record.
Why it has to be remanded?
The issue here is, my lords, in all these claim petitions, the few documents which have not been considered, where it requires some specific finding to be recorded by the. It's some time frame fixed and within.
ಟ್ರಿಬ್ಯುನಲ್ ಮೆಂಬರ್ಸ್ಗೆಲ್ಲ ಒಳ್ಳೆ ಫೆಸಿಲಿಟೀಸ್ ಕೊಡ್ತೀರಿ ಅನ್ಸುತ್ತೆ ಅದಕ್ಕೇನೆ. ಹೌದಲ್ರಿ, A16 final
Certain-
report is filed before the
Certain.
railway tribunal.
My request, my lord,
He did not look into this document A16.
my request, was some guidelines may be required according to
Already
the given.
ಆರ್ಡರ್ ಮಾಡಿದೀವಲ್ಲ ಅದ್ರಲ್ಲೇ ಗೊತ್ತಾಗ್ತದೆ
Yes.
ಯಾವ ಮ್ಯಾಟರ್ ನೋಡ್ಲಿ ಇದೇನೆ.
I too agree with that.
The documents. That's why I asked immediately after the incident, he was shifted. ಎಲ್ಲಿದೆ ಮೇಡಮ್ ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ಸ್ ಹಾಸ್ಪಿಟಲ್ದು? ಏನ್ ಇಂಟಿಮೇಶನ್ ಕೊಟ್ಟಿದಾರ?
Discharge request, my lord, A7.
Railway tribunal did not look into this document, A16, final report. ರೈಲ್ವೆ ಪೊಲೀಸ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಿ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ದಾರೆ. ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಆಕ್ಸಿಡೆಂಟಲಿ ಫೆಲ್ ಡೌನ್ ಅಂತಲೂ ಕೂಡ ಇದೆ. And immediately he was taken to the government hospital and then Kim's hospital. All these details are found. Even ಆರ್ಡರ್ ನಲ್ಲಿ ಏನೂ ಇಲ್ಲ, ನಥಿಂಗ್.
There is no reference to that. No.
ಟಿಕೆಟ್ ಇಲ್ಲ ಅನ್ನೋದು is not a bona fide passenger ಅನ್ನೋದು ಆರ್ಡರ್ ಬರೆಯೋದು.
Yes. True, my lord, because that should not be the.
ಎಲ್ಲಿದೆ
Yes,
ಮೇಡಮ್?
they have to.
Immediately he was taken to the hospital.
A7, my lord. A7, my lord, discharge request, my lord, it is
Discharge request.
ಹೌದು, A7.
ಅಡ್ಮಿಷನ್ ರೆಕಾರ್ಡ್ ಎಲ್ಲಿದೆ ಅಂತ ಕೇಳಿದೆ ನಾನು. ಅಡ್ಮಿಷನ್ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಗೊತ್ತಾಗ್ತದೆ ಹೇಗೆ ಅವನು
ಇದರಲ್ಲಿ ಟೈಮ್ ಆಫ್ ಅಡ್ಮಿಷನ್ ಇಟ್ ಇಸ್ ಮೆನ್ಷನ್ಡ್
ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ. A5, A6,
A7,
A7.
A7 discharge request ಅಲ್ಲಿ ಡೇಟ್ ಆಫ್ ಅಡ್ಮಿಷನ್, my lord, on 10/3/2010.
Of fall from moving
train.
10/3/2010.
He was admitted at 9:35 a.m. Discharged on the same day at 9:35 p.m. He was shifted to Kim's Hospital. Here it is mentioned 9:35 a.m. Immediately he is admitted, my lord, by the railway police only. His relatives were not there.
A7 ಅಲ್ಲಿ ಇದೆಯಲ್ರಿ ಕ್ಲಿಯರ್ ಆಗಿ. On the date of the accident itself, he was shifted to the hospital, wherein history is also given. ಅವತ್ತೇ ಡಿಸ್ಚಾರ್ಜ್ ಮಾಡಿಸ್ಕೊಂಡಿದೆ.
ಅಂದ್ರೆ
ಮಿಷನ್ ಡಿಸ್ಚಾರ್ಜ್ ಎಲ್ಲ ಒಂದೇ
Kim's Hospital he was shifted to ambulance.
ಅವತ್ತೇನೆ
ಹುಬ್ಳಿಗೆ ಅವತ್ತೇ ರಾತ್ರಿ. Because his relatives were at Haveri only. On request he was shifted.
ಮಿಷನ್ AM ಡಿಸ್ಚಾರ್ಜ್ 9:35
PM.
ರಾತ್ರಿ
ಶಿಫ್ಟ್ ಮಾಡಿದ್ದಾರೆ. He died on 17/3 in Kim's Hospital. And postmortem was conducted in the Kim's Hospital itself.
Again, the statement of objection, it was denied that he fell from the train. Rest of the things are in the statement of objections filed before the tribunal.
Heard the appellant counsel and also the counsel appearing for the respondent. The present miscellaneous first appeal is filed against the dismissal of claim petition filed by the appellants for the death of deceased who is aged about 16 years.
No,
One by name,
40
ಏನು ಅವನ
40
ಹೆಸರು?
42 years, that's what they say.
16 years,
16 years. His father
16 years.
40.
16 years. His name is, Parappa Gowda alias Channappa, who was proceeding from Haveri to Hassan in the Dharwad-Mysore train. The claim of the claimants is the father and mother, and they reiterated in the claim petition that on 10/3/2010, the deceased Manjunath alias Parappa Gowda,
Manjunath ಅಲ್ಲ, my lord, his
Manjunath alias Manjunath, later it was amended as Parappa Gowda alias Channappa,
Channappa alias Parappa Gowda.
Proceeding from Haveri to Hassan in the Dharwad-Mysore train, and there was very much rush in the train. He was standing near the door and he accidentally fell down when the train was reached near Hodanashpur railway station and sustained grievous injuries. Immediately admitted, he was taken to the Jaya Chamarajendra Hospital and then Kim's Hospital, Hubli, where he died on 17/3/2010 since the treatment was not successful. The deceased was aged about 16 years and untoward incident was taken place while traveling in the train. The respondents appeared and filed their statement of objections contending that this is a case of voluntary non-fit injuria. And no man can take advantage of his own wrong. And also contend that the claim
Yes.
doesn't come under ambit of section 123C or section 124A of the Railway Act 1989.
For he's not a bona fide passenger also.
It is also contended that he was not a bona fide passenger.
And
No
dependents
material-
also
and
disputed.
Material is placed before the tribunal that he was a bona fide passenger.
And appellants are not the dependents. That was also one of the issue which
It
they
is
have.
also contended that the travel admittedly from Haveri to Hassan, but the alleged incident is near Holanespur station after 32 kilometers away from Hassan. No ticket or authority with the deceased to show that he was traveled in train. No eyewitness to the incident. Having considered the pleadings of the claimant as well as the respondent, the railway tribunal framed the following issues. Para number 5. The claimants, in order to prove the claim, examined the first applicant as AW1 and got marked A1 to A15. A1 to A15 through AW1 and AW2 and 3 were also examined, and A17 and A18 were marked through AW2. Respondents have not led any evidence. ಏನು ಮಾರ್ಕ್ ಮಾಡಿಸ್ಲಿಲ್ವಾ?
ರಿಪೋರ್ಟ್ ಮಾತ್ರ.
ಗಾಟ್ ಮಾರ್ಕ್ ಎಕ್ಸಿಬಿಟ್ R1 to R5. RW1 ಯಾರನ್ನ ಮಾಡಿದ್ರಲ್ಲ?
Yes.
RW1 and RW2 are examined and got marked R1 to R5. The railway tribunal, having considered both oral and documentary evidence, comes to the conclusion that the evidence which have been led before the tribunal not inspires the confidence that accident was occurred while traveling. Of the train and location, timing at alleged incident spot does not match with timings mentioned in the application. The incident timing in application is some 4 hours after the passage of train at Holaneshpura. The affidavit of applicant's witnesses seems to be created, crafted for the purpose of claiming compensation. Though examined AW3 that he had witnessed the purchasing of ticket by the deceased, who is said to have traveled with the deceased, stated that the boy died 3 days later than travel date, and subsequently, as reported by his wife on his return to village after 2 days at Dharmasthala, where he went after return from travel with the deceased boy after 2 days, would make the unfortunate death of the boy 4 days after the travel date. And the same creates the doubt, and witness did not specify the date of travel. And hence comes to the conclusion that the claimants have not proved the case that he was traveled and he was a bona fide passenger, and dismiss the claim petition. Being agreed by the said order, the present appeal is filed, and the counsel appearing for the appellant would contend that the railway tribunal failed to appreciate the fact that in column number 6 of the claim petition, date and place of the accident name of the train involved is categorically mentioned, and time of the accident at 9:35 a.m. And discharge summary also discloses that immediately after the accident, he was taken to Sri Chamarajendra Hospital, Hassan, in terms of exhibit A7. And time is also mentioned. And even discharge day timings also mentioned. It is also contended that the injured was shifted to the Kim's Hospital where he died. And history is also clearly mentioned in the hospital records that he fell down from the train moving towards Mysore. First of the council also would contend that railway tribunal observed that FIR is registered after 9 days of the incident and fails to take note of A7. He was shifted from Hassan to Hubli KMC Hospital. And though FIR was registered on 17/3/2010, but incident was taken place on 10/3/2010. The council also would contend that PM report also clearly discloses the date of incident as the 10/3/2010 and date of death is 17/3/2010. Apart from that, railway police have investigated the matter and filed the final report in terms of A17, and the same also clearly discloses that he fell down from the moving train and sustained the injuries and he succumbed to the injuries. The council would submit that all these documents were not taken note of by the railway tribunal and committed an error. And even the railway tribunal did not look into the document of A7 and A16, which clearly discloses that untoward incident was taken place and immediately was shifted to the hospital and he succumbed to injuries. For contra, the council appearing for the respondent would vehemently contend that in order to prove the fact that he was a bona fide passenger, no document is placed before the railway tribunal. And also the railway tribunal, while rejecting the
Claim petition.
Given the reason that the AW3 is also, 3 evidence is also not inspires the confidence. And railway tribunal also given the reasoning for not proving of the claim of the claimants and not committed any error. Having heard the appellant counsel and also the counsel appearing for the respondent and also on perusal of material available on record, the point that would arise for the consideration of this court are whether the railway tribunal committed an error in dismissing the claim petition and whether it requires interference. What order? Having heard the appellant counsel and also the counsel appearing for the respondent, it is not in dispute that the appellant, in order to prove their case examined, the father of the deceased as AW1. And he also produced document A1 to 15. And in his evidence, he reiterated the averments of the claim petition and he was subjected to cross-examination. In the cross-examination, he categorically says that on 10/3/2010 at about 6 p.m., his brother informed that Hassan police called him informing that his son has fallen down at Valanarshipura and he has been admitted to Hassan Hospital. The police also informed him that injuries are very serious and they are sending the injured person to Kim's Hospital. And on 11/3/2010 morning, he was sent to the injured to the Kim's Hospital. He also admits that they have not lodged any complaint stating that his son was not seen in the house. His son informed that on 9/3/2010, he was proceeding from Haveri to Hassan. And also admit that they have not produced any journey ticket before the tribunal. He says that the deceased was conscious and he informed about the journey and other things on 11/3/2010 and also on 12/3/2010. The police have not recorded the statement of the deceased in the hospital when he was conscious. The claimants also mainly relies upon the evidence of AW3, who says that he had witnessed that the deceased that when he was in the queue in the Haveri railway station counter, the deceased was standing in the queue, 2 persons behind him. He has seen the deceased purchasing the ticket. And deceased told him that he is going to Hassan. The train arrived Haveri railway station at 9:30 in the night. And the same was proceeding from Dharwad to Mysore. And he alighted at Davanagere. And when he alighted, he offered his seat to the deceased. After 3 days, he came to know about the death of the deceased. When he came back from Dharmasthala, his wife had informed that the boy had died. The tribunal, while considering the claim petition, mainly relies upon the evidence of AW3, wherein he says that he came to know about the death after 3 days. And no doubt, the document reveals that the incident was taken place on 10/3/2010 and he died on 17/3/2010. It is important to note that when the incident was taken place, immediately injured was taken to the Chamarajendra Hospital. And the railway tribunal fails to take note of document A7, discharge summary issued by the Chamarajendra Hospital, wherein the admission time is mentioned as 9:35 AM on 10/3/2010 and he was discharged on the very same day evening at 9:35 PM. And history is also very clear that fall from moving train on 10/3/2010. And when the history is given immediately at the time of admission, ought to have been taken note of the same. No doubt, postmortem report is very clear as per A8 that death is due to coma as a result of injuries sustained. It is also important to note that document A16 is very clear that the police have registered the case immediately after the death of the boy and investigated the matter and filed the charge sheet. And on perusal of the charge sheet also, it is very clear that investigation is conducted and filed the report stating that the death is on account of accidental fall from the moving train on 10/3/2010. And the fact that he boarded the train on 9/3/2010 itself, and the incident was taken place on the next day morning. And the railway tribunal did not discuss anything about A7 as well as A16. And no doubt RW1 and RW2 are examined. They also not speaks anything about the documents which have been produced. And railway tribunal ought not to have carried away with the conclusion that the evidence of AW3 is not clear and there is a discrepancy. It has to be noted that AW3 categorically stated that he found the boy was in the queue and he had witnessed that he had purchased the ticket, and on enquiry he revealed that he is going to Hassan. But he alighted at Davangere, and also he categorically says that after he went to Dharmasthala and when he came back, he came to know about the death of the boy through his wife. And railway tribunal committed an error only in coming to the conclusion that he gave this answer that after 3 days he came to know about the same, and the said answer cannot be a material discrepancy coming to such a conclusion. The tribunal committed an error in not considering immediate document of A7 and also the investigation report that is also conducted by the railway police itself, that he fell down near Holenarsipur when he was traveling, that is in moving train, and he had sustained injuries, and immediately he was taken to the hospital on the very same day in the early morning. And history is also given that it is an accidental fall from moving train, and when such been the case, ought not to have dismissed the claim petition of the claimants. And the reasoning given by the railway tribunal is erroneous, and the same is not based on the documentary evidence available on record which have been marked, particularly A7 and A16. And hence, I answered the point as affirmative. In view of the discussions made up, I pass the following order. Appeal is allowed, impugned judgment and award passed by the tribunal is set aside. Consequently, the application filed by the claimants is allowed and granted compensation of rupees 4 lakh with interest.
You are now it is 8 lakhs.
No, it is.
And if
Earlier.
interest not exceeds the amount of rupees 8 lakh has to be granted. The respondent railway is directed to satisfy the award amount within 8 weeks from today. The appellant is directed to place the copy of this order to the tribunal forthwith to make the payment in favor of the claimants.
58.
Next.
B.S. Raghu Prasad, M. Shiva Prakash.
But the respondent on submission,
Alright.
tomorrow,
Okay?
senior parted matter.
ಏನ್ರಿ ರೆಡಿ ಇದೀರಾ ನೀವು ಪಾಠ ಆಡಿದ್ರೆ ಮುಗಿಸ್ಕೊ ಬರ್ಲಿ ಮಧ್ಯಾಹ್ನ 2:30. 2006 ಮಾಡ್ರಿ ಏನ್ ಅರ್ಜೆಂಟ್
ಟುಮಾರೋ ಮೇಲೆ ನಾಳೆಗೆ ಮಾಡ್ತೀವಿ.
ನಾಳೆಗೆಲ್ಲ ಡೇಟ್ಸ್ ಆಲ್ರೆಡಿ ಇದೆ. 2006 ಮ್ಯಾಟರ್ಸ್. ಇನ್ನೊಂದು ಯಾರು ರೆಡಿ ಇದಾರಾ? 59 ಬಸವರಾಜ್. ಪಾಸ್ ಓವರ್ ಮುಗಿಸ್ಕೊ ಬರ್ಲಿ ರೀ ಮಧ್ಯಾಹ್ನ.
ನಾಳೆಗೆ
ನಿಮ್ದು ಎಷ್ಟೊತ್ತಾಗ್ತದ್ರಿ?
My lord, plaintiff's appeal,
ಹಾ
so it may take some time.
ಅದೇ ಎಷ್ಟೊತ್ತಾಗ್ತದೆ?
Half an hour.
ಅಂಡ್ ಜಾಯಿನ್.
ನಾಳೆಗೆ ಇದೆ ಸರ್.
ನಾಳೆಗೆಲ್ಲ ಡೇಟ್ ಇಲ್ಲ ನೋಡಿ. Appellant counsel present, respondent counsel seeks time, list this matter on 4/11. 59.
Basavaraju.
No date, 2006. Huh? No date. Other side ಯಾರು ಇದಾರ ನೋಡಿ? ಯಾರು ಇಲ್ವಾ? ಯಾರ ವಿಘ್ನೇಶ್ವರ ಫಾರ್ R3A ಅಂತೇನೋ ಇದೆ? ಹಾ ರೆಡಿ ಇದೀರಲ್ಲ? ಹಾ
ರೆಡಿ ಇದೀವಿ.
ಹಾ ಸರಿ ಹೇಳಿ ಮಧ್ಯಾಹ್ನ. ನೋ ಡೇಟ್ ಕೌನ್ಸಿಲ್ 2006 ನಾಚಿಕೆ ಆಗ್ಬೇಕು ಟೈಮ್ ಕೇಳಕ್ಕೆ. 18 ವರ್ಷ ಆಗಿದೆ ರೆಗ್ಯುಲರ್ ಫಸ್ಟ್ ಅಪೀಲ್. ಅಟ್ಲೀಸ್ಟ್ ರೀಚ್ ಆಗ್ಲಿ ಅಂತ ನಾನೇ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ಓಲ್ಡ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ತಗೊಳ್ಳೋಣ ಅಂತ. No, personal inconvenience is not a ground. Personal inconvenience is not a ground. You argue at 2:30. I will give you 1 hour time. You go through and the papers. No dates. 2006 ಎಲ್ಲ no dates. ನನಗ್ ಗೊತ್ತಿಲ್ಲ. 20 ವರ್ಷದೆಲ್ಲ ಇಟ್ಕೊಂಡು ಕುಳಿತ್ಕೊಂಡಿದೀವಿ ನಾವು ಮ್ಯಾಟರ್ಸ್ ಅಪೀಲ್ಗಳೆಲ್ಲ. ಅದು ರೆಗ್ಯುಲರ್ ಫಸ್ಟ್ ಅಪೀಲ್. It is ashame on the institution. No counsel. You assist the court counsel, that's all. Now time 1:30, 2:30, you go through the papers and assist the court. ನೀವು ಆದ್ರೇನು ಓದ್ಬೇಕಷ್ಟೇ. ನೀವು ಫೈಲ್ ಓದಿದ ತಕ್ಷಣ ಓಲ್ಡ್ ಆಗ್ತೀರಿ ನೀವು. ಫೈಲ್ ಓದ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನೀವೇನೆ. ನೋ ಡೇಟ್ ಕೊಡೋದಿಲ್ಲ. ಯಾವ್ದು ಡೇಟ್ ಕೊಡೋದಿಲ್ಲ. ಅದಕ್ಕೆ ಹಾಕ್ಸಿದೀನಿ ನಾನೇನೆ. Instructions I have given to the registry, post all old RFS.
My lords, one submission, my
ಹೇಳಿ
lord.
ಏನು?
Serial number 1, list number 1, serial number 8. ಅಜ್ಜನ್ ಆಗಿದೆ ಸ್ವಾಮಿ, ಅದ್ರಲ್ಲಿ ಇಂಟ್ರಿ ಮಾಡರ್ ಇದೆ, kindly extend the entry.
Serial number 8 ನೋಡ್ರಿ ಯಾರು ತಗೊಂಡಿರೋ ಡಿಕ್ಟೇಷನ್ ಹೇಳ್ರಿ ಎಂಟ್ರಿ ಮಾಡ್ರು. ಇದ್ರೆ ಹೇಳ್ಬಿಡಿ. Serial number 8
Serial number.
entry model is extended till next date of hearing.
ಅಚ್ಚಾ. Entry model extension.
ಹೇಳ್ತಾರೆ 8. ಹೇಳ್ತೀನಪ್ಪ.
Court officer. Court officer. Madam. Madam, mentioning it to 2:30. God. Ma'am. Ma.
Court officer?
ಸರ್
ಅಲ್ಲ, ಸೀರಿಯಲ್ ನಂಬರ್ 66 ಏನಾರ ಅಡ್ಜನ್ ಆಗಿದೆಯಾ?
ಆಗಿಲ್ಲ, ಬರ್ತಾರೆ, ವೆಯ್ಟ್ ಮಾಡಿ.
ಹೌದಾ, ರೀಚ್ ಆಗತ್ತಾ ಈಗ ಮಧ್ಯಾಹ್ನ?
ನಾನು ಹೆಂಗ್ ಹೇಳೋದು ಸರ್, ಅದನ್ನ ಕೇಳೇ ಬಿಡಿ ಆ ಕ್ವೆಶ್ಚನ್. ನಂಗೆ
ಓಹೋ.
ಆನ್ಸರ್ ಮಾಡಕ್ ತುಂಬಾ ಕಷ್ಟ.
ಆಯ್ತಾಯ್ತು. ಅಲ್ಲ, ಎಲ್ಲಿವರೆ ಬಂದಿದ್ದಾರೆ? ಎಷ್ಟು
ಹಾ?
ಎಷ್ಟರವರೆಗೆ ಬಂದಿದ್ದಾರೆ ಸೀರಿಯಲ್ ನಂಬರ್?
ಇವಾಗ 658.
ಹಾ,
58.
58.
ಹಾ.
ಓಕೆ.
ಏನ್ ಹಾಕಿದ್ರಿ ಅಂತ ಅರ್ಥನೇ ಆಗ್ತಾ ಇಲ್ವಲ್ಲ, ನೀವೇ ಡಿಸ್ಪೋಸಲ್ ತೋರಿಸ್ಬೇಕಾಯ್ತಲ್ವಾ? ಅರ್ಥನೇ ಆಗ್ತಾ ಇಲ್ಲ. ಹರಿದಾಸ್ ಪಟ್ಟಿ ಕೇಳಿದ್ವಿ, ಫೋನ್ ಮಾಡಿ. ಯಾವ್ದು ಹೇಳ್ತೀರಿ ಹೇಳು?
ನಾವು ಅದೇ ಇದ್ರ ಮೇಲೆ ಸಬೇಟೆಡ್ ಅಂದ್ರಲ್ಲ, ಅದಕ್ಕೆ
ವೇಟೆಡ್ ಅಂದ್ರೆ ಬಿಫೋರ್ ಇದು ತಾನೇ ಅರ್ಥ?
ಅಂದ್ರೆ ಇವರು ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಟೈಮ್ ಹೇಳಿದ್ವಿ, ಅದನ್ನು ಇದ್ ಮಾಡ್ತಾರೆ.
ಟೈಮ್ ಅಂದ್ರೆ ಏನಕ್ಕೆ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಅನ್ನೋದು ಇಂಪಾರ್ಟೆಂಟ್ ಇಲ್ವಾ? ನೀವೇನ್ ಗೊತ್ತಾ, 1000 ರೂಪಾಯಿ ನೀವು ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಟೈಮ್ ಅಂದ್ರೆ ಸ್ಟೇ ಟೈಮ್ ಅಂದ್ರೆ ಏನ್ ಅರ್ಥ?
ಎಂಟ್ರಿ ಮಾಡ್ರಕ್
ಹಾ,
ಹೇಳಿದ್ರು.
ಹೌದು.
ಅದೇ ಅದನ್ನ
ಅದಾದ್ಮೇಲೆ
ಡಿಸ್ಮಿಸಲ್
ಇವಾಗ
4
ಏನ್
ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ರು.
ಅಷ್ಟೊಂದು ತೋರಿಸಿದ್ರು.
ಅದೇ ಒರಿಜಿನಲ್ ಫೈಲ್ ಬಂತಲ್ಲ,
ಅದಕ್ಕೆ ಇದೆಲ್ಲ ಏನಾಗಿದೆ, ಡಿಸ್ಮಿಸ್ ಆದ್ಮೇಲೆ ಇದೆಲ್ಲ ಡಿಸ್ಮಿಸ್ ಆಗಿರುತ್ತೆ ತಾನೆ. ಇವಾಗ ರೆಸ್ಟೋರ್ ಆಗ್ಬಿಟ್ಟು ಮತ್ತೆ ಅದು ಡಿಸ್ಮಿಸ್ ಆದ್ಮೇಲೆ ಇದೆಲ್ಲ ಏನಕ್ಕೆ ಹಾಕಿದ್ರು ತೋರಿಸ್ಬೋದು. ನೋಡಿ, ಮಧ್ಯಾಹ್ನ ಕೂತ್ಕೊಳ್ಳಿ, ಹೇಳ್ತಾರೆ ಇಷ್ಟೇ ಏನಕ್ಕೆ ಹಾಕಿದ್ರು ಅಂತ ಕೇಳಿದ್ರು. ಈ ಪರ್ಮಿಷನ್ ಅದು ಏನಕ್ಕೆ ಅಂತ ಏನ್ ಹೇಳೋದು, ಏನ್ ಆನ್ಸರ್ ಮಾಡೋದು ನೋಡ್ಕೊಂಡಲ್ವೇನಪ್ಪ ಮಾಡ್ಬೇಕು. ಸುಮ್ನೆ ಬೈಸ್ಕೋತೀವಿ ಎಲ್ಲರೂ ಸೇರಿ.
ಆಮೇಲೆ ಅದು ರಾಂಗ್ ಆರ್ಡರ್ ಆಗುತ್ತೆ. ಸಿಂಗಲ್ ಜಡ್ಜ್ ಆರ್ಡರ್ ಅಂತ ಹೇಳ್ತಾರೆ.
ನಿಮ್ಗೆ ಹೇಳ್ತಾ ಇರೋದು ಸುಮ್ನೆ ಒಂದ್ ಸಬ್ಮಿಷನ್ ತರ ಕೊಟ್ರೆ
ಕೊಡ್ತೀನಿ ಬೇಕಾದ್ರೆ, ನಾನು ನಾಳೆ ಫೈಲ್ ಮಾಡ್ತೀನಿ.
ಅದಕ್ಕೆ ಹಿಂಗ್ ಮತ್ತೆ ಬರುತ್ತೆ, ಅದು ಹಾಕ್ಸಿದ್ರಾಯ್ತು. ಯಾಕೆ ಇಷ್ಟೊಂದು ರಬ್ ಮಾಡ್ಕೊಳ್ಳೋದು? ಆಮೇಲೆ ನಿಮ್ಗೆ
ಇಂಟ್ರೆಸ್ಟ್
ಹಂಗಾಗೋಗುತ್ತೆ ನಂಗೆ ಅದು.
court officer.
ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಇದ್ದೀರಾ?
ಹೇಳಿ.
ಮೇಡಮ್ ನಾನು ಧಾರವಾಡದಿಂದ
ಸರ್ ಹೆಸರು ಹೇಳಿ ಸರ್.
ಪ್ರವೀಣ್ ದೇವರೆಡ್ಡಿ ಅಂತ.
ಪ್ರವೀಣ್
ದೇವರೆಡ್ಡಿ, ಪ್ರವೀಣ್ ವೈ ದೇವರೆಡ್ಡಿ.
ಪ್ರವೀಣ್ ವೈ
ದೇವರೆಡ್ಡಿ ಅವರ DEVARE ಪ್ರವೀಣ್ ವೈ ದೇವರೆಡ್ಡಿ ಅವರ.
ದೇವರೆಡ್ಡಿ ಅವರ.
ಎಸ್ ಮೇಡಮ್.
ರೆಡ್ಡಿ ಅವರ.
ಮೇಡಮ್ ಇದರಲ್ಲಿ ಫಸ್ಟ್ ತಗೋತಾರ ಮೇಡಮ್ ಮುಂದೆ ಧಾರವಾಡದ ತಗೋತಾರ?
ಹೌದು.
ಓಕೆ.
Milord mentioning. Mentioning, Milord. Serial number 80.
Serial number?
80.
80.
Yes, Milord. I'm down with viral infection.
ಯಾವ್ದ್ರಿ serial number 80? Yes, madam.
I'm down with viral infection, Milord.
Yes, madam. What happened to your senior?
I'm the one who's assisting Sandesh, senior counsel Sandesh Chowta, who's available. But I am not in a position, Milord, today. No, next week.
ಶ್ರೀಹರ್ಷ
ಶ್ರೀಲೋಪಂತ್ ಏನಕ್ಕಿದೆ ಫಸ್ಟ್ ಟೈಮ್ ಅಥವಾ ಏನು?
ಸರ್ ಎಲ್ಲ ಆಗಿದೆ ಸರ್.
Further hearing, Milord.
Madam, it was listed on 30th.
Milord, ನಂಗೆ ತುಂಬಾ ಹುಷಾರಿಲ್ಲ. We wanted to close today. One ಅವಕಾಶ.
Madam, matter is urgent.
Thank you.
ಆಯ್ತು.
Date.
For respondents state, my lord, in Dharwad matters.
ಧಾರವಾಡ ಮ್ಯಾಟರ್ ಹೇಳಿ.
Please, madam. Offense punishable under section, my lord, 420, my lord. Charge sheet is filed against the.
Where is the petitioner counsel? Petitioner counsel ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ ಮೇಡಮ್. ಲಾಸ್ಟ್ ಟೈಮ್ ಏನಾಗಿದೆ ನೋಡೋಣ. Petitioner counsel seeks time. List this matter on 2310. You are appearing for respondent, state.
State, my lord. Charge sheet is filed, my lord. Evidence is commenced, madam. PW1 has been commenced, madam.
Already evidence is commenced.
Please, my lord.
Sorry. Petitioner counsel is absent and counsel for the state would submit that already evidence has been commenced. However, in the ends of justice, one more opportunity is given to the petitioner counsel. If petitioner counsel doesn't appear in the next date of hearing, petition will be dismissed. List this matter on next Wednesday.
Please.
30-10.
Matter pertains to Kalburgi bench.
Kalburgi ಬೇರೆ ಇದೆಯಾ?
Nandagav, RB Nandagav.
ನಾಡಗೌಡ. ಫಸ್ಟ್ ಟೈಮ್ ಇರ್ಬೇಕು ನೋಡಿ ಇದು. ಅರ್ಲಿಯರ್ ಬಂದಾಗಿಲ್ಲ.
ಇಲ್ಲ ಸರ್ ಬಂದಿಲ್ಲ.
First time, HCGP is directed to take notice and list this matter. And petitioner counsel is absent, list this matter on 30-10.
230 matters.
230 matters.
List 1. 68. Non-compliance for second time.
Lordship, I have subjection, my lordship, only 3 days, my lordship, I will comply. Some will help, my lordship, I enable.
Petitioner counsel seeks 3 days time to comply with office objection and post the matter after compliance.
Oblige.
Orders matter. 69. Sirajuddin Ahmed.
Sirajuddin Ahmed.
Just after 2 weeks, Lordship, and time may be granted for Lordship.
Petitioner counsel seeks 2 weeks time and hence list this matter. 2 weeks andre kodi after
611.
611.
Mature, Lordship.
70. Vikram Raj.
Vikram Raj, A.
Yes, Lordship. Appearing for the petitioner, petition filed under section 439, your lords.
First time bandid earlier.
Notice issue agide, your lords. Previously it was posted before.
Where is the earlier order?
Your lordship, accused, there are 2 accused in this.
Whether this petitioner had approached earlier or not?
No, your lordship, this is the first time.
First time.
First time, yes, your lordship. Accused number 2 is on bail,
name?
On bail, your lordship.
Dhanush Bandari.
Dhanush Bandari. Offense under section 394 and 397, read with 34 of IPC, your lordship. Accused number 2 is on bail, your lordship, granted by this honorable court. You may be permitted to read the complaint, your lordship, which is at page.
Now charge sheet already filed.
Charge sheet has been filed, your lordship.
Go to the charge sheet, column number 17.
Column number 17 is at page 34, your lordship.
Page 34.
34 of my petition. I may be permitted to read, your lordship.
34 only a letter issued by.
My petition, your lordship.
Your petition only I am reading.
That was, that's a list of documents, your lordship, filed on the previous occasion.
Counsel at page number 34, this is the letter issued by the corporation, Mangalore.
Petition, that's not my petition, your lordship.
This is not your petition?
That's not my additional documents.
9052.
The additional documents, sir.
The additional documents.
Additional documents. My petition. Petition only page number 34.
Yes. 34.
34. ಒಂದನೇ ಮತ್ತು ಎರಡನೇ ಆರೋಪಿತರು ಕಾನೂನಿನೊಂದಿಗೆ and then there's a
this accused is accused number
1, your lordship. There's accused number 1, 2 and a child conflict with law. ಕಾನೂನಿನೊಂದಿಗೆ ಸಂಘರ್ಷಕ್ಕೆ ಇಳಿದ ಬಾಲಕನನ್ನು ಸೇರಿಸಿಕೊಂಡು ಸಮಾನ ಉದ್ದೇಶದಿಂದ ಪೂರ್ವ ತಯಾರಿ ಮಾಡಿಕೊಂಡು ಆರೋಪಿ ಎರಡನೇನವರ ಬಾಬ್ತು K19HJ 4976 ನೇ ಸ್ಕೂಟರ್ ನಲ್ಲಿ ದಿನಾಂಕ 15/1/24 ರಾತ್ರಿ 10 ಗಂಟೆ ಸಮಯಕ್ಕೆ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದಿಂದ ವ್ಯಾಪ್ತಿಯ ಉರ್ವ ಪೊಲೀಸ್ ಠಾಣಾ ಸರಹದಿನ ಸುವರ್ಣ್ಸು ರಸ್ತೆಯಲ್ಲಿ ಬಂದು ನಡೆದುಕೊಂಡು ಹೋಗುತ್ತಿದ್ದ ಚಾಸ 1ನೇಯವರ ಹಿಂಬದಿ ಸುಮಾರು 30 ಅಡಿ ದೂರದಲ್ಲಿ ಸ್ಕೂಟರ್ ನಡೆದುಕೊಂಡು ಹೋಗುತ್ತಿದ್ದ ಚಾಸ 1ನೇಯವರ ಹಿಂಬದಿ ಸುಮಾರು 30 ಅಡಿ ದೂರದಲ್ಲಿ ಸ್ಕೂಟರ್ ನನ್ನು ನಿಲ್ಲಿಸಿ 1ನೇ ಮತ್ತು 2ನೇ ಆರೋಪಿತರು ಕಾನೂನಿನೊಂದಿಗೆ ಸಂಘರ್ಷಕ್ಕೆ ಇಳಿದ ಬಾಲಕನೊಂದಿಗೆ ಸ್ಕೂಟರಿನಿಂದ ಇಳಿದು ಚಾಸ 1ನೇಯವರ ಬಳಿ ಬಂದು ಆರೋಪಿತರ ಪೈಕಿ 1ನೇ ಆರೋಪಿತನು ಚಾಸ 1ನೇಯವರಲ್ಲಿ ಮೊಬೈಲ್ ಫೋನ್ ಕೇಳಿದ್ದು ಚಾಸ 1ನೇಯವರು ಕೊಡಲು ನಿರಾಕರಿಸಿದಾಗ 1ನೇ ಆರೋಪಿತರು ತನ್ನ ಸೊಂಟದಲ್ಲಿದ್ದ ಕೊಳವೆ ಆಕಾರದ ಸ್ಕ್ಯಾಬರ್ಡ್ ನಿಂದ ಬಟನ್ ಸ್ವೋರ್ಡ್ ಚಾಕನ್ನು ಹೊರ ತೆಗೆದು ಚಾಕನ್ನು ಚಾಸ 1ನೇಯವರಿಗೆ ತೋರಿಸಿ ಭಯಪಡಿಸಿ ಚಾಸ 1ನೇಯವರ ಪ್ಯಾಂಟಿನ ಎಡೆ ಕಿಸೆಯಲ್ಲಿದ್ದ ವಿವೋ ಫೋನ್ ಮಾಡೆಲ್ ಮೊಬೈಲ್ ಫೋನ್ ಅನ್ನು ಮತ್ತು 2ನೇ ಆರೋಪಿತನು ಚಾಸ 1ನೇಯವರ ಪ್ಯಾಂಟಿನ ಬಲಬದಿ ಕಿಸೆಯಲ್ಲಿದ್ದ 500 ರೂಪಾಯಿಯನ್ನು ಬಲವಂತವಾಗಿ ಕಸಿದುಕೊಂಡಿರುತ್ತಾರೆ. ಆ ಸಮಯ ಚಾಸ 1ನೆಯವರು ಪ್ರತಿರೋಧಿಸಿದಾಗ 1ನೇ ಮತ್ತು 2ನೇ ಆರೋಪಿತರು ಹಾಗೂ ಕಾನೂನಿನೊಂದಿಗೆ ಸಂಘರ್ಷಕ್ಕೆ ಇಳಿದ ಬಾಲಕ ಸೇರಿ ಚಾಸ 1ನೆಯವರ ಮುಖಕ್ಕೆ ಕೈಯಿಂದ ಹೊಡೆದು ನೆಲಕ್ಕೆ ಬೀಳಿಸಿ ಕಾಲಿನಿಂದ ತುಳಿದಿರುತ್ತಾರೆ. ಆಗ ಚಾಸ 1ನೆಯವರು ಜೋರಾಗಿ ಬೊಬ್ಬೆ ಹೊಡೆದಾಗ 1ನೇ ಆರೋಪಿತನು ತನ್ನ ಕೈಯಲ್ಲಿದ್ದ ಬಟನ್ ಸ್ಪೋರ್ಟ್ ಚಾಕನ್ನು ಅದರ ಕೊಳವೆ ಆಕಾರದ ಸ್ಕ್ಯಾಬರ್ಡ್ ನಲ್ಲಿ ಹಾಕಿ ಚಾಕುವಿನ ಹಿಡಿಯಿಂದ ಚಾಸ 1ನೆಯವರ ಬಲ ಕೈಗೆ ಹೊಡೆದು 2ನೇ ಆರೋಪಿ ಮತ್ತು ಕಾನೂನಿನೊಂದಿಗೆ ಸಂಘರ್ಷಕ್ಕೆ ಇಳಿದ ಬಾಲಕನ ಜೊತೆ ಸೇರಿ ಆರೋಪಿ 2ನೇಯವರು ಬಾಬ್ತು KA-19 ವೆಹಿಕಲ್ ಸ್ಕೂಟರ್ ನಲ್ಲಿ ಪರಾರಿಯಾಗಿರುತ್ತಾರೆ. Your Lordship, as far as the allegation against A1 is concerned, he is alleged to have held the knife as against the CW1 and threatened him with that knife to hand over his mobile phone and his belongings. Your Lordship, the accused number 2 is also on the same footing, Your Lordship. But as far as his release is concerned, he was let go on the ground that only 500 rupees as a alleged recovery from him was concerned. It was not recovered from him. Your Lordship, this the sword and the mobile phone that is alleged to have been taken from the accused is recovered from the vehicle of the accused number 2, Your Lordship. The additional documents that I have produced may be looked into. The one that Your Lordship had previously taken. Adralli,
Where is the order in respect of accused number 2?
Order I'll
granting the
produce.
bail?
it's the order as against the accused release of accused number 2, Your Lordship.
This court already granted bail in favor of accused number 2.
Yes, Your Lordship. I seek some of my grounds are on parity, Your Lordship, well, as against the accused number 2. But one of my grounds is, Your Lordship, this recovery of the sword and the mobile phone is at the instance collectively at the instance of accused number 1 as well as accused number 2. Moreover, the sword and the
Accused number 2 only recovery is only in the vehicle.
yes, Your Lordship, accused number 1's the sword
Sword is recovered from you only.
sword was collectively recovered, Your Lordship.
Collectively, by knife was recovered at the instance of accused number 1. And so also the mobile. And there is no recovery except motorcycle at the instance of the
The
petitioner.
mobile and the sword, Your Lordship, were recovered.
Sword was recovered at the instance of the accused number 1.
Your Lordship, I have produced as far as additional documents is concerned, Your Lordship. I have produced it at page number
Yes, madam, what do you say?
75.
Only a threat and causing of injuries, but
Please,
not.
your lordships, in the part of the trial court order, your lordships, antecedents, there is antecedents
many
against accused number
cases?
1. I have to secure the report with respect of that, your lordship.
Antecedents ಇದೆಯಾ?
ಇದೆ ಅಂತ mention ಮಾಡಿದ್ದಾರೆ. Page
And-
number 23 of the petition copy, your lordship. They've not mentioned the,
ಏನ್ರಿ ಏನಾದ್ರು ಕೇಸಸ್ ಇದೆಯಾ ಅವನ ಮೇಲೆ?
I have been acquitted in some of them, Your Lordship.
Acquitted ಆಯ್ತ್ರಿ, ಎಷ್ಟ್ ಕೇಸ್ ಇದೆ ಹೇಳ್ರಿ?
I
as
need
far
to
as
seek
accused
instructions, Your
is
Lordship.
concerned, no antecedents is there, your lordships, but accused number 1.
ಎಷ್ಟ್ ಕೇಸಸ್ ಇದೆ ನಿಮ್ ಮೇಲೆ ಹೇಳ್ರಿ?
I've sought instruction on that.
You are also not having.
I'm
any
not aware,
instructions.
but as far as I'm instructed, Your Lordship, some of them I've been acquitted.
Some of them ಬಿಟ್ಬಿಡ್ರಿ, ನಾವು ಕೇಳಿ, you are not answering to my specific
But
question.
there are antecedents, Your Lordship.
Okay,
I
cases
agree.
against you.
I'll seek instructions. One date may be
You are
given.
an habitual offender.
I'm not an habitual offender, Your Lordship. Not even
On
I'm.
what basis you are making that statement? If you are not having any information,
Because
what basis you are making such
been
submission?
instructed to some extent that in some of this one. One date may be given, Your Lordship. I'll seek information on this.
Counsel for the petitioner and also the counsel for the state seeks time to verify whether he is an habitual offender or not. This matter on 30th.
Grateful, Your Lordship.
ಕೋರ್ಟ್ ನಾವು ಕ್ವಶನ್ ಕೇಳಿದಾಗ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಆ ಕ್ವಶನ್ ಆನ್ಸರ್ ಮಾಡ್ಬೇಕು.
Apologies, Your Lordship.
ಆಯ್ತಾ?
Yes, Your Lordship. Grateful.
Don't try to evade.
71, ಏನ್ ರಾಧಾಕೃಷ್ಣ?
Appear for the petitioner. This is by A1 petition, my lord.
A1.
A1, Swami.
Earlier reject ಆಗಿದೆಯಾ?
Reject alla, Swami. Earlier it appears some of the, there are a number of accused, they have approached this on the court by
ಈ
filing.
petitioner approach ಮಾಡಿದಾನ ಅಂತ ಕೇಳಿದೆ.
ನನ್ನ ಪ್ರಕಾರ ಇಲ್ಲ ಸ್ವಾಮಿ, ಇದು
ಪ್ರಕಾರ ಇಲ್ಲ.
ಇಲ್ಲ ಸ್ವಾಮಿ. ಈಗ ಇದೇನ್ರಿ
ಬೇರೆಯವ್ರು ಅಪ್ರೋಚ್ ಮಾಡಿದಾರಾ?
ಇರ್ಬೇಕು ಸ್ವಾಮಿ, ಇರ್ಬೇಕು.
ನಿಮ್ಮವನ ಹೆಸರೇನು?
ಮುನಿಯಪ್ಪ ಸ್ವಾಮಿ, A1.
ಮುನಿಯಪ್ಪ ಇದಾನಲ್ರಿ, ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ನಂಬರ್ 1969 of
This
2020
is in
first
respect,
petitioner.
my lord, so far as this petition is concerned, I have argued for discharge before the learned magistrate, saying that offense under section 409 may not be attracted for a given circumstances. That has been negative by the learned magistrate. I have approached the learned session judge. That also negative.
ನನ್ನ
Against that,
ಪ್ರಶ್ನೆ ಮೊದ್ಲು ಅರ್ಲಿಯರ್ ಬೇಲಿಗೆ ಬಂದಿದ್ನ ಇವನು ಅಂತ ಕೇಳಿದೆ.
ಅಲ್ಲ ಆ ಆರ್ಡರ್ ಮ್ಯಾಗ ಬಂದಿಲ್ಲ, ಡಿಸ್ಚಾರ್ಜ್ ಮ್ಯಾಗ ಬಂದಿಲ್ಲ.
ಯಾವ್ದ್ರಲ್ಲೂ ಬಂದಿದ್ದಾನಲ್ಲ ಅರ್ಲಿಯರ್?
ಇಲ್ಲ, ಡಿಸ್ಚಾರ್ಜ್ ಮ್ಯಾಗ ಬಂದಿಲ್ಲ.
82 ನಲ್ಲೇ ಬಂದಿದ್ದಾನೆ ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್.
That quashing the proceedings, total proceedings it appears.
ಈಗ ಡಿಸ್ಚಾರ್ಜ್ ಮೇಲೆ
Discharge ಮ್ಯಾಗ ಸ್ವಾಮಿ, ಡಿಸ್ಚಾರ್ಜ್ ಮೇಲೆ
ಡಿಸ್ಚಾರ್ಜ್ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ.
ರಿಜೆಕ್ಟ್ ಆಗಿದೆ ಸ್ವಾಮಿ. Allegation is this my lad. They are work.
ಡಿಸ್ಚಾರ್ಜ್ ರಿಜೆಕ್ಟ್ ಆದ್ರೆ ನೀವು RP ಹಾಕ್ಬೇಕಲ್ವಾ?
I have filed RP before the learned.
ಅಂತಿದೆ ಅಲ್ಲಿ.
ಅಲ್ಲ ಯಾಕಂದ್ರೆ ಸ್ವಾಮಿ, I have filed before the learned magistrate revision. The second revision is not maintained by 397(2). ಅದಕ್ಕೋಸ್ಕರ I am before this court.
ಸೆಷನ್ ಜಡ್ಜ್ ಮುಂದೆ ಹಾಕಿದಿರಿ?
ಹೌದು ಸ್ವಾಮಿ, that has been negative.
Yes.
ಅಲ್ಲ
ಇಲ್ಲ ಅರ್ಲಿಯರ್ ಆಲ್ಸೋ. ಹೇಳಿ.
Facts is this my lad. Assistant Commissioner, C11 is the Assistant Commissioner. Traffic, Northeast Traffic Division. He, on 13/12/2019, he had a credible information within the jurisdiction of Malleswaram and Ashok Nagar Police Station. Traffic police officials, by using the alcoholic meters purchased by them illegally without permission of the senior officers, they are checking the drunken drivers and by threatening them, saying that if the case is filed, they have to pay 15 to 20,000. Saying so, they are collecting amount without the knowledge of the petitioner. Keeping this as the situation, my lord, on 15/12/2019, CW1 sent one person as a decoy by making him to take alcohol with permission, my lord, alcoholic beer. Accordingly, he went. After some time, he returned and informed. And accordingly, when CW1 and other staff people went there, they found these persons, including the petitioner, were checking the drunken drivers. So, basing on that, my lord, subsequently has secured the presence of the police inspector, traffic, Ashok Nagar police inspector. After seeing them, he said that they are of their staff. But without knowledge of the police inspector, without knowledge of senior officers, these accused have committed this act. So my respectful submission, my lord, I have argued mainly on the ground that in order to constitute offense under section 409 IPC, there must be some entrustment. Here, their case is, my lord, they have made use of the alcoholic meter, which has been purchased by A2 from one institution. This your lordship will get at page. I request you lords may kindly
Go to page 40.
I will come.
Go to page 40,
40,
column number
40.
17.
41 Swami, ಅದಕ್ಕೆ ಮುಂಚೆ ಮೈಕ್ 41 my lord.
That is report. 41 is report.
That is true. Report ಆದ್ರೂ ಆರೋಪಿ 2 ಲಾಸ್ಟ್ ನಗರ. ಆರೋಪಿ 2 ಗಂಗರಾಜು ಈತನ ದಿನಾಂಕ 7/12/19 ಒಂದು ಆಲ್ಕೋಮೀಟರ್ ರಿಪೇರಿ ಮಾಡುವ ನೆಪದಲ್ಲಿ ಮೆಡಿಕಲ್ ಸಪ್ಲೈಯರ್ ಇಂಡಿಯಾ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್ ಕಚೇರಿಗೆ ಖಾಸಗಿ ವ್ಯಕ್ತಿಯ ಜೊತೆ ಭೇಟಿ ನೀಡಿದ್ದು, ಆಗ ಈತನು ಆ ವೇಳೆ ಅಶೋಕನಗರ ಸಂಚಾರಿ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿದ್ದರು ಸಹ ಹೆಬ್ಬಾಳ ಸಂಚಾರಿ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ಸೇವೆ ಎಂದು ಮಾಹಿತಿ ನೀಡಿ ಹೋಗಿ ತಾನು ತೆಗೆದುಕೊಂಡು ಹೋಗಿದ್ದ ಆಲ್ಕೋಮೀಟರ್ ಸರಿಯಾಗಿದ್ದರೂ ಸಹ ಇದು ಕೆಲಸ ಮಾಡ್ತಿಲ್ಲವೆಂದು ಸುಳ್ಳು ಹೇಳಿ ರಿಪೇರಿ ಮಾಡಿಕೊಡಿ ಎಂದು ಕೊಟ್ಟು ನಂತರ ತನ್ನ ಜೊತೆಯಲ್ಲಿ ಕರೆದುಕೊಂಡು ಬಂದಿದ್ದ ವ್ಯಕ್ತಿಯನ್ನು ತೋರಿಸಿ ಇವರಿಗೆ ಆಲ್ಕೋಮೀಟರ್ ಬೇಕೆಂದು ಹೇಳಿ ಶ್ರೀ ವಿನಾಯಕ ಇಂಟರ್ನ್ಯಾಷನಲ್ ಸ್ಕೂಲ್ ಹೆಸರಿನಲ್ಲಿ ಒಂದು ಆಲ್ಕೋಮೀಟರ್ ಅನ್ನು ಖರೀದಿಸಿ ಮಾಡಿಕೊಂಡು ತಂದಿರ್ತಾರೆ. So like this, yes, it is only the accused number 2 has purchased the alcometer that has been made use of. It is not, they have made use of their government supplied alcoholic meter. If it is used, it amounts to 409. It amounts to cheating. Absolutely, it amounts to cheating. Apart from that, as you let's say, idರಲ್ಲಿ ಕೂಡ ಸ್ವಾಮಿ page 17 ನಲ್ಲಿ ಕೂಡ ಸ್ವಾಮಿ ಕಾಲಮ್ ನಂಬರ್ 17 ಈ ಕೇಸಿನ ಸಂಕ್ಷಿಪ್ತ ಸಾರಾಂಶವೇನೆಂದರೆ
ಕಂಟಿನ್ಯೂ ಮಾಡಿ ಅದನ್ನ ಇನ್ನು ಆ ಪ್ಯಾರ ಇದೆಯಲ್ಲ ಈಗ ಓದಿದ್ರಲ್ಲ.
ಹೌದು ಸ್ವಾಮಿ.
ಮುಂದೆ ಕೂಡ ಇದೆ.
ಮುಂದೆ ಆರೋಪಿಗಳು ವಾಹನ ತಪಾಸಣೆ ಮಾಡುವ ನೆಪದಲ್ಲಿ ಇಲಾಖೆಯಿಂದ ಮಂಜೂರಾಗಿದ್ದ ಅಥವಾ ಠಾಣೆಯಿಂದ ವಿತರಣೆ ಮಾಡಿದ್ದ ಆಲ್ಕೋಮೀಟರ್ಗಳನ್ನು ಉಪಯೋಗಿಸದೆ without using the instrument supplied by the government, they have made of
what they have purchased that was used.
That is there in order to commit cheat they have used. My response is in order to constitute an offense under ingredients of offense under section 409, there must be some entrustment should be there. that entrustment is not, that alcohol meter is not entrusted to these persons.
Yes.
They have purchased illegally. It is the act, it's an act which amounts to an offense under 420. So ಅದಕ್ಕೋಸ್ಕರ 420, 409 ಆಗಲ್ಲ ಅಂತ ನಾನು have made a request before the learned magistrate. That has been negatived by the learned magistrate as well as both the court.
That's all.
Asterisk.
Yes.
Lordships, prima facie, the case is made out against accused number one, your lordships. Sufficient material is looked into by the learned judge. Your lordships, accused number one, il entrustment baradilla. The machine which was entrusted to him, he has not used that machine. He's purchased his own machine and he's made use of it.
He purchased the other one and made use
He's
of the
made
same
use
for
of
the
it.
purpose of extracting the money from
From
the
the public.
persons.
Please, your lordships.
Hmm.
So, your lordships, 409 will come into place, your lordships, when that machine was used for cheating the public. That machine which was given by the department, that is not used by the accused number one, your lordships. And the decoy who was sent, your lordships, from him also they have, he is the main witness, your lordships, who has clearly stated that they have forcefully extracted money from him.
From the decoy also.
From the decoy also, your lordships. The accused number 5, it was transferred by through Paytm, your lordships. Accused number 5 account ಗೆ ಹಾಕಿದ್ದಾರೆ. Paytm use ಮಾಡಿ.
ಏನಕ್ಕೆ?
This fine, your lordships, the amount which they used to collect, accused number 5 Paytm account was used. The money would be paid through that, the fine amount.
Transferred.
Which would collect as fine amount, that would be transferred through Paytm through accused number 5 account.
Accused number 5 account. To whom it was transferred?
Accused number 5's Paytm account itself, your lordships.
With permission, drunk and drivers ಇರ್ತಾರೆ.
42 may be seen.
Publics ಇದ್ ಮಾಡ್ತಾರಲ್ಲ, ಅವ್ರ ಹತ್ರ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದು ಪೇ ಟೈಮ್ ನಲ್ಲಿ ಇವ್ರು ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ತಿದ್ರು ಅಂತ.
Page number
Through
42.
Paytm they used to collect ಅಂತ.
Page number 42.
42. ಆರೋಪಿಗಳು ವಾಹನ ತಪಾಸಣೆ ಮಾಡುವ ಸಮಯದಲ್ಲಿ ವಾಹನ ಚಾಲಕರಿಗೆ ಮದ್ಯಪಾನ ಮಾಡಿ ಚಾಲನೆ ಮಾಡುತ್ತಿದ್ದೀಯಾ, ನಿನ್ನ ವಾಹನ ಸೀಸ್ ಮಾಡುತ್ತೇವೆ ಮತ್ತು ಪ್ರಕರಣ ದಾಖಲಿಸುತ್ತೇವೆ, ನೀನು ಕೋರ್ಟ್ಗೆ ಹೋಗಿ 10,000 ರೂಪಾಯಿಗಳನ್ನು ದಂಡ ಕಟ್ಟಿ ವಾಹನವನ್ನು ಬಿಡಿಸಿಕೊಳ್ಳಬೇಕು ಮತ್ತು ಕೋರ್ಟ್ ನಿನ್ನನ್ನು ಜೈಲಿಗೆ ಕಳುಹಿಸಬಹುದು ಎಂದು ಹೆದರಿಸಿ, ನಿನಗೆ ಕೋರ್ಟ್ ಹೋಗಲು ಇಷ್ಟವಿಲ್ಲದಿದ್ದಲ್ಲಿ ಇಲ್ಲಿಯೇ ಹಣ ಕೊಟ್ಟರೆ ಹಾಗೆ ಬಿಟ್ಟು ಕಳುಹಿಸುತ್ತೇವೆ ಎಂದು ಹೇಳಿ ಸುಮಾರು 3,000 ರೂಪಾಯಿಗಳಿಗೆ ರಿಂದ 7,000 ರೂಪಾಯಿಗಳವರೆಗೂ ನಗದು ರೂಪದಲ್ಲಿ ಮತ್ತು ಆರೋಪಿ 5 ಈತನ ಪೇಟಿಎಂ ಅಕೌಂಟ್ಗೆ ಹಣವನ್ನು ವರ್ಗಾವಣೆ ಮಾಡಿಸಿಕೊಂಡಿರುತ್ತಾರೆ.
The amount was transferred into the account of A5.
A5. But the decoy specifically mentions all the presence of these accused persons here. And they've been caught red-handed.
So, heard the petitioner counsel and also the counsel appearing for the state. This petition is filed under section 482 of CRPC, praying this court to quash the order passed by the third additional chief metropolitan magistrate Bangalore in CC number 1411 of 2021. Wherein trial court comes to the conclusion that there are sufficient material to frame charge for the offences punished under section 409 of IPC. And the same has been confirmed in the revision petition number 142 of 2014 passed by the CCH-61 and discharge the accused number 1 for the offence punishment under section 401 of 409 of IPC. The factual matrix of the case of the prosecution is that based on the complaint of CW1, Assistant Commissioner, Northeast Traffic Subdivision, Bangalore, on 15/10/2019 at 18:45 hours, registered the case in crime number 196 of 2019 for the offence punishment section 409, 420, 384, read with section 34 of IPC against the petitioner and others, and investigated the matter and filed the charge sheet in CC number 1411 of 2021. And specific allegation made in the charge sheet that this petitioner along with other accused persons on 13/12/2019, when the complainant had received the information within the jurisdiction of Ashok Nagar and Malleshwaram traffic police station limits, the traffic police, by purchasing privately the alcohol meter, by using the same without the permission of senior police officers, under the pretext of lodging the cases against the drunken drivers, and without issuing the receipts, collecting the amount. And accordingly, on 15/12/2019, near this Srinivagilu Ring Road Junction, within the traffic jurisdiction of Vivekananda Traffic Police Station, by putting the barricades, they were checking the vehicle. Then as decoy, one person by taking one pint beer in order to confirm the allegations, sent the said decoy, and the said decoy went and returned and informed the complainant. Accordingly, they went near the spot, and 3 persons, by using the fictitious alcohol meters without the permission of senior police officers, conducting raid of drunken drivers and get it transferred the amount to Paytm and checking the vehicle owners. And hence, case has been registered and investigated and filed the charge sheet. The petitioner, who had filed an application for discharge before the trial court, has contended that ingredients of section 409 is not made out and he may be discharged for the said offence. And trial court dismissed the application, and revision petition is also filed, and the same is also dismissed, and hence the present petition is filed. The main ground urged in the petition is also that in order to constitute ingredients of offence punishment section 409 of IPC, ingredients is very clear that whoever being in any manner entrusted with property or with any dominion over property in his capacity of a public servant, or in the way of his business as a banker, merchant, factor, broker, attorney or agent, commits criminal breach of trust in respect of the property shall be punished with imprisonment for life, or with imprisonment for either description for a term which may extend to 10 years, and shall also liable to fine. And these are the ingredients have not been made out while invoking section 409 of IPC against the petitioner herein. Both the trial court as well as the revisional court have committed an error in coming to the conclusion that there are sufficient material to even frame the charge for the offence punishment section 409. And hence prayed this court to quash the order and discharge him for the said offence. The counsel appearing for the petitioner also brought to notice of this court the charge sheet allegation made against this petitioner and others, and also brought to notice of this court report filed under section 173 subclass 2 of CRPC, and contend that when such ingredients are not made out, ought not to have rejected the application, and hence it requires interference. Per contra, the counsel of appearing for the state that additional SPP would contend that the fact that the alcohol meter was supplied, was entrusted to them, is not in dispute. And specific case of the prosecution is also that they have purchased the other alcohol meter and using the same for extracting the money from the general public on the guise of checking of drunken driving of the vehicle. And also contend that using of the said privately purchased article, they are collecting the money and transferring the amount in favor of the Paytm of the accused number 5. And investigation is done and collected the material. And there are sufficient materials and the same has been considered by the trial court as well as the revisional court. And the very contention that not made out the ground to invoke section 409 cannot be accepted. Having heard the petitioner counsel and also the counsel appearing for the respondent state. And so also considering the grounds urged in the petition as well as the charge sheet allegations made in column number 17 is very clear that all of them are to them and they were not using the same, and instead of privately purchased alcometer was used to extract the money and also getting transferred the money in the Paytm of accused number 5, and all of them have indulged in such act. It has to be noted that when the specific allegation is made and also when the report is received on 13/12/2019 and thereafter only on 15/12/2019 a decoy was sent and got it confirmed the same, and thereafter only raid was conducted. And when such material is available before the court, the very contention of the petitioner counsel that there is no any entrustment and no ingredients are made out to invoke section 409 cannot be accepted. The fact that they were entrusted with the official alcometer is not in dispute.
Sorry, my lord.
Also, they have purchased
with permission, my lord.
they have purchased the alcometer privately and the same is used. And also decoy was sent and got it confirmed, and statement of decoy was also recorded during the course of investigation is also not in dispute. The very contention that they have not made out the ingredients of the offense on the section 409 to frame the charge against them cannot be accepted. It has to be noted that on the date of information, trade was not conducted, and the same was got it confirmed on after 2 days of the information, and thereafter by sending the decoy only information was collected and got it confirmed, and thereafter only the materials are seized at the instance of the petitioner as well as others. And when such being the case, the very contention that no ingredients are made out cannot be accepted. It may require the trial and witnesses CW 1 to 5 and CW 26 to 29 and CW 32 to 36 were police officials, and many of them under control of CW 1. And the very contention that they have given statement against the petitioner at the instance of CW 1 also cannot be accepted at the stage of framing of charge, and only the court has to look into the material collected during the course of investigation, and only while invoking discharge application has to take note of the fact that whether there is a material to proceed against the petitioner or not, and court cannot conduct any mini trial at the time of considering the material on record for framing of charge, and hence I do not find any ground to quash the order as sought. In view of the discussions made up, I pass the following order. Petition is dismissed.
72, Latif B.
Lord, this is a successive bail application. Lord, it's for
What is the change circumstances?
the change circumstance, Lord, now the material witness has been examined. There are 4 witnesses has been examined. The case of the
It was rejected on what ground?
Lord, on merits and medical grounds, all the thrice it is dismissed. 3 times it was.
3 times. This is 4th application.
4th application.
That's why, what is the change circumstances now?
Now, Lord, the 4 witnesses has been examined.
Ah.
Complainant has been examined as PW1. And the son of the complainant who was cited as eyewitness to the is not an eyewitness, Lord, he is a last seen witness, has been examined as PW2. And the father of the deceased examined as PW3 and wife of the deceased examined as PW4. Or 4 witnesses has been examined. The case of the prosecution rests on circumstantial evidence and the last seen theory. Last seen theory is concerned, Lord, the witness has supported.
Witnesses are supported.
Witnesses are supported.
Then whether this court can sit and appreciate the
Lord, I am not saying that not to appreciate the trial or
whether
giving
this
any
court can
findings on
usurp
that.
the jurisdiction of the trial court for appreciation. They have supported the case of the
They
prosecution.
supported the case of prosecution, Lord, at this stage, tampering of prosecution witness does not arise. Therefore, Lord, custodial trial is not required. I'm not saying that, Lord, the court has to appreciate the evidence and giving a finding. My
Already this was
submission is
considered the same on merit.
that is on merits, Lord. There is apprehension of the prosecution that he may tamper the
Not the
witnesses.
question of apprehension. Prima facie material.
Now, Lord, he is undergone more than, Lord, from 2021 he is in custody. 21.
2021.
Please.
What is the punishment?
Punishment
For
is,
302.
Lord, the apex court in the recent judgments, Lord, the Supreme Court has held long incarceration in jail. Long incarceration in jail also is one of the ground for granting bail. Here it is the case, only 4 witnesses examined from last.
How many other witnesses?
Lord, the charge sheet, there are as many as more than 50.
More than 50.
50.
15.
So 52. Witness has been cited. Therefore, Lord, again
There not be any general application for applying for incarceration.
I'll place some judgments, Lord, then. Kindly have it next week. I'll place judgments, Lord.
Supreme Court has taken note of more than 7 years, 8 years. They are in
No,
the
Lord,
jail.
in a case, Lord, 1.5 years, the incarceration also be considered by the apex court.
That is depends upon the facts of the case. Each
Yes,
case.
Lord. In those cases, my Lord, one of the case in the NDPS case, Lord,
Citations kodi ಆಮೇಲೆ
I'll
see
place. I'll place.
whether now you are having
I don't
citations.
have, Lord.
Told petitioner counsel seeks time to place the citation before this court and list this matter on yavaga 3010 or 611.
30.
3010.
73. Balakrishna MR. Appearing for the respondent, my lords.
Last time I directed.
Memo of appearance were filed it, my lords. It's not showing, the name is not showing.
Madam, last time order ಮಾಡಿದ್ವಲ್ರಿ? Last time matter list ಆಗಿತ್ತಲ್ಲ ಅವಾಗ ಆರ್ಡರ್ ಮಾಡಿದ್ವಲ್ಲ? Show the name of Unikrishnan ಅಂತ. ಮಾಡಿದೀವಿಲ್ಲ? Then why they have not shown the name? ಅಲ್ಲಿ ತೋರಿಸಿದಾರೆ ಇಲ್ಲಿ ಹಾಕಿಲ್ವಲ್ಲ ಕಾಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ? Yes, madam. You are from Unikrishnan office.
Yes, my lords. I'll seek 2 weeks time to file my objections, my lords.
Objections.
Yes.
Counsel seeks time to file statement of objections. And registry in spite of directed to show the name of central government standing counsel Sri Unikrishnan is not shown his name in the cause list. And directed to show the name without fail. If once again, if not shown the name, proceedings will be initiated against the concerned officials. List this matter on 611.
Grateful. 74. Ganesh K.
Lordship, I represent petition.
ಬೋರ್ಡ್ ಬ್ರಾಂಚ್ ಅವರು ಇರ್ಬೇಕು ನೋಡಿ ಮೇಡಮ್ ಆಟೋ ಶೀಟ್ ಅಲ್ಲಿ ತೋರಿಸಿದಾರಲ್ಲ ಯಾರು ಕರೆದ ಹೇಳಿ ಬೋರ್ಡ್ ಬ್ರಾಂಚ್ ನವ್ರಿಗೆ ಗಣೇಶ ಕೆ ಹೇಳ್ರಿ.
74.
Petition number 439. Petitioner is accused number 90. This is the third bail of application filed by the petitioner before the Procedural. Change circumstance is that during his stay in the JC, when he was taken to the Vide hospital, he was diagnosed with heart problem, Your Lordship. The doctor who had made an angiogram has suggested to insert 2 stents, Your Lordship. I placed the medical records of petitioner where he was taken to Vide hospital, Your Lordship. Facts of the case, Your Lordship.
Where is that report? ಆಯ್ತು, ಸ್ಟಂಟ್ ಹಾಕಕ್ ಕೊಡೋಣ ಬಿಡಿ ಒಂದ್ ಸ್ವಲ್ಪ ದಿವಸ. ನಿಮ್ಗೆ ಅಷ್ಟೇ ಬರೀ ಸ್ಟಂಟ್ ಹಾಕ್ಬೇಕಷ್ಟೇ ಅಲ್ಲ. ಆಯ್ತು, ಸ್ಟಂಟ್ ಹಾಕ್ಸೋಣ ಬಿಡಿ. ಏನ್ ಮೇಡಮ್, ಯು ಹ್ಯಾವ್ ಟು ಸೇವ್ ದಿ ಲೈಫ್.
Number 17 also stands on the same footing, Your Lordship. Whereas the petitioner has avoided the loan of 20 crore, Your Lordship, and he has repaid 18 crores, and he has only balance to repay the amount of 20 crore, Your Lordship. Charge sheet filed by the Basungudi police station.
ಎಲ್ಲಿದೆ ರೀ ರಿಪೋರ್ಟ್, ಎಲ್ಲಿದೆ ರೀ? Now you are seeking for medical ground. 260? 63.
The report card from the jail authority.
262, 63. Medical report of Rajesh. ಹೌದಾ? Impression. Patient is suffering from uncontrolled diabetes, mellitus, hypertension, ischemic heart disease, coronary artery disease, degenerative valve disease and medications. Coronary angiogram was done at Jayadeva Hospital on 17/7/23 and has been advised surgery. So and so. Functional flow reserve. So and so, if not controlled by medicines. Currently he is on regular medications for the above said ailments and requires treatment at higher center antide. 279. Hmm. 18/7/23 ಇದ್ರಿ ಇದು. ಹೋಗ್ಲಿ, ರೀಸೆಂಟ್ ಸರ್ಜರಿ ಮಾಡ್ಬೇಕು ಅಂತ ಎಲ್ಲಿದೆ? ಅದೇ ರೀಸೆಂಟ್ ಆಗಿ ಮತ್ತೆ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡಿದ್ದು ಎಲ್ಲಿದೆ ಅಂತ ಕೇಳಿದೆ. ಇದು 1.5 ವರ್ಷ ಆಯ್ತಲ್ಲ ಆಗ್ಲೇ. ನೀವು ಅರ್ಲಿಯರ್ ರಿಪೋರ್ಟ್ ತೋರಿಸಿದ್ರೆ ಯಾವಾಗಿಂದದು? ಈಗ 15/5/24. Yes, madam, you verify and submit.
Your Lordships, the petition copy is not there, Your Lordships, because enforcement directorate anta ide. Directorate.
Petition copy? ನಿಮಗೆ ಕೊಟ್ಟಿಲ್ವಾ?
I served the copy to the office.
I'll
On
verify
21st
Your
itself I
Lordships.
served.
ಆಫೀಸರ್ ಮಾಡಿದಾರಂತಲ್ಲ ಆಫೀಸ್.
Serve ಮಾಡಿದ್ದೀನಿ.
I'll
Two
verify
sets serve
Your
ಮಾಡಿದ್ದೀನಿ.
ತೊಗೊಳ್ಳಿ.
The medical.
Additional SPP 6 time to verify the records and list this matter on 30th.
Your
Your Lordships, the
Huh?
so deteriorating. Its health condition is so deteriorating, he is suffering a lot also.
ರೀ ಅವ್ರು ವೆರಿಫೈ ಮಾಡಿ ಅಂತ ಹೇಳಿ 30 ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ, ಮತ್ತೇನ್ರಿ ನಿಮ್ದು?
Your Lordships, medical report may be given, copy of the medical report may be.
ಎಂಟೈರ್ ಪಿಟಿಷನ್ ಕಾಪಿ ನಿಮಗೆ ಕೊಟ್ಟಿರ್ತಾರೆ ಮೇಡಮ್, ದಟ್ ಈಸ್ ಪಾರ್ಟ್ ಆಫ್ ದಿ ಪಿಟಿಷನ್. ಗೋ ಟು ಪೇಜ್ ನಂಬರ್ 267 and 279 ಅಷ್ಟೇ. ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ಸ್ ನೋಡ್ಬಿಟ್ಟು ಸಬ್ಮಿಷನ್ ಮಾಡಿ. ಇಫ್ ಇಮಿಡಿಯೇಟ್ ಟ್ರೀಟ್ಮೆಂಟ್ ಇಸ್ ರಿಕ್ವೈರ್ಡ್, ವಿ ಕ್ಯಾನ್ ಕನ್ಸಿಡರ್ ಇಸ್ ರಿಕ್ವೆಸ್ಟ್. 75.
From heart ತುಂಬಾನೇ ಇದಾಯ್ತು, accident ಆಗ್ತದೆ ಅಂತ ತುಂಬಾ ಹಿಂದೆನೇ ಹೇಳ್ಬಿಟ್ಟಿದ್ದಾರೆ. He is critically suffering some.
ಈಗಲೇ ಆರ್ಡರ್ ಮಾಡ್ಬೇಕಾ? ಮತ್ತೆ ಏನಕ್ಕೆ ಮತ್ತೆ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? 30th ಮಂಡೇ ಅಂದ್ರೆ ವೆಡ್ನೆಸ್ಡೇ ಹಾಕಿದೀನಿ, ಮತ್ತೇನ್ರಿ? ಶೌರ್ಯ ಕಾಪಾಡ್ಬೇಕು. ವಿಖ್ಯಾತ್ ವಿ.
Time allotted. Seek for some time allotted.
Time ಬೇಕಾ? Please, petitioner counsel 6 time list this matter on 30th, please.
Hearing on IS 76, Mohan Kumar D.
Advocate petitioner, praise for 1 week time allotted. I applied trial court order sheet, my lord. It is
Petitioner
not,
counsel 6 time. ಲಾಸ್ಟ್ ಟೈಮ್ ಮತ್ತೆ ಇಂಟ್ರಿಮ್ ಬೇಲ್ ಅಪ್ಲಿಕೇಶನ್ ಪ್ರೆಸ್ ಮಾಡ್ತಾ ಇದ್ರಿ, ಈಗ ಬಂದು ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ರಿ.
ಅಪ್ಲೈ ಮಾಡಿದ್ವಿ ಆರ್ಡರ್ ಶೀಟ್ ಗೆ.
ಆಯ್ತು, ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 30/11. ಹ್ಮ್ 30/10 ಸಾರಿ. ಎಲ್ಲ 30/10 ಆಗ್ಬೇಕು, ಎಲ್ಲ 30/11 ಅಂದ್ವಿ ಮೇಡಮ್.
Admission matter 77.
ಹೋಗ್ಬಿಟ್ಟಿದ್ವಿ.
Anand Muttalli.
Petitioner, my lord.
Hmm.
Lord, a purely civil dispute is given a criminal color, my lord. The last date itself, you had addressed arguments. Respondent was not present.
ರಟ್ಟಿಹಳ್ಳಿ ಗೀತಾ ವೀರಣ್ಣ ಅವ್ರೇನೋ ಇರ್ಲಿಲ್ಲಲ್ಲ? ಆರ್ಡರ್ ಶೀಟ್ ನೋಡಿ. Learned additional SPP seeks time. Learned counsel for respondent number 2 is absent. However, one more opportunity is gone. Doesn't appear. Yes, madam, ನೀವ್ ಹೇಳ್ಬೇಕು. ನೋಟ್ಸ್ ಇದೆಯಾ ಮೇಡಮ್ ಇದ್ರಲ್ಲಿ ನೋಡಿ?
Lordships,
ಇದೆಯಾ? ಇಲ್ಲ. Yes, you make out grounds. ಏನು ಹೇಳಿದ್ರಿ last time?
My lord, purely civil dispute, my lord, which is given a criminal color. A private complaint comes to be filed, wherein the second respondent alleges that she was induced by the petitioner herein, who is the managing director of a company, to invest in invest and take up a franchise of the company, my lord. My lord, the company is company deals in garments, ready-made garments, sale of ready-made garments. Hence, my lord, the allegation is that the petitioner has induced her to invest a sum of around 8 lakhs in order to open up the franchise. And once the franchise was opened, the terms of the agreement was not honored. Based on this, my lord, for recovery of the said amount, this criminal complaint is filed in order to pressurize the petitioner to settle the amount. My lord,
recovery of rupees 8 lakh.
8 lakhs, my lord. More than 8 lakhs, my lord, including rent and other expenses, around 53 lakhs is what has been claimed in the complaint.
What is the total amount claimed?
Around 53 lakhs, my lord.
53 lakhs.
53 lakhs. Here, my lord, private complaint comes to be filed. It was referred to the jurisdictional police station for investigation. And after investigation, my lord, the police files the B report. After B report is filed, my lord, the second respondent
was challenged and again cognizance was taken.
Peace, my lord. My lord, a total of 3 accused, my lord. Against accused number 1 and 2, the complaint has already been quashed. And now against the third accused is before this honorable court, my lord. My lord, this is a transaction which took place back in 2010, my lord.
This petitioner is A1, na?
Yeah, A3.
A3.
A3. Against A1 and A2, it has already been quashed.
1 and 2 quashed.
Please, my lord. Order is at page number 95, my lord, annexed G. Alleged offences are 406, 409, 420, my lord. My lord, there is no intention to cheat. As in the complaint itself, the second respondent has stated that once she has paid the money, the petitioner has supplied goods to her to an amount of 4 lakhs, pursuant to which for almost 8 months, my lord, the commission which was earned by the sale of the garments has already been remitted back to the complainant. As such, my lord, there is no intention of to cheat the complainant. Further, my lord, the company, due to the global recession, my lord, a lot of investors had backed off, and due to severe financial constraint, the company had to be wound up, my lord. The winding up order, my lord, is at annexure E, page number 59, my lord. And an official liquidator was also appointed. Any such grievance of the complainant to recover the money had to be made before the official liquidator, my lord. My lord, further, my lord, without there's an agreement which has been entered into, which is annexure F, between the company and the second respondent, my lord. Now, my lord, if any grievance, my lord, the company had to be made the primary accused. In order to attract vicarious liability upon the petitioner herein, the company had to be made a party. Without making company a party, they have proceeded to directly file it against the directors. Further, my lord,
Page number 114 may be seen, your lordships. Page number 114 of the petition copy itself.
Page number?
114. It is observed that in the sworn statement, the complainant has not disclosed the statement of accused number 1 and 2 in the company. The entire allegation is against accused number 3, who is representing the company. When the complainant stated that these accused persons are directors and designators of the company, which is a registered company, the complainant is required to produce the records of the company, but the complainant has not produced any records of the company. The main allegation is against accused number 3 itself, Your Lordships. And further in para number 7, Your Lordships, it is also important to note that accused number 2 retired in 2011 itself, and the present complaint is filed in 2015. And on perusal of the entire allegations in paragraph 4 of the complaint that accused persons are directors and other designators of the company. Main allegation is against accused number 3, Your Lordships. And only on this ground, Your Lordships, the revisional court has taken note of the amendments made in the complaint, has rightly come to the conclusion that in washing against accused number 1 and 2, Your Lordships.
Yes, heard, reserved.
$78. Karunakara.
Petitioner. Not said passed an interim order earlier on 10/7/2024. This is with respect to grant of land, about 4 acres. To recapitulate the facts, madam, grantee is one Halavaya. Halavaya has a son by name Iraya. This Iraya has a daughter called Rupa. She is the complainant. But in the year 1998, Halavaya had adopted this Sumitra, who is the A2 before my lords. So they also filed a civil suit on 2/4/2019. The MR was challenged after MR is now MR is done way back in the year 1998. Suit for declaration is made in the year 2019 on 2/4/2019. That civil suit is pending. After that, on 4/6/2019, they filed this PCR. In the complaint itself, they make an incorrect statement.
Complaint was filed in the year?
On 4/6/2019.
4/6/2019.
After a period of 2 months from the date of institution of the civil suit.
Civil suit.
My lords noticed this issue and then passed this interim order. And at this time, it was also noticed that there were 2 MRs. So my lord wanted to know how come there could be a 2 MR mutation register? Because the charge sheet indicate that the investigating police have secured a endorsement from the revenue authorities saying that one MR is not at all available. This will, my lords will get at ink page 50. My lord noticed this and then directed by learned friend to produce, and she said that she has both the MRs.
Your Lordships, I had informed the particular IO to get the records, Your Lordships. I have not received still, Your Lordships.
Long back, madam, more than 2 months.
Your Lordships, I
2.5 months, 3 months.
followed it up with them, Your Lordships. Last 30/10, Your Lordships. Last opportunity may be given, Your Lordships. One last time. I'd asked for the MR mutation records. They told they had, since it was the originals were given to the trial court, they're still trying to secure them, Your Lordships.
One more noticeable point, my lord, is they themselves state in the original suit that they are in possession. They are seeking for declaration. And they say that we are continue to be in possession in ink page 112, first para, last line. So where is the question of
when the suit was filed?
When suit was filed, they say that they are in continue to be in possession. Question of 420, not there. First they go to the civil court, seek for this. It's an arm twisting method for, and I have taken a very specific stand in my written statement. In para 7, way back, say in the year 2007, 2008, this adoption took place. And MR also, there is also a unregistered partition, which I have produced before my lord. That is the father of this complainant Rupa. He has signed. So all these facts, if they are disputed questions of facts, this required to be thrashed out in a full-fledged trial before the trial court. Not having got any relief, immediately thereafter they approach the learned magistrate.
Heard the petitioner counsel and the additional SPP seeks time on the ground that she could not get the records in spite of instructions given to the IO. And hence, ಯಾವಾಗ ಬೇಕು ಎಷ್ಟು ಸರ್ 3010 and hence this matter on 3010.
79,
Interim order may kindly.
Interim order granted earlier is extended till next date of hearing.
79, RB Sadashiv.
Dispute between the husband and wife.
Hmm.
A false complaint is lodged.
Hmm.
A false complaint is lodged
Hmm.
after the institution of the petition for divorce.
Hmm.
My lord was pleased to allow the petition with respect to 3 accused,
3 accused.
5 to 8.
Ah.
And with respect to 1 to 5,
Hmm.
my lord was pleased to dismiss it.
Hmm.
After that, we filed an application for the trial court for discharge.
Hmm.
The trial court has dismissed that, against which we filed a revision before the
Hmm.
first appellate court.
Hmm.
And the first appellate court was pleased to stay the proceedings.
Hmm.
Now, since the first appellate court has dismissed it, we are before my lord.
CRP also dismissed.
Yes,
CRP
yes.
also dismissed.
Therefore, we
Hmm.
are before the court.
Hmm. Now, what is the ground?
The ground is, my lord, dispute between husband and wife. Others are not concerned with the case.
Hmm.
Out of 5, first petitioner is the husband. It is understandable between the husband and wife, some allegations, something might have happened. We are only Panchayat Das.
Panchayat Das.
Yes, we are called to their house. All this incident takes place in the house of the parents of the wife.
Hmm.
Whether it is possible for third persons like Panchayat Das, you call us and say that we have done something to them. In what way we are concerned with the marital dispute between the husband and wife, my lord, is all the concern. And what the trial court has said is, because the high court has said that there is a material, therefore I cannot go behind it.
Hmm.
I just take my lord's attention to page 39.
Page 39.
39, my lord.
Hmm.
Paragraph 12.
Hmm.
The court also needs to be cognizant of the fact that the Honorable High Court in its order dated 4/2/21 at para 9 has specifically held that there is sufficient material as against these accused as regards their involvement in the alleged incident.
Hmm.
When a higher forum has given such finding,
Hmm.
judicial discipline demands that the same is followed by the forum below.
Hmm.
Therefore, for the reasons, I dismiss it.
Hmm. Where is the order passed by this court?
Of course, that is not produced before the court is.
Hmm.
And looking at the, of course, the medical certificates, my lord finds all of them. I have produced those medical certificates before the court.
Hmm.
Kindly see the medical certificates which I have produced before the honorable court at pages.
Page number?
ಇಲ್ಲ ಒಂದ್ ನಿಮಿಷ ಗೊತ್ತಿಲ್ಲ ಅಂತಾರೆ ಅವರು. Yes, I'll place it before the court, my lord, which are not there before the court. Stereotype in all the certificates for 3/4 persons, own certificates. And also, of course, the whole thing is wrong because of the relationship and age and everything is wrong. Kindly see page 54 in this case. In the ಇಲ್ಲಿ ಶಿವಲಿಂಗಪ್ಪನವರು ಅಂತಾರೆ. What is this? 70 years. Correct. Next one is Ratnamma, wife of Shivlingappa, and it is shown as male instead of female. Apart from that, she is aged about 60 years, but it is shown as 31 years. Whether Madhavi, wife of Sri Ashok, that is the second respondent herein, is shown as 60 years. And thus my lord finds from this, it is a casual way of putting things before the court, which could be termed as a concocted. Next. Page 55, kindly see, my lord, it's the wound certificate. Everywhere they only say tenderness and simple in nature. Injury is simple in nature. This is with respect to Mr. Shivalingappa.
Virupaksha and other.
Virupakshappa is the first petitioner.
Other with
Husband, my lord.
hand at about 8:30 PM on 21/2/20 in his house.
Similarly, my lord, the wound certificate, my lord finds it on page 55 of Mr. Shivalingappa. And on page 56, 57. My lord finds
Adavi.
that of Ratnamma. Tenderness, so and so. Above mentioned injuries.
But there are injuries.
Huh?
There are injuries, they were subjected to assault.
Hello, what kind of injuries, my lord?
Maybe injuries.
Abrasions.
Maybe an abrasions.
And
Now you are seeking for quashing.
yes, my lord. That is true. What I respectfully submit is the material dispute, if you call us as a heads of the village or something like that, and if we participate, whether we could have anything to say in the matter
So
except
whether they sustained simple injury or grievous injury is immaterial while quashing. But they have sustained the injuries. Wound certificate discloses the nature of injuries sustained by the victims.
yes.
Whether
Or
the court can quash the proceedings.
ಎಲ್ಲಾನು ಒಂದೇ ಕಡೆ ಒಂದೇ ರೀತಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಎಲ್ಲದಕ್ಕೂ. It is possible.
ಒಂದೇ ತರ ಏನಿಲ್ಲ.
ಹೌದ್ರಿ, ಒಂದೇ ಕಡೆ ಇದ್ರಿ. ಟೆಂಡರ್ನೆಸ್ ಎಲ್ಲರಿಗೂ ಹೇಳ್ತಾರೆ. ಮತ್ತೆ ಓನ್ಲಿ ಎಲ್ರಿಗೂ
ಲೆಫ್ಟ್ ಆಂಗಲ್ ಆಫ್ ಮೌತ್
simple
and
injuries
left
ಅಂತ.
back of shoulder.
What I respectfully submit, my lord, when I can understand the husband doing something because of anxiety or anger against the wife and the relatives who are in the house. That is parents-in-law and like that.
Not only wife, even also others
We have-
also assault was made.
As far as we are concerned, kindly see the accused number 1 to 5, that is petitioners 1 to 5.
Left arm
One is
and upper back and
One
back
is-
of neck.
second, the third petitioner is 68 years old. In what way he is bothered about this parental
Whether this court can examine this at the time of quashing the same.
prima facie, my
Regarding
lord?
nature of injuries. Prima facie, there is an injuries on the victims. That's the reason only this court found the material against accused number 1 to 5 and others has been quashed.
Here at the FIR stage, when there was no material, no charge sheet before the court, my lord, understandable that material was not there. Therefore, my lord took the view that there is some.
Yes, madam.
This was 164 statement of the victim has also been recorded, your lordships, respondent number 2. Her statement is also recorded. And also there are wound certificates also, your lordships. All which shows that there are injuries. Which shows that there is some kind of altercation and also some kind of fight has happened. And there is
I heard result, no, let's see.
Please.
Adjourn 81. Radha by.
457 and 380 of IPC minutes. The trial court imposed a sentence of 2 years minutes. Later, it was modified to 1 year. Lord, with respect to the facts is concerned, my lord, accused number 2 was deputed as a security guard in the complainant Coffee Gordon, my lord. Thereafter, my lord, on 25/7/2008 to 29/7/2008, a complainant noticed that my lord, some coffee bags were missing, my lords. Thereafter, my lords, after 4 days of the incident, my lord, he lodged a complaint before the respondent police, my lords. Thereafter, my lords, a charge sheet was filed against the accused persons. My lords, a trial court imposed a 2-year sentence along with a fine of rupees 10,000 each.
ಹೌದ್ರಿ recoveries ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ. Coffee bags are
Recovery
also
ಇದೆ.
recovered.
I'm relying on the technical ground, my lords. Already, with respect to the recovery is concerned, my lords, Reliance citation already produced with the before lordship, my lords.
11 bags are recovered.
Already recovered, my lords. With respect to the recovery, my lords, it is not proved in terms of section 27 of Indian Evidence Act. Already given some citation, my lords.
ಏನ್ citation ಹೇಳಿ
ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಕೊಟ್ರಿ ಅದೇನೋ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತಾರೆ ಅದ್ರಲ್ಲಿ ಏನಾರು ಇದೆಯಾ?
But the entire case is rest on circumstantial evidence, my lords. On such being the status, my lords, the Panchanama.
ಕಾಫಿ ಬ್ಯಾಗ್ ಕಳ್ತನ ಆಯ್ತು, ಕಾಫಿ ಬ್ಯಾಗ್ ನಿಮ್ ಕಡೆಯಿಂದ ರಿಕವರಿ ಆಗಿದೆ. ವಾಟ್ ಎಲ್ಸ್ ಎವಿಡೆನ್ಸ್ ಇಸ್ ರಿಕವರ್ಡ್ ರಿಕ್ವೈರ್ಡ್?
My lords, in the present case, my lords, evidence of PW 15 has been discarded, my lords. At those instance, my lords, the recovery has been made based on the voluntary statement of accused number 2. My lords, with respect to the same, my lords, page number 11 of my citation, my lords.
Even recovery at the instance of the accused also an incriminating material against you.
Please, my lords, but recovery is not made in the terms of section 27 of Indian Evidence Act, my lords.
What is
As laid down by the Subramania versus State of Karnataka. Page number 11, my lords. Page number 11 of my citations. Subpara 84, my lords. If it is say of the investigation officer that the accused appellant while in custody on his own free will and volition made a statement that he would lead to the place where he had hidden the weapon of the offense, the site of burial of the dead body, clothes, etc., then the first thing that the investigation officer should have done was to call for 2 independent witnesses at the police station itself. Once the 2 independent witnesses would arrive at the police station, thereafter in their presence, the accused should be asked to make the appropriate statement as he may desire in regard to pointing out the place where he is said to have hidden the weapon of the offense. When the accused while in custody makes such statement before 2 independent witnesses, the exact statement or rather the exact words uttered by the accused should be incorporated in the first part of Panchanama, that the investigation officer may draw in accordance with law. This first part of Panchanama for the purpose of section 27 of Indian Evidence Act is always drawn at the police station in the presence of the independent witnesses, so as to lend the credence that the particular statement was made by the accused, expressing his willingness on his own free will and volition to point out that the place where the weapon of the offense or any other article used in the commission of the offense has been hidden. Once the first part of Panchanama is completed, thereafter the police party along with the accused and the 2 independent witnesses would proceed to the particular place as may be led by the accused. If from the particular place anything like the weapon of the offense or bloodstained cloths or any other article is discovered, then that the part of entire process would form the second part of Panchanama, my lords. This is how, my lords, the procedure laid down by the Honorable Apex Court with respect to the seizure Panchanama, my lords. But in the present case, my lords, no 2 independent witnesses were present at the police station, my lords. The recovery is not made in terms of section 27 of Indian Evidence Act, my lords. By relying on same judgment, my lords, the division bench of this court, my lords, which is at
recovery, and what is the mode of recovery in this case?
Direct coffee bags were recovered at the instance of PW 15.
How anta kelta idini nanu in the present case?
My lords, without making 2 independent witnesses, they are straight away gone to the place based on the voluntary statement of accused number 2.
Independent witnesses ilva?
Alla, there is a procedure with respect to independent witnesses, my lords. Independent witnesses there, but with respect to evidence of PW 15, adne discard ಮಾಡಿದ್ದಾರೆ.
PW 15. Who is an independent witness?
Who is the owner of the coffee shop, my lords? The stolen goods were sold to him. But his evidence was discarded by the trial court.
Why it was discarded?
ಬರ್ತಿಲ್ಲ ಅಂತ ನಾವು ಇದು ಮಾಡಿದ್ವಿ. ಏನೋ ಅಪಿಯರ್ ಆಗ್ತಿಲ್ಲ ಅಂತ.
ಅಪಿಯರ್ ಆಗ್ತಿಲ್ಲ ಅಂತ. Not subjected for cross examination ಅಂತನಾ ಏನು? ಅಲ್ಲ initially ನಾನು ಹೇಳಕ್ಕಾಗಲ್ಲ ಅದನ್ನ. ಅಲ್ಲ initially chief discarded ಅಂತ.
Please, my lords, initially chief was conducted, my lords, thereafter is not available. That's why the evidence of PW 15 discarded.
ಎಲ್ಲಿದೆ ಅದು ಆ ರೀತಿ?
Let's see it. In depositions in page 22, please.
These records, trial court records.
The observation of the court minutes is point out. That's in page 22 minutes.
in page 22 of trial court judgment, para 21. Para 21, last 3 lines, my lords.
Para 21, huh?
Please, my lords. Last 3 lines, my lords.
Owner of the Sri Rama Coffee work was examined by the prosecution. In his examination in chief, he has deposed that he know the accused persons wherein he purchased the coffee seeds. From them, he further deposed that the police brought the accused number 2 to his shop and seized the stolen coffee seeds by him through exhibit P3, but when the case has been posted for further examination in chief of PW 15, he has not appeared irrespective of issuance of summons and warrants. Hence PW 15 was dropped and hence his evidence has been discarded, not available for the cross examination through the guilt of the guilt.
Please, my lords. Because, my lords, the entire case is rest on circumstantial evidence, my lords. Such being the case, my lords, seizure Panchanama carries.
The recovery witnesses have supported or not?
No, my lords. PW 1 to 3 have been supported, my lords. They are the interested witnesses, my lords. PW 1 is the complainant. PW 2 is the manager at the complainant Gordon, my lords. And PW 3 is the accountant at the complainant's Gordon. They are supported the case of the prosecution, my lords. PW 6 to 12 have been turned hostile. The trial court relied on the evidence of official witnesses and also PW 1 to 3, my lords. They are none other than the interested witnesses, my lord.
ಅಲ್ಲ ರಿಕವರಿ ಬಗ್ಗೆ ಏನು ವಿಟ್ನೆಸ್ ಎವಿಡೆನ್ಸ್ ಇಲ್ವಾ?
ಅಲ್ಲ ರಿಕವರಿ ಬಗ್ಗೆ PW 15 is the sole witness, my lord.
Your lordships.
PW
2 and 3.
2 and 3.
2 and 3. They are the worker and the manager of the place, your lordships.
ಆಯ್ತು.
PW 1 is the complainant.
ಹಾ.
They have supported regarding the seizure. They have, ಅವರು ಓನರ್ ಇದು ಜಾಗಕ್ಕೆ ಕರ್ಕೊಂಡು ಹೋಗ್ಬಿಟ್ಟು ಎಲ್ಲಿಂದ ಮಾರಾಟ ಇವ್ನ್ ಮಾಡಿರ್ತಾರಲ್ಲ ಅಲ್ಲಿ ಕರ್ಕೊಂಡು ಹೋಗ್ಬಿಟ್ಟು ಕಾಫಿ ಬೀಜಗಳನ್ನ ರಿಕಗ್ನೈಸ್ ಮಾಡಿಸ್ತಾರೆ.
Why you have not secured the independent witnesses? According to they are the manager and
Accountant.
2 and 3.
Accountant. Manager and accountant, my lords.
And accountant.
Please.
How they become an independent witnesses?
PW 15, your lordships.
Huh?
PW 15 also speaks about the seizure, your lordships.
Caesar.
Please, your lordship.
ಅವ್ರ ಪ್ರಕಾರ PW 15 turned hostile ಅಂತಾರ.
ಅಲ್ಲ evidence has been discarded.
PW 15 evidence is not subjected for cross examination.
Your lordships, that itself will not take away the material evidence in chief, your lordships. If the witness is not available for cross examination, your lordships, but to that extent, with regard to the
How
seizure,
can
he
the
is
court can
supported.
rely upon the evidence of chief evidence
Lordships, with regard to the
without
seizure,
subjecting him for cross examination?
he has supported with in regard of
May be supported in chief examination, madam. What is the scope of cross examination? He is not subjected for cross examination, whether the witness who comes and deposes before the court in part, that to a chief examination in part. Whether the court can rely upon. In a case of criminal case, proving is beyond reasonable doubt. No other independent witnesses.
lordships, the IO is there, your lordships, at PW 13. He is the IO who has,
Any independent witnesses with regard to the recovery, madam?
no, your lordships.
Huh?
No independent witnesses, your
Then?
lordships. Up to PW 5, the witnesses supported, your lordships.
5.
PW 5. He is also the manager, your lordships. PW 5 is the
All are
manager.
complainant parties, madam.
Please, your lordships.
Then?
No independent witness.
Huh?
No independent witnesses, your
Then?
lordships. They have turned hostile, your lordships. PW 6, PW 7, 8, 9, 10, 11, all the witnesses have turned hostile.
Even as per the prosecution.
Recovery witnesses, police witnesses idara illa? ಅವಾಗ ಪೊಲೀಸ್ನವರು ಬೇರೆಯವರು ಇದ್ರ ಇಲ್ಲ? Whether they have supported, whether their evidence is credible.
PW 13 is the only, his IO is the only who is being examined, your
PW 13.
PW 13 and PW 14 speaks about the arrest of the accused, your lordship.
Arrest ಬೇಡ, recovery ಸಂಬಂಧಪಟ್ಟಂತೆ.
Bari PW 13, your lordships. With recovery, only PW 13 is the witness IO.
ನೀವೇನು ಸೇಲ್ ಮಾಡಿದ್ರಿ ಕಾಫಿ ಬ್ಯಾಗ್ಸ್ ಅದ್ರ ದುಡ್ಡೆಲ್ಲ ರಿಕವರಿ ಮಾಡಿದಾರಲ್ರಿ?
ಅಲ್ಲ ಆಮೇಲೆ
ಹಾ
out of my lords 20,000 the
the amount realized from the sale of coffee seeds was also recovered from the accused persons on the basis of voluntary statement. The portion of the statement voluntary given by the accused persons for discovery is not hit by section 25 of the Evidence Act and same can be relied upon. It is for the prosecution to show that such statement was made by the accused which was free from threat and coercion. Schedule 1 to 3 has clearly deposed that accused after arrest and voluntarily statement, the accused voluntarily led the police team along with them and so or the recovered coffee seeds.
That's when the recovery is not made in terms of section 27, entire proceedings will be vitiated.
Third, order the petitioner counsel and also the counsel appearing for the respondent. The present revision petition is filed challenging the conviction and confirmation passed by the trial court as well as the appellate court. The main contention urged before this court by the petitioner that there is no any recovery as contemplated under section 27 of Indian Evidence Act. The counsel also contends that main in this revision petition is only on the ground of technicality, proving of recovery, and no independent witnesses have been examined. The counsel also submits that though PW 15 has been examined and his evidence is only chief, that too in part, and he has not appeared before the court to give evidence and even not subjected for cross-examination. And though PW 1 to 3 have been examined and supported before the trial court, they are the complainant and manager and also the accountant of the complainant. The counsel also contend that PW 13 is the IO, no other independent witnesses. The counsel also in support of his argument vehemently contend that no recovery of key, and even though contend that duplicate key was recovered and person was not examined and no key was also handed over. The counsel in support of his argument relied upon the judgment of the Apex Court reported in 2023 SEC online SC 50 and brought to notice of this court a discussion made by the Apex Court in paragraph number 32, wherein the extraction was made in respect of the judgment of Subramania versus State of Karnataka. That is paragraph number 82 and 84. And the procedure to be followed for recovery in order to prove the recovery under section 27 of the Evidence Act. Counsel also brought to notice of this court discussion made in paragraph number 33, 37 and 38. The counsel also in support of his argument, he relies upon judgment passed by this court in division bench in criminal appeal number 1004 of 2017 connected with criminal appeal number 1084 of 2015. Yeah, paragraph idರಲ್ಲಿ
It's para 21, 22, 23.
And counsel relies upon paragraph number
21 to 23. 21 to 23.
21 to
23 minutes.
23 and also brought to notice of this court the reference of judgment, paragraph number 82 regarding section 27 of the Indian Evidence Act, and so also the paragraph number 83, 84 of the very same judgment of the Apex Court, and allowing of the appeal with regard to the recovery has not been proved. Per contra, the counsel appearing for the state would contend that though they are the witnesses of complainant, But PW 2 and 3 speaks about the recovery. And apart from that, PW 13 IO also speaks about the recovery. And council also would contend that even coffee bags which were sold and monetary consideration was also recovered at the instance of the accused petitioner. You next now, no accused.
Well, accused number 1 to 4.
Sole accused.
There are 5 accused, my lords. 1 to 4 are before this court. 1 to 4.
1 to 4 are before this court. What about 5? 5 was accused.
5 not preferred any appeal.
Crown confirm ಆಗಿದೆಯಾ? Sentence ಅನ್ನಲ್ಲ, he underwent sentence.
That I have no instruction with respect to accused number 5.
The council also submits that coffee bag are sold to CW 13. CW 13 PW 15
CW 13 is PW 15, your lordship.
CW 15.
13 is PW 15.
And his evidence also can be considered. Having heard the petition of counsel and also the counsel appearing for the respondent, and also having considered the material available on record and also the reasoning given by the trial court as well as the appellate court in confirming the same, this court has to analyze whether the judgment impugned of convictions and confirmation order passed by the trial court suffers from its perversity, whether it requires interference by exercising the revisional powers. Having heard the petitioner counsel and also the counsel appearing for the respondent, and also having considered the factual aspects of the case, the police have registered the case against the petitioner's hearing of the offences punishable under section 457 and 380, read with section 149 of IPC. The trial court mainly relies upon the evidence of PW 1 to 3 as well as PW 13, and other witnesses have turned hostile. The PW 1 to 3 are the complainant as well as the manager and also the accounts officer of the complainant. No doubt specific allegation is that these petitioners have committed the offense of theft of coffee bags and when the complainant inspected the godown, he found that 12 bags totally weighing 845 kgs of coffee seeds worth of rupees 1,22,632 was missing. And hence complaint was given and police have investigated the matter and filed the charge sheet, and recovery is also made at the instance of these petitioners. Since they sold the coffee bags to the CW 13. This court has to take note of the fact that when the recovery is made and relies upon the evidence of PW 15, and PW 15 is not subjected for cross-examination and also his evidence is incomplete and his evidence was discarded. The remaining witnesses are PW 1 to 3 and PW 1 is complainant, PW 2 is the manager and PW 3 is the accounts officer. The other witness is PW 13 is the IO who conducted the recovery. The main contention of the petitioner before this court is also that recovery under section 27 of Evidence Act, since the accused only disclosed the sale of coffee bags to the CW 13 and CW 13 evidence is not available before this court. The apex court also in the judgment referred supra in particularly paragraph number 32 extracted the paragraph number 82 wherein section 27 of the Evidence Act was extracted and paragraph number 83, 84 in detail discussed with regard to the procedure for recovery at the instance of accused for the purpose of section 27 of the Evidence Act. And in the case on hand, there are no independent witnesses. For recovery is concerned, the other witnesses have turned hostile except the interested witnesses of PW 1 to 3. And when such being the case, when there is no any recovery, and the same has not been proved by examining independent witnesses as well as the person from whom recovery is made, that is PW 15, and his evidence is also discarded. The trial court ought not to have convicted the petitioners for the offences alleged against them. The appellate court also, though considered the evidence and reassessed the same, fails to take note of the scope and ambit of section 27 of the Evidence Act. And when the disclosure statement was made by the accused in voluntary statement, and the same has to be recovered at the instance of independent witnesses, and they must be secured by the police to the station and have to draw the panchanama. And the accused himself has to lead the independent witnesses and recovery witnesses. And in order to prove the same, no material on record. When such being the case, in any of the principles laid down in the judgment of the apex court, in the case of Bobby versus State of Kerala, wherein also the judgment of Subramania versus State of Karnataka was considered and discussed in detail, particularly in paragraph number 32. That is paragraph number 84 of the judgment of Subramania versus State of Karnataka was extracted. The apex court also in paragraph number 33 comes to the conclusion that prosecution has failed to prove the circumstances that the dead body of the deceased was recovered at the instance of Bobby. And in the case on hand also, when the allegation is made that recovery is made at the instance of the accused persons, that is recovery of poppy seeds, and the same has not been proved as established under the procedure under section 27 of the Evidence Act, and hence there is a merit in the contention of petitioner counsel that both the courts failed to consider the aspect of proving of recovery at the instance of the petitioner and relied upon only the interested witnesses of evidence of PW 1 to 3 and evidence of PW 13 and the observation made by the trial court, particularly in paragraph number 24, and relying upon the evidence of PW 1 to 4 and PW 13 is erroneous. And even the trial court also comes to the conclusion that evidence of PW 15 is discarded in paragraph number 21 and committed an error in convicting the petitioners, and hence it requires interference of this court. And the order impugned and also the confirmation made by the appellate court suffers from its infirmity and no legal evidence against the petitioners and not proved the recovery at the instance of the petitioner, and hence it requires interference. In view of the discussions made up by the following order, revision petition is allowed and judgment of conviction and confirmations are set aside and petitioners are acquitted for the offences alleged against them. If any fine amount is deposited, it is ordered to be released in favor of the petitioners on proper identification. That's now. Because the registry is directed to pay the fee of rupees 5,000 to the amicus curiae. ಹೌದಾ? RBS ಆಫೀಸರ್ ಯಾರು ನೀವು ಇದ್ದೀರಾ ಮೇಡಮ್? RBS ಆಫೀಸಾ ಅಥವಾ ಇಲ್ವಾ? RBS ಆಫೀಸ್ ಇದ್ದಾನ? ಮೇಡಮ್ ಇದರಲ್ಲಿ ಹರ್ಡ್ ಅಂಡ್ ರಿಸರ್ವ್ಡ್ ಅಂತ ಮಾಡ್ಕೊಂಡು ಕ್ರಿಮಿನಲ್ RP ನಿಮ್ ಸೀನಿಯರ್ ಆಫೀಸರ್, ನೀವು ಅಲ್ಲೇ ಇದ್ದೀರಾ ನಂಗೆ ಗೊತ್ತಿಲ್ಲ.
ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ತೀನಿ ನಾನು.
ಬಟ್ ಅದ್ರಲ್ಲಿ ನೋಟಿಸೇ ಹೋಗಿಲ್ಲ R2ಗೆ. ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿಲ್ಲ ಮೇಡಮ್. ಅಡಿಷನಲ್ SPP to take notice. ಆಮೇಲೆ that discharge order has been challenged before this court and the same is legible and hence the office objection. Next time ಆಗ್ಲಿಲ್ಲ ಆಮೇಲೆ hard and reserved ಬೇಡ, ಅಲ್ಲಿ issue notice ಅಂತ ಮಾಡಿ. Issue notice against respond number 2 and the same has to be served through the additional SPP through IO. Through IO. Hard and reserved ಇತ್ತಲ್ಲ ಅದು. ನೋಟಿಸ್ ಕೊಡದೆಲ್ಲ ಮಾಡಂಗಿಲ್ಲ ಅದು. Next.
Passport matter. List 1, passport matter, serial number 5. And the Kishore.
Appealing for the appellants, my lords. My lords, in this matter, the appeal was valued at 60 lakhs and it has to be posted before the division bench, my lords. In para number 43 in page 63.
Complaints ಆಯ್ತಾ?
Complaints ಆಗಿದೆ.
ಯಾವಾಗ ಮಾಡಿದ್ರಿ?
Just before now.
Morning it was passed over with regard to
at lunch break of complaint.
ಎಲ್ಲಿ ಮಾಡಿದಾರ ಮೇಡಮ್?
Page number 63, para number 43, my lords.
ಈಗ ಬರ್ದಿದಾರ? ಕಂಪ್ಲೇಂಟ್ ಹೌದು ಅದನ್ನೇ ಹೇಳಿದೀಗ. ಆಯ್ತು ಸರಿ, ಕಂಪ್ಲೇಂಟ್ಸ್ ಆಯ್ತಾ? The counsel submits that he has complied with office objections with regard to the office objection regarding valuation. The matter also appears to be total value of the subject matter of the appeal comes to rupees 60,97,380. And hence, for the purpose of jurisdiction, as mentioned in paragraph number 43 of the appeal memo. And hence, the registry is directed to place the same before the appropriate court.
Serial number 6.
Raghuram Kadambi.
Yes, my lords, I have complied with the objections. Court fee was already paid, but it was not correctly apportioned.
ಇದೆಲ್ಲ ಆಯ್ತು, ಬೇರೆ ಇನ್ನೇನೋ ಇತ್ತು ನೋಡಿ.
That was the only objection, my lords. Valuation was not correctly indicated. That was only.
Counsel submits that he has paid the cost and also paid the court fee and also complied the office objections with regard to the valuation. Howda?
Deficient illa.
Valuation.
Valuation slip has been filed and corrected. DB, my lords, all.
And then and hence registry is directed to post the same before the appropriate court. Forum ಅಲ್ಲ, ಹಿಂದಿನ forum ಅನ್ನಲ್ಲ, appropriate court ಅಂತ ಮಾಡಿ. Same.
22. Sorry, bro.
22. RFA dismiss ಆಯ್ತಾ? RP ಅಲೋ ಆಯ್ತು, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೋದ್ರು, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ RP ಆರ್ಡರ್ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿದ್ರು, ಆಯ್ತು. ಈ ಕೋರ್ಟ್ ಮುಂದೆ ಯಾಕೆ ಹಾಕಿದ್ರು? Submitted second on record and in view of the order of the Honorable Apex Court mentioned above, the further orders of the Apex Court is further order of the Apex Court is awaited. Mostly stay ಆಗಿತ್ತೇನಾ entry ಮಾಡಿದ್ರು? ಇನ್ನೇನಿದೆ ಫಸ್ಟ್ ಮತ್ತೆ? The registries wrongly posted the matter along with the letter received from the Apex Court dated 25/7/24 24. And no need to consider the matter once again.
29. Adit Minden.
The respondent.
Defendant is before your lordship. The defendant is before your lordship. My lords, there are 3 orders, my lords, which were simultaneously passed. My lords, IA1 was by the plaintiff.
If present appeal is against one order or on the three, against all the 3 orders?
My lords, it assails 2 orders. The plaintiff.
Number 1 and 2.
Please. My lords, plaintiff files an application under Order 39 Rule 1 and 2, and so does the defendant. Plaintiff's application is allowed. Defendant's application is rejected. Against which this appeal was filed. Of course, so far as IA4 is concerned, that, my lords, was an application filed, my lords.
You already filed writ petition.
I have filed a writ petition. Now, my lords,
now before this court is only IA number 1 and 2.
Only IA number 1 and 2. My lords, of course, my learned senior counterpart on the last occasion, my lords, had raised a preliminary objection that a single appeal may not be maintainable against 2 orders. But on that count, my lords, my respectful submission is that this is a common order that has been passed on 2 applications. My lords, there are dictums of the honorable courts where, my lords, the honorable courts have held that in the situation where an appeal is filed under section 96 or 100, my lords, where there are multiple decrees, there, my lords, of course, preferably, my lords, 2 appeals have to be filed. But then, my lords, there is one recent dictum of the Honorable Kerala High Court, my lords, where the Honorable Kerala High Court says, notwithstanding the number of decrees, my lords, a common appeal can be maintained as long as the parties are similar, my lords, and the subject matter of contention.
Not the decree, here is only an order.
It's only an order. So I would respectfully submit, my lords, since this is an appeal under Order 43 Rule 1.
What is the relief sought in both the IAs?
My lords, both the applications.
Rule 1 and 2 only.
My lords,
In
of
the
course,
aspect of the very same property.
with respect to, my lords, different portions of the same survey number. My lords, may I just explain the
Different
facts?
portions.
Yes, different portions. My lords, I'll take my lords through the facts of this case, my lords. Then eventually, if my lords were to hold that I'll have to prefer a separate appeal, I'll confine this appeal, my lords, only insofar as rejection of my application is concerned. Because, my lord, there is a counterclaim by me as well. My lords, there is one fact which is admitted by both sides. That, my lords, my father was the predecessor in title of the plaintiff. My lords, the actual owner of this entire pocket of land, my lords, was one late Masti Gowda, who is the father of this defendant.
I think only you have to pay the additional court fee, that's all.
That I'll pay.
Madam Notary.
My lord, the
The separate
counterclaim
appeal.
only, they have sought for counterclaim for a different property, my lord.
Different property.
I'll make my submissions. Let
The
my learned
schedule is
friend-
different in the counterclaim. And
May-
they have then filed an order 39 Rule 1 and 2 in my suit
May I
for a
sub-
different suit scheduled property.
Let us say, my lords, I'll make my submissions.
First you show me the copy of the IA.
Yes.
Filed by you and also filed by them.
Lords, my lords would find my application. Of course, there are 2 separate lines, my lords, I would say. My lords, 273, page 273 is my application. And if my lords were to be
To
scheduled-
land in 70/3/B.
Yes.
Situated at Sri so-and-so.
Sriganada Kavalu village, Sunkadakatte, Yashwantpur, Hubli. And the extent is 1 acre, 5 guntas. My lords were to please mark that. Extent is quite different. Now, so far as the suit schedule is concerned, my lords would get that, my lord, at page 60.
Page?
60. The schedule. My lords have. My lords, the survey number is the same, but the extent is 35 guntas. And my lords, as a prelude to my submissions, my lords, I would submit that I am not questioning the plaintiff's title or possession over this extent of land.
Now, once you filed the suit for the relief of the permanent injunction to the extent of 35 guntas.
Yes.
How you can file in application for interim injunction to the extent of 1 acre 5 gunta.
That is the reason. That is what I'm explaining. That is what, because my lords, I have filed a counter claim also. My lords were to appreciate. There is a counter claim. So it is not merely an application, my lords. I have filed a counter claim also. For all purposes, my lords, which is a different suit in itself. My lords, I'll submit the facts. But then, my lords, I'll persuade
Where
my
is the application filed by them?
my lords that my lords, page 130.
113,
Please, 130.
130, 130.
Schedule 131 ನಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ. ಅದೇ 35 ಗುಂಟೆ ಅಂತ ಹೇಳ್ತಾರೆ. Rest of the same, rest of the description of the property is absolutely similar. Except for the extent. The survey number and the location, everything is the same.
Your property, you have not given the boundary.
But I have given my boundary. I have given my boundaries. If my lords were to see page 273 again.
In another page, bounded on.
House.
25 feet.
25 feet, private
Remaining
property.
portion East.
Yes.
West road and property bearing survey number 78.
Lords, I'll clarify. Lords, may I just request my lords to kindly peruse page 210 so far, so that there is clarity on facts.
But boundaries are different.
Absolutely.
Extent is different.
Precisely. Lords, may I, for a moment, may I request
20
my
bar
lords?
3B, 70 bar 3B.
ದಯವಿಟ್ಟು ತಾವು page 210 ತಾವು ಬನ್ನಿ. This is a sketch, my lords, which was produced by the defendant. And authenticity of which is admitted by the plaintiff also.
And trial court also ought not to have considered both the applications together when independent properties are
Circumstances.
claimed by them.
No, I'll explain the circumstances. My lords has page 210. Now, if my lords were to see, my lords, my father, my lords, late Masti Gowda, my lords, he sold a total extent of 2 acres 35 guntas in 3 separate tranches. My lords, that is visible from the sketch itself. My lords has,
They have to file separate appeal.
but but for the time being, may I persuade my lords?
If you are restricting only, then I will consider.
I am confining myself, my lord, only to the rejection of
Concern
my.
for the appellant restrict his prayer in this appeal. Only rejection of IA number
My lords, IA number 3.
3 na.
2, I'm sorry. I'm sorry.
IA number 2.
2.
IA number 2. Head.
My lords, my lords has this sketch, my lords, page 210. My lords, my father had sold 2 acres 35 guntas in favor of one gentleman named Chandrasekhar. That is not in dispute because Chandrasekhar is the vendor of the plaintiff.
Vendor of the plaintiff.
Yes. My lords, he had sold 1 acre, my lords, on 7th April 1990.
Your father sold 2 acres?
2 acres 35 guntas.
35 guntas.
Please, out of 4 acres. My lords,
Out of survey number?
the same survey number, my lords.
70 bar 3B.
Howdu. 70 bar 3B. Now, my lords, they were sold in terms of 3 separate deeds of conveyances, which are mentioned in the sketch itself, which I have taken my lords to. First sale deed, my lords, was on the 7th of April 1993, which is the lowest, the bottom portion, my lords. Then, my lords, 22nd July 1993. And eventually, my lords, the suit schedule property on the 2nd of September 1993, which is 35 guntas. My lords has it. Now, the authenticity of the sketch is not in dispute. Now, my lords, what was retained by my father
is 1 acre 5 guntas.
Absolutely, my lords, which lay on the western portion of what was sold to Chandrasekhar. Now, my lords, may I take my lords to the first sale deed?
Then you have to show the
Yes.
total extent of property 3 acres 35 guntas. Because you have sold 2 acres 35 guntas in favor of the vendor of the plaintiff.
Yes, my lords.
2 acres 35
lords,
guntas.
What
And according to you, you have retained 1 acre.
1 acre 5
Then there must be an existence of total extent is 3 acres 35 guntas.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಇದ್ದಿದ್ದೆ ನನ್ನ ಹತ್ರ 4 ಎಕರೆ. 4 ಎಕರೆಯಲ್ಲಿ 2 ಎಕರೆ 35 ಗುಂಟೆ ಮಾರಿದಿರಿ. ನನ್ನ ಹತ್ರ ಉಳಿದಿದ್ದು 1 ಎಕರೆ 5 ಗುಂಟೆ
ಗುಂಟೆ
ಅಷ್ಟೇ. ಈಗ my lords, so far as these conveyances are concerned, that is not in dispute. Nobody disputes that because, my lords, the buyer is the vendor of the plaintiff. My lords, may I trouble my lords with the first sale deed? The suit schedule property of 35 guntas was sold by my father to Chandrasekhar. The schedule, my lords, is at page 75.
2 acres to 35 guಂಟಾ.
ಈ 35 ಗುಂಟೆ ನೋಡ್ಸ್ ಆ 2 ಎಕರೆ ಏನಿದೆ ನೋಡ್ಸ್ ದಟ್ ಇಸ್ ಔಟ್ ಆಫ್
2
ಕಂಟೆನ್ಷನ್.
ಎಕರೆ 35 ಗುಂಟೆ ಸಪರೇಟ್ ಸೇಲ್ ಡೀಡ್.
ಅಲ್ಲ 2 ಎಕರೆ ಐ ವಿಲ್ ಟೇಕ್ ಮೈ ಲಾಟ್ಸ್ ಬ್ಯಾಕ್ ಟು ದ ಸ್ಕೆಚ್ ನೋಡ್ಸ್. ತಾವು ದಯವಿಟ್ಟು ಆ ಸ್ಕೆಚ್ ತಾವು ನೋಡಿ. 1 ಎಕರೆ 35 ಗುಂಟೆ
ಆಯ್ತ್ರಿ. ಒಟ್ಟಿ 3 ಸೇಲ್ ಡೀಡ್, 1 ಎಕರೆ 35 ಗುಂಟೆ.
ಆ 2 ಎಕರೆ ಇದರಲ್ಲಿ 2 ಎಕರೆ ಹ್ಯಾಸ್ ಬೀನ್ ರಿಟೈನ್ಡ್ ಬೈ ಚಂದ್ರಶೇಖರ್.
ಆಯ್ತು.
ವಾಟ್ ಹಿ ಸೋಲ್ಡ್ ಟು ದ ಪ್ಲೇಂಟಿಫ್
ಇಸ್ 35 ಗುಂಟೆ.
only 35 guntas. Now, my lords, the bone of contention is only the boundary between this 35 guntas and the land retained by my father. My lords, the first sale deed which my father executed in favor of Chandrasekhar, the schedule, my lords, is at page 75. May I trouble my lords with that schedule, my lords, for a moment? Because my specific contention, my lords, is that discrepancy commenced in the second sale deed. My lords has it, page 75. Now, ದಯವಿಟ್ಟು ಪಶ್ಚಿಮದ ಬೌಂಡ್ರಿ ತಾವು ಒಮ್ಮೆ ನೋಡಿ. ರಸ್ತೆ 25 ಅಡಿ ಅಂತಿದೆ. Now, my lords, may kindly turn, my lords, to the sale deed executed by Chandrasekhar in favor of the plaintiff. The schedule is at page 104. 104. My lords have it. ಅದರಲ್ಲಿ ವೆಸ್ಟರ್ನ್ ಬೌಂಡ್ರಿ ತಾವು ಒಮ್ಮೆ ನೋಡಿ.
Road and property bearing survey number 78 ಅಂತಿದೆ.
Absolutely. Now, who permitted him to change his boundary is something which is inexplicable. My lords, in fact, this change of boundary was a unilateral move by Chandrasekhar. And my lords, there is a reason behind it. Now, my lords, if my lords were to go back to the sketch at page 210, essentially what happens, my lords, is now what lies to the west side of my land is survey number 78. The reason why I am pointing out this discrepancy, my lords, is what lies to the west of the property retained by my father is survey number 78. ಹಾಗಾಗಿ ಈ ಬೌಂಡ್ರಿ ನಾವು ತಕೊಂಡ್ರೆ ಕೆಳಗಡೆ ಇದ್ದ 35 ಗುಂಟೆ ಮೇಲ್ ಬಂದು ಬಿಡ್ತದೆ ಸರ್. If my lords were to juxtapose this boundary to this sketch, the portion which is measuring 35 guntas is translocated, my lords, to the west. My lords, this was the very first discrepancy. Then, my lords, when the land was sold in 3 tranches, for some reason, my lords, beyond our knowledge, there was no subdivision which was made. No application was filed before the revenue authorities to subdivide these portions and to assign separate subdivision numbers. That was not done for reasons best known to the subsequent buyers. Without which, my lords, they secure an order of conversion. What Chandrasekhar does is, he secures an order of conversion. That also is part of the records, my lords, which also surprisingly was sanctioned without subdividing the properties into different subdivisions. My lords, if that were to have been done, my lords, no confusion would have prevailed. Now, my lords, coming back to this list, my lords, this was not the first suit. This was not the first suit, my lords. What preceded this was an incident where a person named Rajesh, he tries to transgress onto my property. Now, this Rajesh is none other than the nephew of this plaintiff. My lords, I had no option but to file a suit vide OS 761 of 2021, which was eventually decreed in my favor. My lord should find the judgment at page 147. The operative portion
against whom we have filed this suit?
Lords, this suit was filed against Rajesh, who was the transgressor at that point in time. At that point in time, lords, the plaintiff did not come to the fore. It was Rajesh, my lords, who committed the act of trespass. And my lords, he is the nephew of the plaintiff, my lords, which is a fact not denied by the plaintiff. My lords, this suit was decreed. And my lords, that decree was called in question before this honorable court. Wide RFA number 214 of 2024, my lords, which is currently pending with an order of status quo. So, my lords, essentially what has happened is that the extent of 1 acre 5 guntas is subject matter of first appeal, which is pending before the honorable court. And where, my lords, there is an order of status quo. My lords, it is precisely for this reason that since my possession was protected, I did not move an application, my lords, to vacate the ex parte interim order that was granted in favor of the plaintiff. What made me move an application, my lords, were incidents that happened after an ex parte was granted in favor of the plaintiff. My lords, sometime in March, they tried to transgress onto my property, my lords. I'll just juxtapose, my lords, 2 photographs. Luckily, my lords, we had photographs, my lords, which were produced in the first suit. My lords, this was my lords time. My lords, may I request my lords to kindly peruse page 211. The photos are stitched horizontally. My lords, if my lords were to see, there is a burnt portion, and my lords would see a compound on the other side. My lords, I am standing on the western portion of my land, and I'm looking at this compound, which is on the eastern side, beyond which is the plaintiff's land. Now, my lords, kindly compare this to the photographs, my lords, at page 245. My lords has it. Now, my lords would see that the compound is not there. Lords, this incident happened soon after, my lords, the ex parte order was passed. My lords, I file a police complaint. A first information report is also registered, which my lords would find at page 257. My lords, had the plaintiff not committed this act of transgression under the umbrella of the interim order, my lords, in his favor, I had no reason to question the interim order in his favor. Lordship may kindly appreciate. Even now I am making a statement that I have no claim over the 35 guntas that he retains. All that I am asking for, my lords, is to protect the land which was retained by my father. My lords, in the plaint, they don't narrate anything at all. Lords, as regards my land, there is no assertion as to the extent of land which I held. Only after file his application, my lords, they come out with a new ground stating that my land was acquired by the state government to establish a beggars colony. Now, that was a ground that was urged before the trial court. But so far as that ground is concerned, the honorable trial court, my lords, in the previous suit, which was instituted by me, my lords, has already observed after a lengthy trial at page 170. My lords would find the relevant observations, my lords. I'll not trouble my lords by reading through the judgment. But what the honorable court, my lords, had come to a categorical conclusion was that no portion of my land was acquired. My father was not even a benefactor, nor was he shown, my lords, as a land loser. So there is a categorical finding, my lords, that I have not lost any land. My lords, be that as it may, my lords. What I did, my lords, is during course of arguments, my lords, in fact, it was a suggestion which came from the bench where, my lords, the honorable court had opined that this is a dispute which cannot be resolved from documents. And that was a context, my lords, where I filed an application under Order 26 Rule 9, seeking appointment of a commissioner. My lords, though the matter is not subject matter of this present list, may I just trouble my lords with the application itself, which is at page 277. My lord, sir. 278 is the operative portion of my application. My lords, all that I requested was, my prayer was that let there be a comprehensive survey so that let the subdivisions also be, my lord, surveyed. And my lords, if at all the plaintiff's assertion of my land having been lost to the government is true, my lords, I'll rest my case. I'll have no case at all. What was surprising, my lords, that the plaintiff opposed this application. Eventually, my lords, resulting in the order passed on IA number 4, where my lords, my application has been rejected. My lords, now, my lords, if my lords were to come to the reasons assigned by the Honorable Trial Court, my lords, in rejecting my application, my lords would find the reasons, my lords, at page 37. Page 37, my lords, para 32. My lords, I'll trouble my lords by reading this paragraph.
Yes.
Further event, the contention of the defendant that the western side of the plaintiff's property, there shall be a road and land measuring 70/3B. My lords, I'll stop here for a moment. My lords, the road which I have shown was that 25 feet road, and which my specific contention was, my lords, was covered up while they broke the compound wall. It means to say, on the western side of the plaintiff's property, there is a road. Thereafter, the defendant alleged to have retained the land measuring 1 acre, 5 guntas of land. In fact, this court, by comparing the 3 sale deeds of his father, categorically comes to a conclusion that the defendant's father did not retain any portion of land on his western side of 4 acres of land. But I'll stop here for a moment and submit, my lord, that this reasoning is unfounded. The documents of the defendant would clearly suggest that he retained 1 acre, 5 guntas on his eastern side. However, this court insisted both the parties to produce the photographs taken through drone to know exactly where the properties of the plaintiff and defendants are situated. As the defendant is claiming that his property is situated on the western side of the plaintiff's property, to that effect, both of them have produced the photographs. If the said photographs are perused carefully, on the western side of the plaintiff's property, there is a road. Thereafter, except some small vacant sites, there is no such 1 acre, 5 guntas of vacant land. In fact, on the western side of the plaintiff's property, after the road, the lands are fully developed and huge buildings have come up. Thus, this court has no inch of doubt to hold that the defendant is trying to manipulate things. He is under state of confusion. He has no clarity as to where his property is situated, and his pleadings do not suggest exactly what is his case against the plaintiff herein. In fact, he has taken his most of the pleading to attack personally on the plaintiff, rather narrating what's his real case. Not, I'll stop here. Not, with greatest of respect, not the Honorable Court has come to this conclusion, not based on certain photographs. Not while negating my prayer to appoint a commissioner. Not, I have come clean, not while requesting for a commission to be appointed. Not, I asked myself, not as to what would be a reason why the plaintiff not is crying shy of a commission. But if a survey is conducted, everything will come to the fore. But if my land is indeed acquired, I don't stand a chance, I'll lose my case.
Any documents with regard to the acquisition of the property?
Nothing was placed on record, In fact, certain documents were placed on record in the earlier round of litigation by me, not the plaintiff in that case. And I have produced everything, from the preliminary notification till the final disbursement of award, based on which, the Honorable Court comes to a conclusion that no portion of my land was acquired. And my father was never arrayed as as a land loser, nor was he a benefactor of any compensation. Ultimately, if the land was acquired by the beggars colony, in fact, my lords would be aware that there is a beggars colony in existence. Sunkad katte daatad takshana edgade alle ide so beggars colony ide. By this time, this land would have been acquired and occupied by the government. That is not the case. Essentially, what has happened now, my lords, is that by virtue of this order, rejecting my application, there is an indirect negation of the order passed by this Honorable Court in the earlier suit, in the RFA. RFA, there is an order of status quo vis-a-vis with the very same property. So, my respectful submission, is that let there be an order of status quo. I would not question, in fact, I would not question the order passed in their favor. So far as their 35 guntas are concerned, I have no intention to question that order. All that I am seeking, and if my lords were to appreciate, the reason also, was thrust upon me. Had they not demolished my compound, of course, which they have denied in one lame sentence. They only say that we have not done it. But had they not done that act, I had no reason to come to this one. Not subject to what they have to say, What I would request my lords is, my lords, let the parties maintain status quo. And let there be a commission. My lords, the reason I had to file a writ petition, my lord, was to overcome, my lords, an objection raised by the registry. My lords, otherwise, my lords are well empowered to appoint a commission here as well. My lords, if a commission is appointed, my lords, and if the entire land is surveyed, my lords, the cat will be out of the bag. Subject to what my learned friend has to say, my lords, I'll rest my case.
Yes. Yes, madam.
My lord, in fact, before the trial court, if I may just put forth one point, my lord, and then if I may request for tomorrow for further arguments on our side. Just before that, my lord, it is not that the trial court has arrived at these findings based on the photographs. In fact, 2 acre 35 guntas was alienated by Masti Gowda, which is admitted by them. All the 3 sale deeds were placed before the honorable trial court, and the boundaries in the 3 sale deeds were examined, juxtaposed to the very sketch they themselves have produced. Thereafter, the trial court arrived at a finding that they are claiming that 1 acre 5 guntas is on the western side of the entire portion of 70/3B. However, if the 3 sale deeds and the schedules executed by Masti Gowda is seen, their portion should have been on the eastern side, which is at the bottom of that entire chunk of land, where land as on date stands acquired for Nirashritara Kendra. And the acquisition records were also placed before the trial court along with our written statement to their counterclaim, where we have also taken a contention that the counterclaim is not maintainable, my lord. Because the land is different. Now they are seeking for status quo on behalf of both parties, while they are not challenging the interim order which is granted in favor of the plaintiff, my lord. So they are only interested in seeking a status quo of both the parties, whereas they have failed to establish even the location of their land, 1 acre 5 guntas. And whilst we are claiming that 1 acre 3 guntas.
What is the area you have purchased?
35 guntas.
35 guntas.
Please, my lord. And as per their own sketch, my land is bounded on by the 25 feet road. They claim that I have covered up the road. If I may produce photographs. Please, my lord. The first photograph, the 25 feet road is visible.
That is in the middle of the photo.
Please, my lord, in the middle of the photo. And on the right hand side is the compounded area, which blue fence, my lord, which is the property, 35 guntas of the plaintiff. Now, my lord, they claim that beyond this road, on the left side is the 1 acre 5 guntas, where there are fully developed and constructed houses. Hence, the trial court, after examining the 3 sale deeds and these photographs, has arrived at a finding that there are fully constructed houses on the portion which is indicated as 1 acre 5 guntas in their own sketch. If my lord, they were already at an advantage with an interim order at the hands of this honorable court, as they claim, there was no necessity for them to file a counter claim yet again. 1 acre 5 guntas they have claimed. However, if the written statement auments are perused, their interest was not in the 1 acre 5 guntas, but however was in my 35 guntas. Your lordships may kindly peruse their written statement at page 138, my lord. Page 139, para 2, my lord. Defendant is the successor in interest of late Masti Gowda, who had purchased parcel of land measuring 4 acres, comprised in survey number 70/3B. Further, my lord, in para 3, they claim Masti Gowda during his lifetime sold an extent of 2 acres 35 guntas on 3 separate dates. The third date, 2/9/1993, is my sale deed, my lord, to one Shri Chandrasekhar, in effect leaving out an extent of 1 acre 5 guntas on the western edge. This is their claim, my lord. Further, in para 3A, They claim it is submitted that possession of the lands as detailed in the aforesaid sale deeds executed by late Masti Gowda was handed over to Shri Chandrasekhar during the lifetime of Masti Gowda. My flow, my lord, emanates from the sale deed dated 2/9/1993 at para 3. And they have admitted that pursuant to the sale deed, my vendor was put in possession of the 35 guntas. And prior to me purchasing the land, my lord, the land was converted by my vendor on 14/6/2017. And the sketch which is prepared at the time of conversion is in tandem with my sale deed, as well as what is claimed before this honorable court, before the honorable trial court, my lord. This sketch at page 88, my lord. Your lordships may kindly peruse the sketch at page 88. Please, my lord. On the left-hand side, the darkened portion is the 35 guntas. Alli raste anta baritare, my lord. This, my lord, now juxtaposed to the pictures which I have produced. Beyond the raste, my lord, is survey number 78. That is indicated in this sketch as well. Beyond the raste is survey number 78, my lord. And alli western side ge raste iradu is not disputed by them. In their own sketch, they say 35 guntas admel western side ge raste ide. Raste admele 1 acre 5 gunta is their case, my lord. Such being the case, the conversion sketch clearly indicates that there is a road. Beyond the road is survey number 78. Further, your lordship may kindly peruse the reasons assigned by the trial court. Para 18 at page 28, my lord. It is para 18, my lord, page 20, please. Now the moot point before the court is, out of 4 acres of land, on which side of 4 acres of land, landlord Masti Gowda sold 2 acre 35 guntas, and where does he retain remaining 1 acre 5 guntas? Does the property of plaintiff and defendant are one and the same? Or does they are adjacent to each other? And what is the case of the defendant on location of his 1 acre 5 guntas of land? In that background, let us answer to the first question. During the arguments, learned counsel for defendant himself contended that his father sold 1 acre of land in favor of Chandrasekhar under registered sale deed dated 7/4/1993, which is bounded as follows. In this, east by land retained by Masti Gowda, west by land retained by him. According to first sale deed done by Masti Gowda, he has retained land on both sides of property sold in favor of Chandrasekhar. Please, my lord. So on the top and bottom, land was retained. He sold 1 acre of land in survey number 70/3 under registered sale deed dated. Please.
He also sold 1 acre land in survey number 70/3 under registered sale deed dated 22/7/93 in favor of said Chandrasekhar, which is bounded on east, land sold in favor of Chandrasekhar; west, land retained by Masti Gowda; north, land of Boranna and Doddanna; south by land belonging to B. Ramakrishnaya. If the boundary of the above said sale deed is analyzed, he sold another 1 acre of land situated on the western side of the land sold under the first sale. And the said Masti Gowda sold another portion of 35 guntas of land in favor of Chandrasekhar under the sale deed dated 2/9/93, which is the last sale deed. Said 35 guntas is bounded by east, land belonging to Chandrasekhar; west by road; north by land of Boranna; south by land belonging to B. Ramakrishnaya. If the boundary of the above said sale deed is examined again, said Masti Gowda sold 35 guntas of land situated on the western of the 2 acres of land sold under 2 sale deeds. If it is also very clear that on the western side of 35 guntas of land, there is a road and no land has been retained by Masti Gowda. In fact, if the boundary of the first sale deed is perused, said Mastigowda retained his remaining portion on the eastern side boundary of his 4 acres of land and not on the western boundary. In the first sale deed, remaining land was on the eastern side. Now the plaintiff is claiming that he has purchased 35 guntas of land from Chandrasekhar. It means to say land of the plaintiff is situated on the western side of 4 acres of land of original landlord Mastigowda, and if at all Mastigowda retained any land, that shall be only on the eastern side of 4 acres of land. It means to say land of both the plaintiff and defendant, neither they are adjacent nor there are one and the same. At this stage, your lordship may also peruse sketches. Our ಕೊಟ್ಟಿರೋ sketch ತಾವು page 210 ನೋಡಿ. ಈಗ ಅದು ನಾರ್ತ್ ಸೌತ್ ಇದಿಲ್ಲ, ಈಸ್ಟ್ ವೆಸ್ಟ್ ಫೇಸಿಂಗ್ ಇದೆ, ಈಸ್ಟ್ ಕೆಳಗಡೆ ಇದೆ. A Karab 16 guntas in possession of Chikkanna Mastigowda and his successor plaintiff. Kindly see first 1 acre, second 1 acre, third 1 acre. ಇದು 35 guntas. ಈ 35 guntasಗೆ even according to them, western boundary is 25 feet road. ಈ 25 feet road, even according to all the photographs exhibited even by him, kindly see, ಅದ ಮೆಮೋ ಜೊತೆ ಕೊಟ್ಟಿದ್ದಿದೆ. ಈ ವೆಸ್ಟರ್ನ್ 25 feet ರೋಡ್ ಆದ್ಮೇಲೆ ಈ ಸರ್ವೆ ನಂಬರೇ ಇಲ್ಲ. 1 acre 5 ಗುಂಟಾದಂತ ವೇಕೆಂಟ್ ಲ್ಯಾಂಡ್ ಇಲ್ಲ. ಅಷ್ಟಲ್ಲದೆ ಕೈಂಡ್ಲಿ ಸಿ ದರ್ ಅಪ್ಲಿಕೇಶನ್. ಇದೆಯಲ್ಲ, kindly see page 306.
ಯಾವುದಿಲ್ಲ, 305 ಒಕ್ಕಲ್ಲ.
ಇಲ್ಲಿ ಒಂದು ಅಪ್ಲಿಕೇಶನ್,
there is an application notes under order 29 rule 1. 306 ಇಂದ ಶುರು ಆಗುತ್ತೆ.
306
ಅದು ಸಪರೇಟ್ಲಿ ಹೊಲ್ದಿರ್ಬೇಕು, ಹೆಚ್ಚಾಗಿ may not be part of
ಇಲ್ವಲ್ಲ, ಕೇವೇಟ್ ಇದೆ. ಆಮೇಲೆ ನಿಮ್ಮ
ಅವ್ರದ್ದು
ಲಾಸ್ಟ್ ಪೇಜ್
ಆರ್ಡರ್ 39 rule 1 and 2 ದ ಅಪ್ಲಿಕೇಶನ್. ಇಲ್ಲಿ ಹೈಕೋರ್ಟ್ ನಲ್ಲಿ ಮಾಡಿರೋ ಅಪ್ಲಿಕೇಶನ್ ಆರ್ಡರ್ 39 rule 1 and 2 IF for injunction.
ಸಪರೇಟ್ ಆಗಿ ಹಾಕಿದಾರ.
ಅದನ್ನ probably ಸಪರೇಟ್ ಅಂದ್ರೆ ಅದ್ರ ಜೊತೆಗೆ ಹೊಲಿಯೋದಕ್ಕೆ ಕೊಟ್ಟಿಲ್ಲ ಕಾಣಿಸ್ತತಿ.
ಇಲ್ಲಿ ಸಪರೇಟ್ 39 rule 1 and 2
ಅದರಲ್ಲಿ ಶೆಡ್ಯೂಲ್ ತಾವು ನೋಡ್ಬೇಕು. ಆಲ್ ದಟ್ ಪೀಸ್ ಅಂಡ್ ಪಾರ್ಸಲ್ ಆಫ್ ಲ್ಯಾಂಡ್ ಸರ್ವೆ ನಂಬರ್ 70/3B situated at so and so Yashwantpura, Bengaluru North, consisting of 1 acre 5 guntas with compound wall, gate, 3 sheds, 1 borewell, along with 16 guntas of A Karab and 4 guntas of B Karab land bounded by. ಈಗ ಸ್ಕೆಚ್ ತಾವು ನೋಡಿದ್ರೆ ಆ ಎ ಕರಾಬು ಬಿ ಕರಾಬು ಎಲ್ಲದು ಈಸ್ಟರ್ನ್ ಮೂಲೆಯಲ್ಲಿ ಬರ್ತತಿ ಅಂತಾರೆ. 210
ಇದೆ, ಕೆಳಗಡೆ ಇದೆ,
ಕೆಳಗಡೆ ಇದೆ, ಸಪರೇಟ್ ಇದೆ. 1 acre 5 ಗುಂಟಾಸು ಟೋಟಲ್ ಬೇರೆ ಇದೆ. ಈಗ ಅವ್ರು ಕ್ಲೇಮ್ ಮಾಡೋ ಪ್ರಕಾರ 25 feet ರೋಡ್ ಆದ ನಂತರ ಅವ್ರದ್ದು ಇದು ಬರುತ್ತೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಮತ್ತ ಆ 3 ಸೇಲ್ ಡೀಡಿನ ಬೌಂಡ್ರಿಯಲ್ಲಿ
that has been discussed by the trial court.
ಹೌದು,
extracting the boundaries meant.
ಹೌದು. At this stage, I would submit injunction, counter injunction in my suit by idruddu, adu counter bere piece adre whether that can be maintained, that's altogether separate aspect. But ನಮಗೆ ಇಂಜಂಕ್ಷನ್ ಕೊಟ್ಟಾದ ನಂತರ ಅದ್ರದ್ದು ವೆಕೇಟಿಂಗ್ ಇಲ್ದಂಗೆನೆ ಇನ್ನೊಂದು ಇಂಜಂಕ್ಷನ್ ಅನ್ನ ಕೇಳ್ತಾ ಇರೋದು. ಮೈ ರೆಸ್ಪೆಕ್ಟ್ಫುಲ್ ಸಬ್ಮಿಷನ್ ಇಸ್ ಇಫ್ ಇಟ್ ಈಸ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ದಿ ಸೇಮ್ ಪೋರ್ಷನ್ ಆಫ್ ದಿ ಲ್ಯಾಂಡ್, it would be like trial court itself being asked to go issue a counter injunction to its earlier injunction. ಅದನ್ನ ವೆಕೇಟಿಂಗ್ ಕೇಳಿದೆ. ಅದಕ್ಕೂ ಟ್ರಯಲ್ ಕೋರ್ಟ್ನವರು ಇಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಪಾಯಿಂಟೆಡ್ ಔಟ್, ಈ ಈಸ್ಟರ್ನ್ ಪೋರ್ಷನ್ನಿಗೆ ಸೇಲ್ ಡೀಡಿನ ಬೌಂಡ್ರಿಗಳ ಪ್ರಕಾರ ಪ್ರೈಮಾ ಫೇಶಿ ನೋಡಿದ್ರೆ ನಿಮ್ಮ ಲ್ಯಾಂಡು ಉಳಿದಿದ್ದು ಏನೇ ಇದ್ರು ಇಟ್ ಕ್ಯಾನ್ ಓನ್ಲಿ ಬಿ ಆನ್ ದಿ ಈಸ್ಟರ್ನ್ ಸೈಡ್. ಈವನ್ ಅವ್ರ ಸ್ಕೆಚ್ ನಲ್ಲೂ ಖರಾಬ್ ಲ್ಯಾಂಡ್ ಈಸ್ಟರ್ನ್ ಸೈಡ್ ನಲ್ಲಿ ಉಳಿದಿದೆ ಅಂತ, ಇಲ್ಲಿ ಮತ್ತೆ 1 acre 5 ಗುಂಟಾಸ್ ಸಪರೇಟ್ಲಿ ಇರುತ್ತೆ ಅಂತ ಹೇಳ. ಆ ಬೌಂಡ್ರಿ ಮೆನ್ಷನ್ ಮಾಡಿರೋದು ಆ ಸೇಲ್ ಡೀಡ್ಗಳನ್ನ ಯಾವನ್ನು ಕ್ವಶನ್ ಮಾಡಿ. ಕಮಿಷನರ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಇಂದ ಬೇರೆ ಏನೋ ಹೇಳಿದ್ರು, ಅದು ಬಂದ್ರೆ ಅದು ಬೇರೆ. ಕಮಿಷನರ್ ಅಪಾಯಿಂಟ್ಮೆಂಟು ಇಂಜಂಕ್ಷನ್ ಆರ್ಡರಿಗೆ ಇದನ್ನ ಮಟೀರಿಯಲ್ ಕಲೆಕ್ಟ್ ಮಾಡಿ ದ್ಯಾರ್ ಆಫ್ಟರ್ ಕನ್ಸಿಡರಿಂಗ್ ದಿ ಇಂಜಂಕ್ಷನ್ ಆರ್ಡರ್ ಎಟ್ಸೆಟ್ರಾ in the normal course is not maintainable, and that commissioner application is in respect of 14 acre 33 guntas. Of course, it might have been made with a good intention that both the sides would ultimately know where each other's land is situated. But that is something maybe appears to be totally outside the scope of this original suit in a scope. Therefore, I would say, with an order of injunction operating against him with a specific boundary, seeking a counter injunction saying that that portion is not the portion, actually it is my portion, and seeking an order of injunction would be like a count.
But now there are earlier 3 sale deeds executed by his father.
By his father.
One is 1 acre, another is 1 acre and 35.
35 guntas.
According to you, you have purchased the property from his purchaser.
How?
35 guntas, which is more fully shown in the sale deed of 2/9/1993.
How?
The very same boundary you have purchased the
Yes,
property.
yes.
That's all in
How?
the case.
How?
No
And
difference.
and those sale deeds are not questioned. ಅದರಲ್ಲಿ ವೆಸ್ಟರ್ನ್ ಪೋರ್ಷನ್ 25 feet ರೋಡ್. ಇದಕ್ಕೆ ಕೋರ್ಟ್ ನವರು just for the purpose of satisfying court's conscience wanted to see the photograph. 25 feet road ಆದ್ಮೇಲೆ ಏನಾದ್ರೂ ಪ್ರಾಪರ್ಟಿ ಕಾಣುತ್ತನು ವೇಕೆಂಟ್ ಪ್ರಾಪರ್ಟಿ ವೆಸ್ಟರ್ನ್ ಸೈಡ್. ವೆಸ್ಟರ್ನ್ ಸೈಡ್ಗೆ 25 feet ರೋಡ್ ಆದ್ಮೇಲೆ ಈಗಿರೋ ಬಿಲ್ಡಿಂಗ್ ಗಳನ್ನು ಬಿಟ್ರೆ ಬೇರೆ, ಅಂದ್ರೆ ಈಸ್ಟ್ ಕಡೆಗೆ ಬಿಲ್ಡಿಂಗ್ ಗಳನ್ನು ಇರೋದು ಬಿಟ್ರೆ ಬೇರೆ ಯಾವುದೂ ಇಲ್ಲ.
Any reply?
Lords, in the context of the photograph for a moment, this is the photographs, my lords, which caused all the confusion. My lords, the road what is being referred to lies to the western side of the land retained by me, which is what, my lords, was the bone of contention, and my lords, that is the reason why I sought for a survey. The road which they now show this, my lords, here in the photograph, that lies to the western side of my land as per the sketch. This and beyond this, my lords, the developed part, this, my lords, is survey number 78. My lords, that is the reason, my lords, why I requested, my lords.
You are also claiming the property what you have retained to the extent of 1 acre 5 gunta.
Please.
In the very same survey number.
In the very same survey. My lords, in fact, I would respectfully submit, my lords, that is the root cause of all the confusion. The fact that notwithstanding 3 alienations, no subdivisions having been made, and my lords, a deliberate insertion in the second sale deed, if my lords would recollect, the first sale deed which my father executed in favor of Chandrasekhar, western boundary was shown as Raste. Road antide. Tadanantara, Chandrasekhar, my lords, when he sold the property to the plaintiff.
Road and property.
Absolutely, my lords. That this, my lords, is in my respectful submission, my lords, was an unauthorized insertion. But ultimately, my lords, my interest is not to prolong this list. My lords, it is in nobody's interest, my lords, to prolong this matter. My lords, this honorable court has already held. My lords, of course, I'll share the ruling also. My lords, a coordinate bench of this honorable court has held that, my lords, there are certain issues, my lords, where the bone of contention cannot be deciphered from the documents. There, my lords, this honorable court holds that it is desired that a commission is appointed, and that it can be at any stage, my lords, of the suit. My lords, all that I'm requesting, my lords, is that if a commission report, my lords, through the government itself, through the authorized surveyor itself, my lords, if that can clarify the situation, my lords, it would stop, my lords, it would put an end to all possible future conflicts also. My lords, may I just pass on that ruling, my lords? Lords, para 11.
I've already read this.
Absolutely. My lords are aware. My lords, that is all that I'm requesting. My lords, at least they cannot find, my lords, any, my lords, other intentions behind me filing this application. My lords, so far as the description of boundary also, my lords, is concerned, the reason why the confusion arose was the olden day practice of displaying Kharab land as their own land. As per this sketch, which was prepared, my lords, at an undisputed point of time, and my lords, which they
Now,
could not
why
dispute.
you have included the same boundary?
That, my lords, that of
on
course
the
I can't.
eastern side.
Adu
And
madakagala.
also the western side.
That's a mistake.
In your IA.
Illa, that's a mistake. I can't insist on that. That's a mistake. I do concede. But the holding of Kharab on the eastern side is what is shown as a boundary on the eastern side in the other sale deeds. Of course, my lords, it would take some time for me to, my lords, juxtapose those boundaries to these to these boundaries. The boundary shown in the sale deed to the boundary shown in the sketch. But ultimately, my lords, the interest is to resolve an issue.
ಅದೇ boundary ಕೊಟ್ಟಿದ್ದಾರೆ. That is at page 273.
Allah, I have read out that boundary, my lords. That does not.
73. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಐಎದಲ್ಲೇನೋ ಅದೇ ಬೌಂಡ್ರಿ ಕೊಟ್ಟಿದ್ದಾರೆ, ಇನ್ಕ್ಲೂಡಿಂಗ್ ದಿ ಖರಾಬ್ ಅಂಡ್ ಆಲ್.
Including the Kharab.
ಹೌದು, 273.
But I would respectfully submit that that was a
Along with
typographical error.
16 guntas, 8
Yes.
Kharab and 4
Now
guntas.
that I would
Kharab.
respectfully.
ಅದೆಲ್ಲದೂ ಸೇರಿ ಈಸ್ಟ್ ಬೈ 25 feet ರೋಡ್. ಈಗ ಅವರ ಸ್ಕೆಚ್ ಅನ್ನು ತಗೊಂಡ್ರು ಸಹಿತ ಅವ್ರು ಕೊಡ್ತಿರೋ
There is no contiguity.
Not tallies with the prayer.
There is no contiguity. So I would not press on that, my lords. That's a mistake. There is no contiguity, my lords, between the Kharab land and the land which I currently hold. So that's a mistake, my lords. I cannot press on that. But all that I'm requesting, my lords, is to, my lords, show indulgence in this matter. My lords, and if a surveyor is appointed.
While selling the property in favor of Chandrasekhar in respect of 35 guntas is concerned.
Please.
On the west, what the property has shown?
My lords, 25 feet road ಅಂತ ಹೇಳಿದ್ದಾರೆ.
25 feet road.
May I draw my lord's attention? Chandrasekhar or ಹೆಸರಿಗೆ, my lords, page 75. My boundaries, of course, sale deed executed by the defendant's father. Page 75ರಲ್ಲಿ
ಪಶ್ಚಿಮಕ್ಕೆ
ರಸ್ತೆ 25 ಅಡಿ ಅಂತ ತೋರಿಸಿದೆ. ಈಗ ಅಲ್ಲಿ 2 ರಸ್ತೆ ಬರ್ತದೆ ಸ್ವಾಮಿ. There is one road, rather there was a road between my land and the plaintiff's land, which according to me, my lords, was closed off. In fact, that land.
No such road is in existence.
There is no such, but of course, my lords, if there
on the west.
Now it has been, no, west, my lords, there is one road which lies to the western side of my portion. My lords, I'll trouble my lords once again with the sketch at page 210. ತಾವು ದಯವಿಟ್ಟು ಒಮ್ಮೆ ತಾವು ನೋಡಿ ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ ನಾನು 25 ಅಡಿ ರಸ್ತೆ ತೋರಿಸಿರೋದು.
ಅಲ್ಲಿ ಪ್ರೈವೇಟ್ ಪ್ರಾಪರ್ಟಿ ಇದೆ.
ಆ 25 ಅಡಿ ಅದರ my lords, if my sketch was wrong.
25 feet road ಅಂತಿದೆ.
Yes, my lords, if my sketch was wrong, my lords, let us for a moment accept what the defendants are saying, plaintiffs are saying. My lords, if the sketch is wrong, then this portion should have been survey number 78. My lords, if they admit the authenticity of the sketch, my lords, they also admit the fact that there was a road here. They have admitted the authenticity of the sketch. May I just show their own averment? Page 296 ಅಲ್ಲಿ, page 296, my lords, their own pleadings, and they admit the veracity of the sketch. My lords, be that as it may, my lords, I cannot trouble my lords with all these facts. all that I'm requesting, my lords, if an appointment, my lords, a commissioner is appointed, my lords, that would put an end to this list. I find no reason why, my lords, the respondents can oppose it.
But now we have already filed the writ petition against the order of
My lords,
commissioner.
I would respectfully submit, my lord, that writ petition was filed. My lords, based on an observation, my lords, the office registry raised an objection, my lords, that an appeal is not maintainable against an order passed, my lords, under order 26 rule 9. That is the reason, my lords, technicality, my lords, I had to file a writ petition. That would be, my lords, withdrawn. My lords, if my lords were to show indulgence, my lords, I can withdraw the writ petition. ಅಗತ್ಯ ಇರ್ಲಿಲ್ಲ ಇದರಲ್ಲೇ. In fact, if my lords were to see ಇದರಲ್ಲೇ prayer ಇದೆ, I had to give up that prayer, my lords, in light of the objections. My lords, beyond this, my lords, I rest my case.
Or reserved.
So great.
Remaining ಎಲ್ಲ adjournments. 30? 32 ಒಂದ್ ಬೇರೆ ಪಾಸ್ ಅವರ್ ಆಗಿದೆಯಾ? ಹಾ, ಅವ್ರ ಹೆಸರು ಡಿಲೀಟ್ ಆಗ್ಬೇಕು ಅಂತ ಇತ್ತಲ್ಲ. ಹಾ ಹಾ ಆಯ್ತು. Registry is directed to delete the name of P.N. Harish for R4 and R9 in RFA number 2196 of 2012. And so also the name of K.G. Vasudeva Murthy for R5 to 8. And issue notice against R5 to 8 and also R4 and 9. Correct? ಇಬ್ರಿಗೂ ನೋಟಿಸ್ ಆಗ್ಬೇಕೀಗ. ಬೆಳಗ್ಗೆ ಕಂಟಿನ್ಯೂ ಮಾಡಿದೀವಿ, ಅರ್ಧ ಡಿಕ್ಟೇಟ್ ಮಾಡಿದ್ವಿ, ಅದು ಕಂಟಿನ್ಯೂ ಮಾಡ್ಕೊಳ್ಳಿ ಅಷ್ಟೇ. ನೆಕ್ಸ್ಟ್ 48.
Vinod Gowda.
Not application petition filed under section.
ಪಾಸ್ ಅವ್ರು ಯಾವಾಗ ಬೇಕು ಹೇಳಿ ಟೈಮ್.
Only thing is, my lord, petition has been dismissed on the ground of delay, though there was no objection. No opposition. If records are called for, my lord.
ರೆಸ್ಪಾಂಡೆಂಟ್ ನಿಲ್ಲಿದೆಯಲ್ಲ.
ಹೌದು. We have produced the records.
Call for records and list this matter on 12/11.
Citation ಮತ್ತೆ ತಗೊಳ್ಬೇಕಾ? We have taken.
First records ಬರ್ಲಿ ನೋಡೋಣ. See.
Date may kindly begin.
12/11. 50. ವೈಶಾಲಿ ಹೆಗಡೆ. ಏನಾಯ್ತು ಬೆಳಗ್ಗೆ ಆಧಾರ್ ಸೈಡ್ ಟೈಮ್ ಕೇಳಿದ್ರಲ್ಲ. ಯಾವಾಗ ಪಾಸ್ ಅವರೇನೆ? ಅದೇ ಟೈಮ್ ಅಂದ್ರೆ ಪಾಸ್ ಅವರು.
Sorry, my lord.
ಯಾವಾಗ ಹೇಳಿ?
My apologies. Any day, my lords. My apologies to my learned friend also.
ಯಾವಾಗ ಬೇಕು ಹೇಳಿ?
ನಮ್ಗೆ ಅರ್ಜೆನ್ಸಿ ಇತ್ತು ತಮ್ಗೆ.
We have both equal lots.
Tuesday.
Any day.
Tuesday.
I will be.
Tuesday ಆದ್ರೆ
29/10. For want of time, list this matter on 29/10.
53.
ನಿಂಗೆ ಯಾರೋ ಪಾಸ್ ಅವರ್ ಕೇಳಿದ್ರು, ಯಾವಾಗ? ಯಾವಾಗ?
Any day, my lords convenient.
ಈಗ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎಲ್ಲ ಫುಲ್ ಆಗಿದೆಯಾ?
30ಕ್ಕೆ ಮಾಡ್ತೀವಿ. 30th.
30 ಜಾಸ್ತಿ ಇದೆ ಅದಕ್ಕೆ.
Any day.
28, 29, 30 ಎಲ್ಲ ಜಾಸ್ತಿ ಇದೆ. 4/11.
Interim order has to be extended.
Want of time, list this matter on 4/11. Interim order granted in
2689 last.
26,891.
Yes.
891 of 23 is extended till next date of hearing.
Please.
59. H.N. Basavaraju.
Respondent. Kindly have it on 28th, my lord.
59. ಯಾವಾಗ?
28th.
28th.
Please.
ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಇದಾರಲ್ಲ, 28 ಜಾಸ್ತಿ ಇದೆ ಉಂಟು ಮೇಡಮ್. 2006 ಮಾಡ್ರಿ. ಯಾವಾಗ? ಆಯ್ತು 28/9 for 10/10 28/10 60.
ಇದರಲ್ಲಿ ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ by me to prepare and argue. Kindly give me a fresh clear date in the first week.
ಕ್ಲಿಯರ್ ಡೇಟೇ ಕೊಟ್ಟಿರೋದು ಈಗ. ಅದರ್ ಸೈಡ್ ಯಾರಿದಾರ? BP ಪುಟ್ಟ.
I represent
respondent. Want of time, list this matter on 4/11.
61.
Clear date. 61. Want of time, list this matter on 4/11. 63.
63. Abi Sadashivappa.
ಅದು ಅಷ್ಟೇ 6/11.
64.
64 also 6/11. 6/11.
First respondent, AG Shivana Association.
AG Shivana is no more. ಅವ್ರ ಮಗ ಅಪಿಯರ್ ಆಗ್ತಾರೆ.
ಯಾರು ನಿಮ್ದಲ್ಲ?
ಮಗ ಅಪಿಯರ್.
R1 and R2 ಎಲ್ಲ ರಾಮಚಂದ್ರ ಅಂತಿದೆಯಲ್ಲ. ರಾಮಚಂದ್ರ and H.M. ನಾರಾಯಣ ಅಂತ ಇದೆ.
Babu for R1 and 2.
ಹಾ.
Ramachandra for R3, 4 and 6 ಅಂತ ಇರೋದು.
ಹಾ ಇದಾರಲ್ಲ, ಬಾಬು ಅಂದ್ರೆ ಯಾರು?
For R1.
ಯಾರು ಇದಾರೆ ಬಾಬು?
2 ಅಂತ ಇರೋದು.
Next 65.
Respondent madam.
711.
Please madam.
66.
66.
minutes, any date, 1 minute, your lordship. ಅರ್ಧ ತಾಸು ಸಾಕು ನನಗೆ.
ಅರ್ಧ ತಾಸು ನಿಮಗೆ ಸಾಕು ಅವರಿಗೆ? 711.
ಆಯ್ತು.
711.
7.
For respondent in 67.
67. ಇದು 811. 811 ಅಷ್ಟೇ ಅಲ್ಲ?
ಒಂದು ಸಬ್ಮಿಷನ್ ಇಲ್ಲ. ಒಂದು 230 ಮ್ಯಾಟರ್ ಮೂವ್ ಮಾಡಿದ್ರು, ಹೊಸ ಮ್ಯಾಟರ್ ಮೂವ್ ಮಾಡಿದ್ರು ಅಂತ ಹೇಳಿದ್ರು.
230.
MFA 230 ಅಂತ ಮೆಮೊ ತಗೊಂಡಿದ್ರು.
230 ಯಾವ್ದು ಮೂವ್ ಮಾಡಿಲ್ಲ ಬೆಳಗ್ಗೆ.
ಮತ್ತೆ
230 ಅಂತ ಯಾವ್ದು ಮೂವ್ ಮಾಡಿಲ್ಲ. ನಾಳೆಗೆ 1-2 ಮೂವ್ ಮಾಡಿದಾರೆ, ಅದು ಕೊಟ್ಟಿದೀವಿ ನಾಳೆಗೆ ಹಾಕಿ ಅಂತ. ಅಲ್ವಾ ಮೇಡಮ್? ಬೆಳಗ್ಗೆ ಯಾವ್ದು 230 ಕೇಳಿಲ್ಲ. ನಾಳೆಗೆ ಅಂತ ಕೇಳಿದ್ರಲ್ಲ, ನಾಳೆಗೆ ಹಾಕಿದೀವಲ್ಲ.
Litigating.